And we are recording.
Great. Call this meeting to order. 4:02 p.m. Sunshine Ordinance Task Force. Please call roll.
Chair Wolf?
Here.
Chair Wolf present. Member Forsley? Member Forsley? Member Forsley not present. Member Neighbors?
Present.
Member Neighbors present. Member Highland not present. Member Yankee?
Present. Member Highland present.
Oh, you are here. Oh, okay.
Thank you.
I apologize. I didn't think you were here. Member Yankee's here. Member Stein?
Here.
Member Stein present. Member Wong? Member Wong?
Here.
Member Wong present. Member Padmanabhan?
Present.
Member Padmanabhan present. Member LaHood?
Present.
Member LaHood present. Member Schmidt?
Present.
Member Schmidt present. We have a quorum.
Okay, thank you.
Shall I read remote access into information?
Yes.
Remote access to information and participation. In accordance with Governor Newsom's Executive Order N3320, declaring a state of emergency regarding the COVID-19 outbreak, and Mayor London N. Breed's proclamation declaring a local emergency issued on February 25, 2020, including the guidance for gatherings issued by the San Francisco Department of Public Health officer, aggressive directives were issued to reduce the spread of COVID-19. On March 17, 2020, the Board of Supervisors authorized their board and committee meetings to convene remotely via Microsoft Teams and will allow remote public comment via teleconference. Members of the public may participate by phone or may submit their comments by email to cheryl.leger@sfgov.org. All comments received will be made a part of the official record. Sunshine Ordinance Task Force agendas and their associated documents are available at sfbos.org/sunshine. As the COVID-19 disease progresses, please visit the Sunshine Ordinance Task Force website regularly to be updated on the current situation as it affects the legislative process. Chair Wolf, did you want to read meeting decorum?
I will read it. Thank you. Also want to add, if you wish to make a statement during general public comment, please press *6 to unmute your telephone to speak. This is for any area regarding that we have public comment. And you can then also press *6 again to mute your telephone once you are done with your statement. We appreciate your self-facilitation on that. Meeting decorum. Any member of the Sunshine Ordinance Task Force may call for decorum due to disorderly conduct of meeting participants. Persons who engage in threatening and/or menacing behavior may be asked to leave. Okay, let's call first item.
Well, it's call to order, roll call, and agenda changes. I am not aware of any agenda changes. Is anybody else? I'm sorry, I didn't hear that.
Any changes or adjustments to the agenda? Okay, seeing none, let's call the next item.
Item number 2, approval of the minutes from the Sunshine Ordinance Task Force May 5, 2021 meeting. So these minutes were not approved in June because it was not the correct version of the minutes. However, the correct version is included in today's agenda.
Okay, folks, any changes or adjustments to these updated minutes?
Just a quick question, not on this, but I noticed that the agenda, this is Vice Chair Yankee, had shall the SOTF waive complaint procedures as part of item 1. Is that something we need to do? Or
No.
No, this agenda does not have more than 2 files for the same.
It was originally included because there were more files, but those got rescheduled.
Yeah, we're going to leave that on the agenda anyway, just in case it's there all to form anyway.
Got it. Okay.
All right. Continuing minutes. Any changes or adjustments to the minutes?
I have a copy of the minutes. If anybody wants to make comment, I can write it down.
Can I, or we're on to the June ones?
No, May.
May.
Sorry. I'll hold my comment.
Okay. All right, hearing none, let's open it for public comment.
Yes, please.
One moment.
Yes, please. Can you hear me?
Yes, just a moment, Mr. Warfield.
Thank you.
Okay, while Mr. Leger is getting ready, just want to announce that during all public comment, you will hear a chime at the 30-second mark when there's 30 seconds left of your testimony period. That way you won't be interrupted with another voice.
Are we ready? Mr. Warfield,
Yes.
you may begin.
You're going to tell me when to start?
Go ahead. I said you may begin.
I didn't understand. Thank you. This is Peter Warfield, Executive Director of Library Users Association. We can be reached at libraryusers2004@yahoo.com. Also at P.O. Box 170544, San Francisco, California 94117-0544. First of all, thank you to the chair for making that announcement about a chime. I'm not sure how it's going to end, but it would be great if there was, well, some other sound that's, as you say, not a human voice, which is kind of interrupting, and I think that's an improvement. I hope there is a concluding sound as well, rather than a voice. First of all, I would like to once again request that the correct and not the incorrect contact information be specifically noted as needing to be put into the minutes. I think I give it correctly when I speak it, and that is in the May minutes you have P.O. Box 1 space 70544. That should be together as one number. And then on the zip code you have left off the 4-digit extension. So it reads 94117 when it should read 94117-0544. I would appreciate if you would explicitly make those corrections and have those in the minutes where it can be clearly understood what the correction actually is. I'd also like, as I have repeatedly said, to have all of that information, as I stated, whenever I make public comment. There's a problem with remote meetings, which is quite a difference from in-person meetings, and that is nobody can approach anybody and say, we'd like to talk about this or that matter with you or an aspect of what you said. It goes both ways. I can't approach others. They can't approach us. I'd also like to have the Library Users Association, if not the contact information associated with my name, and in particular that will come up where the where our complaint was heard, where it says the petitioner was Peter Warfield. In fact, the petitioner was Library Users Association, and so the write-up should say that Peter Warfield, Executive Director of Library Users Association, said what your minutes say I said with regard to the case. Thanks very much.
Do we have other public comments?
Yes, please.
Are you ready, sir?
Yes, I am.
And
Thank you. This is anonymous. I just wanted to say something is wrong with the conference call line. It's very hard to hear Ms. Leger, and sometimes there's various echoes and things going on. That's all. Thank you.
All the phone callers, before we move on, all the phone callers, please mute your lines, or I will do it for you. Press *6.
Is there further public comment?
You may unmute yourself if you want to speak by pressing *6 again. Okay, last call for public comment on the minutes for
this
For May
file
5th.
1415. Maybe I'm out of order at this time. I don't
Yeah.
know for sure.
No, we're doing the minutes for May 5th right now.
Oh, I'm out of order. I'm sorry.
No problem. Okay, hearing no more public comment is closed. Is there any further discussion on the minutes? If not, is there a motion? Is there a motion to approve the minutes?
This is Member Wong. I'll move to approve the minutes from May 2021.
Okay, is there a second?
This is Member LaHood. I'll second.
Okay, moved by Member Wong, second by Member LaHood. For all the comments, please call roll.
Member Wong?
Aye.
Member Wong, aye. Member LaHood?
Aye.
Member LaHood, aye. Member Padmanabhan?
Aye.
Member Padmanabhan, aye. Member Neighbors?
Aye.
Member Neighbors, aye. Member Stein?
Aye.
Member Stein, aye. Member Forsley? Member Forsley?
Absent, move on.
Member Forsley absent. Member Schmidt?
Aye.
Member Schmidt, aye. Member Yankee?
Aye.
Member Yankee, aye. Member Highland? Member Highland?
Can't hear you. *6 to unmute if you're on the phone, Chris.
All right. Member Highland, aye. Chair Wolf?
Aye.
Chair Wolf, aye. The motion to approve the minutes from May 5th, 2021 has passed.
Okay, thank you.
You can add Member Highland as an aye. I managed to mute too late.
Yeah, we got it. Thank you.
All right. Thank you. Thanks.
Let's call the next item.
Item number 3, approval of the minutes from the Sunshine Ordinance Task Force, June 2nd, 2021 meeting.
Okay, any changes or adjustments to this?
I have one.
Member LaHood?
What is it?
Yes. I noticed in the June minutes that the library users 2004 email address should be at yahoo.com, not at gmail.com. I think this might have been copied from a previous incorrect version.
No, I got Mr. Warfield's email asking me to correct the May and June minutes, and I did that in the system.
They're different. One says Yahoo and one says Gmail.
Yeah, I know.
Okay.
So which is the correct one?
The one in the agenda in the packet is not correct. I heard from Mr. Warfield, I believe, this morning, and I made the change.
Okay. As long as you're aware of it. Thank you.
Yeah.
Okay. Any other changes or adjustments? Okay, let's move public comment. Public comment.
Yes, please. Can you hear me?
Yes, just a moment.
Thank you.
Are you ready, Mr. Warfield?
Yes.
Go ahead, sir.
This is Peter Warfield, Executive Director of Library Users Association. We can be reached at libraryusers2004@yahoo.com, as I have said many times before, and also at P.O. Box 170544, San Francisco, California 94117-0544. I appreciate Member LaHood's anticipating or noticing that there was a problem with the email address. I believe there was a problem with the May email address as well previously, but somewhere in its life as a draft document, it may have changed. And I'm a little uncomfortable with changes that are not acknowledged in the minutes. I think the appropriate thing to do, while I appreciate the administrator saying that she has changed this, I looked at these minutes earlier today, and they had the wrong email address. That means they had been published for more than a month with the wrong email address, which, as far as I'm concerned, is worse than no email address, because it means that somebody using it might try and reach us and fail and say, well, I guess whatever they might say and give up. If they didn't have anything, they might go and search for it somewhere. So I would appreciate, and I think it's important, that the correction be done as a correction to something that was published for over a month, and specify what the correction is. I would appreciate that very much. In addition, I would appreciate having the relationship with Library Users Association in every appearance of my name in public comments when I have given it, as well as the contact information, which apparently you don't seem to want to do. But I haven't heard any explanation for why at the full task force. It seems to be a policy or some kind of a thing that is unspoken and not answered when I have requested what's happening. In addition, I noticed that my apologies, it wasn't in May, it was in June that we presented our complaint number 20082, library users against the Library Commission. And so where the minutes on item 5 say Peter Warfield's petitioner, no, the petitioner was Library Users Association, of which I'm the executive director, and so it should say Peter Warfield, executive director of Library Users Association, provided a summary and so on and so forth. So other than that, that's all that I have time for, but I think that should do it and make the minutes accurate and documented and voted on. Thank you.
Do we have other public commenters?
Yes, anonymous, please.
You ready, sir?
I am.
Go ahead.
Thank you very much. This is anonymous. I think that you should not use anonymous number 2, and anonymous number 3, just like you shouldn't use male anonymous versus female anonymous. The trying to guess whose accent is who hasn't actually been accurate in the June minutes. So I think you should probably do what other commissions do, which is just say anonymous speaker said this, anonymous speaker said this, or make it accurate as to who is who in that minute. But I think that would be very hard, and it requires guessing whose accent is whose. So I think it should just say anonymous speaker said this and that, because there were at least 3 of us. And right now it's not correct or consistent. Thank you.
Please call for any other public commenters.
Hi, this is Mark Price-Wolf with the City Attorney's Office. I wasn't able to join the meeting via Teams. I don't know, I didn't get an invite. I just wanted to let you know that I'm on the call and be listening.
Okay, thank you.
Mm-hmm.
Okay, last call for public comment. Okay, hearing no public comment is closed. I just want to respond to the last speaker with regards to seeking to trying to identify who anonymous speakers are. What what any one or another commission does in their practice is no bearing on what we do here to assure compliance or reasonable process. There's no law or rule providing specifics on this aspect. Plus, the Sunshine Ordinance requires that there be, quote, each member of the public and, unquote, and, quote, each individual speaker, unquote, with regards to public testimony. The ordinance reads in section 6715 as follows in paragraph A, and I'm leaving out the part of the Board of Supervisors requirements. Every agenda for regular meetings shall provide an opportunity for members of the public to directly address a policy body of items of interest in to the public that are within the policy subject matter jurisdiction, provided that no action shall be taken on any item not appearing on the agenda unless the action is otherwise authorized by section 67.7E of this article. Paragraph B, every agenda for special meetings at which action is proposed to be taken on an item shall provide an opportunity for each member of the public to directly address the body concerning that item prior to action thereupon. C, a policy body may adopt reasonable regulations to ensure that the intent of subdivisions A and B are carried out, including but not limited to regulations limiting to total amount of time allocated for public testimony on particular issues and for each individual speaker. Each policy body shall adopt a rule providing that each person wishing to speak on an item before a body at regular or special meetings shall be permitted to be heard once for up to 3 minutes. Time limits shall be applied uniformly to members of the public wishing to testify. So I don't agree with the blanket labeling of just anonymous for all unnamed speakers without being able to distinguish between the multiple speakers, which we require for the minutes, and under public testimony rules of state and local laws here in the Sunshine Ordinance, part which I just read. One voice, one individual, one opportunity to speak on any single item at a time. In order to keep track, we need this distinction. So there has to be some delineation because many times one speaker does not want their person to be related or their statements to be related to somebody else's statement. Not all. So if you're naming everyone anonymous, then there's no distinction. And how are we to tell which anonymous is reacting to another anonymous's comments? Not all anonymous speakers speak for each other. We cannot discern by their name, or if we cannot discern by their name or some label, and as this particular anonymous stated as in the public comment, and in a email message to myself and to Vice Chair Yankee and to Administrator Leger, quote, should not distinguish by accent or voice, especially erroneously, unquote. Then by name, it must be. It's the only other way to distinguish between one speaker and another. So if we're going to keep claiming or notating that it's an anonymous speaker, there must be some way of distinguishing by some description, like a number or a letter. If a person doesn't want to be identified by their accent or voice, then they're free to enter their comments in writing. If there was no recording, then the accent and voice would truly be unidentifiable. But since these are recorded audio public meetings and we can hear voices, and as we all know, there's no guarantee of anonymity in public meetings or in public spaces, then one has to make a decision as to whether to reveal themselves in person by voice or visually. This can only go on so far within reason, and in order to be able to continue to run our meetings smoothly. So if the task force wants to overrule my position on this, then let's put it on the August agenda for discussion and possible action. Any other discussion on the matter? Okay, hearing none. Let's call roll.
We haven't got a motion.
Oh, we need a motion. Sorry. Is there a motion to approve the June minutes?
So moved by Member Highland.
Is there a second?
This is Member Wong. I'll second.
Moved by Member Highland, second by Member Wong. Any further commentary? Hearing none, please call roll.
Member Highland?
Aye.
Member Highland, aye. Member Wong?
Aye.
Member Wong, aye. Member Padmanabhan?
Aye.
Member Padmanabhan, aye. Member Neighbors?
Aye.
Member Neighbors, aye. Member Stein?
Did you say Member Stein?
Yes, I did.
Sorry, it cut out. Yeah, aye.
Aye, okay, great. Thank you. Member Forsley, is she present? Member Forsley absent. Member Schmidt?
Aye.
Member Schmidt, aye. Member Yankee?
Aye.
Member Yankee, aye. Member LaHood?
Aye.
Member LaHood, aye. Chair Wolf?
Aye.
Chair Wolf, aye. The motion to approve the June 2nd, 2021 task force minutes has passed.
Okay, thank you. Please call next item.
Item number 4, file number 19145, hearing regarding request for reconsideration, complaint filed by Chris Kors against the Police Commission to the task force found that the Police Commission did not violate Administrative Code sections 67.5 and 67.21 for failing to respond to a public records request in a timely and complete manner. Shall I read the preamble, sir?
Yes.
Okay. April 7, 2021, the task force found that the Police Commission did not violate Administrative Code sections 67.21 and 67.5. On April 29, 2021, the petitioner emailed a request for reconsideration within the 30-day requirement. On May 25, 21, Chair Wolf requested that the matter be reviewed by the Compliance and Amendments Committee before going to the task force for reconsideration. On May 25, 2021, the Compliance and Amendments Committee found that based on the lack of new information, the committee recommends that the task force deny Chris Kors' request for reconsideration.
Okay. CAC Chair LaHood, would you like to make a presentation on this?
Yes, I can give a brief overview because I know not everyone was around for all of the. We've had several hearings back and forth on this. So this complaint originally was heard by the complaint committee back in September 2020. This was about Mr. Kors. What had a complaint that he had gone before the police commission in a closed session regarding his termination from the police department. He wanted a copy of the recording and a transcript of the hearing, and there was a portion of the hearing which was in closed session. There was a lot of back and forth over several meetings about whether a full recording of the meeting, including the closed session, existed. It was eventually determined that it existed. He was provided ultimately with the recording. However, Mr. Kors believes that he was not provided with a complete recording. There's a disagreement about this. The police department says that they have provided a complete recording. Mr. Kors disputes this. Nevertheless, as Ms. Leger stated, the task force found no violation, but then this was brought before Compliance and Amendments for possible reconsideration. Mr. Kors asserted that we did not and should have considered SB 1421, which covers off-duty conduct, and and relates to this issue because he was off duty at the time of the incident, which precipitated his termination hearing. He was off duty and he was involved in a car accident. He also says he still disputes the police commission. He still believes that there is that he has not received a complete recording. The police department, Sergeant Youngblood said that they did supply a complete reporting, and he says SB 1421 applies to off-duty officers, but that use of force doesn't apply in this instance because it was a traffic accident. We voted on this. It was a split decision. The committee recommended denying the request for reconsideration because there was a lack of new information provided. However, I did not vote with my committee members, so I don't know if Member Neighbors or Member Wong would like to make any additional comment on that, but I think that gives an overview of this case.
Thank you. Other members of the committee, if you would like to add, please do now.
Sure, just briefly, this was my first time hearing reconsideration of the decision. My understanding was that this decision should be made on the introduction of new information. And in my thinking, the argument for SB 1421 as a use of force wasn't satisfactory for that condition. It didn't meet the terms of new information. And so that was kind of my rationale in that. And I don't know if Member Wong wants to add anything.
Not necessary, but if you want to.
Yeah, nothing from me.
Okay, great. So we'll now move forward with our hearing portion. This is a hearing to whether to grant reconsideration. And the recommendation from the Compliance and Amendments Committee is to deny that. So, why don't we hear from, is Mr. Kors here? You can unmute by pressing *6. Not hearing anything. Okay.
Hello?
Yes,
Hello?
Are you here?
Yep, I'm here.
Okay. I'll give you an opportunity to address the full task force. I had requested that it be heard by CAC first in case there was a lengthy and extensive amount of discussion to try and narrow down the issues. Considering that it wasn't a unanimous vote, but though it was a majority vote, I'll give you 3 minutes to explain what new evidence that you think might convince the task force to allow reconsideration.
Is there any possibility I can get 4?
Okay, I'll give you 4 minutes.
I appreciate that. Thanks.
Mr. Kors, are you ready?
Yeah, I'm ready.
And be sure to give them a 30-second chime. Thank you.
Shall I give him a chime when his time is up?
No, chime at 30 seconds and then a second chime when time is up.
Okay. You ready, sir?
Yeah, go ahead.
Go right ahead.
All right. The Police Commission's most recent resolution determining not to release the records regarding file 19145 claims that they have an attorney-client privilege and that they refuse to waive in closed session deliberations.
The Brown Act does not, in fact, permit closed sessions for the purpose of attorney-client communications on its own, except regarding litigation. See Roberts v. City of Palmdale, 1993, 5 Cal 4363. Also see Open and Public 4 by the League of California Cities, page 36. Additionally, the new evidence found in Government Code Section 54956.9 states, in relevant part, nothing in this chapter shall be construed to prevent a legislative body of a local agency based on advice of its legal counsel from holding a closed session to confer with or receive advice from its legal counsel regarding pending litigation when discussion in open session concerning those matters would prejudice the position of the local agency in the litigation. For purposes of this chapter, all expressions of the lawyer-client privilege other than those provided in this section are hereby abrogated. That's important. This section is the exclusive expression of the lawyer-client privilege for purposes of conducting closed session meetings pursuant to this chapter. Please see the new evidence on page 490. This new evidence further supports that the requested documents must be released, and note that the Police Commission has not cited any section of the Brown Act for a proposition to have attorney-client privilege closed sessions outside of litigation matters. Instead, closed sessions have to be held under a specific exemption open to session permitted by the Brown Act. More importantly, the Commission did not publicly state the basis for the closed session as a litigation matter. Therefore, the records requested are disclosable. See the new evidence, Open and Public 5, page 42, as documented on page 491 of the evidence packet. Before holding a closed session, the pending litigation exception, the legislative body must publicly state the basis of the closed session by identifying one of the following three types of matters: existing litigation, anticipated exposure to litigation, or anticipated initiation of litigation. In this case, it was a personnel closed session citation that was used, not the litigation closed session. And because it was a personnel matter, not a litigation matter, Penal Code 832.7b, SB 1421, explicitly makes this recording publicly disclosable. In fact, the Sunshine Ordinance demands certain boilerplate language to be used to justify each closed session. The SOTF should examine the new evidence contained in the original agenda on page 492 of the evidence packet to realize that this was not an attorney-client privilege litigation closed session, but instead a personal matter closed session. Personal matters are not closed to protect not attorney-client privilege, but with the privacy of the employee. And I waived my privacy rights. As this task force knows, there is no deliberative process privilege in San Francisco, Admin Code 67.24H. This new evidence is documented on page 493 of the evidence packet. Some of the text was cut out due to the formatting issue, so I'll read it word for word. Neither the city nor any office employee or agent thereof may assert an exemption for withholding for any document or information based on a deliberative process. Exemption either as provided by California Public Records Act 6255 or any other provisions of law that does not prohibit disclosure. Additionally, the following is taken from page 7 of Open and Public 5, a guide to Ralph M. Brown Act, which is documented on page 493 and page 465 of the evidence packet. Again, some of the print was cut off, so I'll read it word for word. Generally, public officials should think of themselves as living in glass houses, and that they may only draw the curtains when it is in the public interest to preserve confidentiality. Closed sessions may be held only as specifically authorized by the provisions of the Brown Act itself. On top of that, members must also bear in mind that the Sunshine Ordinance Task Force requires a higher level of transparency than the California Public Records Act and the Brown Act. More reasons why the requested transparency must be provided. A few members of the SOTF incorrectly concluded that SB 1421, which requires all records related to certain kinds of police conduct be released, did not apply to off-duty conduct. Since the Police Commission's own interpretation. Yes? Oh, shoot. Well, thank you for letting me talk for 4 minutes. That's it. I guess I'm done.
Okay. Ms. Leger, we did not hear the chime.
Really? Because I hit it.
Yeah, we didn't hear it. So I'm wondering if your mic, you were muted.
No, I'm not muted.
Okay. Can you just hit it so we can hear?
Did you hear it?
No.
Chair Wolf.
Yes.
Chair Wolf, it might be that the Microsoft Teams is interpreting that as background noise because it's not part of a flow of sound, and so I think it's canceling it out.
Okay. It may not be close enough to a microphone either.
Yes.
So That could be the same. Okay, well, then let's go back to a voice notice.
Hang on, I'm moving the chime closer to the, I want to see if this works because it's on my, excuse me, it's on my mouse pad.
Can't hear it.
Yeah.
Okay. All right, we'll have to figure out some other way to do it. I thought maybe it would work. Okay. All right. Members, discussion? Or a motion? Or questions for the petitioner for the reconsideration?
I would, Member Schmidt, I would say that if the law had changed in some way after the prior decision, if there's, say, a new statute, some kind of case law coming out of one of the courts, that would be a real good reason to maybe do a reconsideration. And it does sound like everything that I hear is that it's about what's in the law, and I'm not hearing that there's anything that changed in the law.
I have a question then. We usually don't apply changes in the law after after the date of the case the case has been filed as a complaint, because the law, unless it specifically states that it applies retroactively, all our cases are heard based upon the time that the incident happened. So unless there's some other reasoning to apply a change in law now that would not have applied then, I'd like to hear it. Member LaHood.
Yes, this, I feel like this comes up occasionally, or it has come up recently because we've had a couple of requests for reconsideration. It seems that when in doubt, we have deferred to members of the public in terms of, or not deferred to members of the public, but that we interpret things generally in favor of members of the public when there's a question. One thing that's come up is a lot of people who bring complaints to the Sunshine Ordinance Task Force, especially those who are coming before the task force for the first time, are figuring this out as they're doing it. And, we want people to come prepared, but, the ordinance is complex, and the way things weave together with the California Public Records Act and the Brown Act. And I think often people don't understand everything they could present in defense of their argument until after we've made a decision. I'd like to know actually what my fellow task force members think about the idea that, if somebody makes a case and we make a decision, but then they come back with new information because they've done additional research. If it is truly information that was not considered the first time around, should we give them the opportunity again, or is that do people need to come to us with a fully formed argument the first time around, and that because they become more familiar with the ordinance and how our process works, should we be giving them a second chance because they know more by the time they've gone through the process, or is it just, sorry, you have to figure it out the first time around?
Let's clarify what the reconsideration is about. reconsideration is about bringing any new information that might change the outcome from the original order of determination.
Right.
It could have been subsequent information that had been gotten, and we only give a short period of time for reconsideration. It's only 30 days. Or if there was, usually that is the case, is there's subsequent information that was not part of the original record. It didn't arrive in time or what have you, but the task force went ahead and made a decision one way or another. So, and this applies for both parties. Reconsideration applies for both. So it's not so much a matter of process or necessarily understanding. If a person maybe wasn't sure whether to include a document or a record or not, and then decided not to include it, but then found out at the end of their hearing that that document would have made a difference, that is a perfect reason to do reconsideration and introduce new information that we had not seen yet or not known about yet that could alter the original outcome. If a reconsideration is granted, then we start at the point just before a motion is made. So we're back at a point of debate in considering discovery and discussion before a motion is made. Okay, so I don't know if that helps clarify things based upon what you had presented, Member Lloyd, but that is just how the reconsiderations are supposed to work.
Yeah, I mean, actually that does. Based on what you're saying, if a petitioner doesn't include information as part of their argument because they didn't realize that it would support their case, and then we make a decision, but they come back to us later with this information that was not formally presented, that they did not formally present, then that perhaps is something, if we think that it would influence the case, that is an opportunity to reconsider.
Right, correct. Right, Member Schmidt and then Member Padmanabhan.
Yes, just the idea that, and I don't think this applies in this case because I don't see that I don't see this happening, but the idea that someone can say, well, actually I had some other documents, so I want to come in and try those out. I'm not sure if I could see, unless the rule's written very clearly that should merit reconsideration. I'm not sure if I would vote for reconsideration in that situation. But again, that's not what I'm seeing here.
Member Padmanabhan.
I'm inclined to I'm inclined to wonder about what Member LaHood has mentioned. And Chair Wolf, you mentioned an additional document, but additional research could actually form the basis of a document. So if the petitioner has done additional research to support his case that, and could change the way any individual task members could potentially vote, then I think we should look at it in greater detail.
Okay, thank you. So this is for either party. It's not just for the petitioner. It's for petitioner or the respondent. And I'll just, for everybody's edification, I'll just read from our complaint procedure for reconsideration. Within 30 days of a publication or issuance of order of determination, either the petitioner or the complainant or the respondent may petition the task force for reconsideration only if information exists that wasn't available at the time of the hearing. The petitioning party must present the new information and provide a written explanation of how the new information may change the task force's determination. The task force will accept no more than one request for reconsideration from each party for any specific complaint. That is the basis of the reconsideration. Everything in the rest of the procedure is just how it operates, when it's supposed to when the reconsideration is supposed to be heard, and so on and so forth. But the crux of how a reconsideration, in this case, if we were to analogize it with a court, this would be an appeal of a final original court decision. So, person has 30 days to file a reconsideration or quote unquote appeal of our order of determination, but they must bring new evidence that would change our minds from our original decision. And so that's the question before us today. Any other discussion? Is there a motion? Vice Chair Yankee.
Yeah, just briefly, I guess I'm kind of in a similar spot as Member Schmidt here. I just am not seeing and maybe someone else can point me to it, but I'm not seeing exactly what seems to be new here. I remember a lot of these types of discussions that we had the last time that we heard this case, and I'm not seeing some type of new document or overall new analysis that I don't think we considered last time when this vote was taken. So that's kind of, I guess, where I'm at on this one.
Thank you. Anybody else? Is there a motion? Motion would either.
May I ask Mr. Kors a question?
Sure.
Mr. Kors, can we hear you?
I don't know. Am I talking?
Yes, we can hear you. I have a question for you. So we received these information packets, and they're very lengthy, and it's trying to capture everything that you've presented to us. Can you we listened to everything that you read into the record in your initial 4-minute statement. Can you tell us succinctly, what are you presenting that is different that you did not present the first time around?
I'm presenting the evidence documented on page 499, where it specifically says off-duty conduct is part of, it should be included. This was a personnel closed session, not a litigation closed session. Therefore, it should be released. The commission initially violated the law by saying that the records did not exist, and unless the commission can cite a specific CPRA exemption for withholding the recording, and the records must be disclosed. Pages 511 and 512. These records are a subset of personnel records, and I have a recording of, if you want to hear the actual, statements by the respondent. These are personnel records, and they should be released. The evidence on 469, pages 514 and 515, email sent between Angela Wilhelm and Benjamin Houston, the human resources manager, basically supports this stance. To say that this was not a use of force. Well, I think, when an object crushes someone's skull, traumatic brain bleed, broken jaw, I think that's a use of force. I mean, great bodily injury was sustained by an object slamming into somebody. And I don't see any reason why intent has anything to do with that. A use of force is a use of force. Sure.
Just to be clear, you are presenting this as new information that you did not present in your original complaint. Is that correct?
Correct. All this is new. I mean, I didn't have time to. Yeah, this is all new.
Thank you.
It would have been helpful to have it would have been helpful to have a kind of a written narrative from you, Mr. Kors, explaining all this. I don't see it in the record.
Oh, asshole.
Excuse me?
I believe I did send it. I believe I did send it in the record. But I mean, hey, maybe I'll have to double check, but I feel fairly certain I sent you all this in the record.
Okay, thank you.
Yeah. So please double check. And I don't know who made that comment. That was not me, by the way. So
Okay.
Just want to let you know. Yeah.
Thank you. Could everybody on the phone please mute yourself? Won't tolerate any interruptions like that. All right. If you're not going to do it, then I'm going to mute you. Okay. We have members Neighbors and then member Schmidt.
Thank you. You know, I think that the request and the spirit behind Chris Kors wanting this information is very compelling, and yet if you're, the definition that you gave us seems to me to be very clear about information existing, and that's not even the same thing as analysis or research. It is evidence that exists, right? And this information existed. 1421 existed prior to this, and the other piece of it being that if it turns on the definition of use of force as including a traffic accident, I'm concerned about that interpretation also. But even downside, whether or not we say use of force, that force does include a traffic accident, to me, it still doesn't meet the minimum. We still were aware of this of SB 1421. We were still aware of those details about what the hearing entailed and what it didn't. And to me, it's not the same as bringing in a new piece of paper or missed something that wasn't in the first case. It was stuff that we already had access to.
Member Schmidt, I was going to say something, but Member Neighbors said it much more eloquently, and so I will just approve what she said. Thank you.
Bruce, I think you're muted.
Okay, so we're running close to about 30 minutes on this now. I want to try to see if we're coming close to a motion or if you need more information at this point.
This is Sergeant Yamba from the Police Commission. May I say one thing?
Yes, well, I'll allow it.
In regards to a use of force by an off-duty officer.
Yeah. Oh, hold on, Sergeant Yamba. We're not going to re-adjudicate the case. Okay. I'm not going to re-adjudicate it or allow it. What we're doing here is just determining whether there is enough evidence, new evidence that is being brought by the person asking for the reconsideration. If it's new or not, and new enough, whether it would change the outcome. That's all we're doing here today. If we grant the reconsideration, then we'll be scheduled for another full hearing, then we'll have an opportunity to break down all the merits. So, with that, if you have something to add, go ahead.
Then I guess I'm good.
Okay, thank you. Okay, members, is there a motion? Member Schmidt, go ahead.
Well, yeah, as to what I think Sergeant Youngblood wished to say, I think, there is one question, which is there something new here? And then number two is, if there is something new, does it matter? And so I think he would be saying that on that other question, whatever is submitted as new, is it material to changing the original decision? So I'm not sure if what he would tell us would be completely irrelevant to reconsideration.
I didn't stop him from not saying anything. I just wanted to let him know what our process is and what we're making a decision on today. Will we allow the reconsideration or not based upon the new information that was presented by the petitioner party as to whether we, the Sunshine Ordinance Task Force, agrees that this new information may change the outcome of our original decision? It has to be new information, not a rehashing of old information. I mean, it's a high bar, just like any, an appeal would be. So, I mean, it's a very, simple. It's almost, just simple black and white. Vice Chair Yankee.
I guess for the reasons that member neighbors so eloquently stated, I will move to not reconsider this case.
Okay, so is a motion to deny the reconsideration. Is there a second?
This is member neighbors. I'll second.
Okay, moved by Vice Chair Yankee, second by member neighbors. Is there any further debate on the motion to deny the reconsideration? Okay, let's open up public comment. In public comment, to be pertinent to whether there was new information or not on the old merits of the case. This is only for reconsideration on whether the new information presented. Okay.
Yes, could I speak, please?
Who's that?
Anonymous, could I speak, please?
Yeah.
Yeah, so I had a question about the new information. So it seems to be a conflict that the person, Chris Kors, was saying he did provide new information. And then the people representing this hearing, some of the people that I've heard from are saying that he hasn't provided new information. I just wanted to ask, has everyone on this hearing read through and through the information, all the information that he provided in this last instance? So basically what I'm saying is if all the information the new information that he says he has provided is actually new and it hasn't been 100% read through by everyone in this hearing, then how would you deny this man the right to say that there isn't new information? And so I just wanted to bring that up because I think there should be transparency. And in this case, it just seems like there's something's missing. And I think transparency is very important for the city of San Francisco. And this gentleman seems to really be compassionate about not being able to have that transparency. And it's obviously affecting his livelihood. There's other people on board that seem not to want to be fully transparent or to guard some type of information. And therefore, I just wanted to make sure that the information that was served by Chris in this last hearing was actually 100% read through, and that everyone knows there isn't any new information in this before they were to say there's no new information. Thank you very much.
Hello, can I?
Do we have a speaker to make public comment?
Sullivan?
Yes, please.
Mr. Sullivan, are you ready to speak?
Sure.
Go ahead, sir.
Okay, so the procedures also say if information exists that was not available at the time of the hearing. So and if the information exists, it doesn't exactly say when it has to exist. It was not available at the time of the hearing for people to consider, is what I would read that into. I also want to point out that the reconsideration procedures say information or new information, not new documents or records or new evidence. But it has to be, you know, the person has to explain why it may change the soft determination. But when you guys, I think you guys should stick with information or new information and not say new documents or records or new evidence. And that's the end of my comment. Thank you for your.
May I speak?
Just a moment.
Have you heard my request, or am I muted, or what?
You are after the person who just spoke. So we have a woman, another speaker.
May I begin?
Yes, you may. Are you also anonymous?
Sure.
Okay. Go ahead.
I am a 44-year resident of San Francisco, and one of the things I like and respect about our beautiful city is the efforts that are made via task forces like yourselves to be transparent in all levels of city government. And this gentleman, Mr. Coors, is obviously seeking redress about something that he feels strongly about enough to have done a lot of research on it. And I think, as one of the previous speakers said, hopefully every one of the task force members, every one of you folks, has thoroughly read his latest presentation. And then do you run something like this by a city attorney to make sure that everything is legally accurate? Because I think he deserves a second go-round at this. This is very important that a city agency is possibly not providing information that Mr. Coors is entitled to. And it's very distressing to hear that as I listen to this meeting. And I do hope you vote to reconsider his plea and go back and check all the documentation he has given you this time around, talk to the city attorney, and then you can render a full and fair decision. I thank you.
We have a speaker.
Is that me?
Mr. Warfield?
Yeah. Let me know when.
Go ahead, sir.
Thank you. Peter Warfield, Executive Director, Library Users Association, Library Users 2004 at yahoo.com, and P.O. Box 170544, San Francisco, California 94117-0544. We're not a party to this, and we're not familiar with this. And what I can say is that I appreciate the discussion. I appreciate the sentiments of the folks who brought up the issue of new awareness as well as new documents. So the first thing I would say is that you seem to routinely suspend rules that you have in various at various times when it's, for whatever reason, convenience, timeliness, and so on the top of your agenda for that matter. The second thing is that there is, and especially as some of the folks noted, for people who are not lawyers or extremely familiar with sunshine law and procedure and so on and so forth, courts were mentioned, and just as something to think about, courts will sometimes, as I understand it, take a statute of limitations and not apply it necessarily to the action that caused the harm, but rather to start the clock from the time that the harm was discovered. So if somebody is spraying near where I live and I don't notice anything until 10 years later when I'm getting cancer or my family is getting cancer, it's generally understood that there might not have been any way for somebody really to understand what the impact was of the offending actions, in this case of spraying nearby, until there was some other event that happened, which basically means an awareness happened. I do think that that does happen sometimes, and that is something that should be considered.
30 seconds.
In addition, I've often thought that there may be instances where the delay of an agency in providing information, somebody might want to make the 30 days and may think there is something additional that could be found, or even knows something. If the agency blocks or delays that provision of that information, that might also cause the new information to exceed the 30 days, and so on and so forth. In any case, I think there should be a generous consideration. Thank you.
May I speak?
Hi. Oh. I was wondering, can I speak?
Anonymous?
Hi,
Which
this is Karina. Oh, sorry. Go ahead.
No, go ahead. You're more than welcome to go ahead.
Oh, sorry. I'm Karina Wong. I just feel that these are public records, and by law, they should be disclosed. Thank you.
I didn't hear what you said, ma'am. What?
I said Karina Wong, and I feel that these are public records, and by law, they must be disclosed. Thank you.
May I speak?
Hang on. You ready, sir?
I am.
Go ahead.
Thank you. I'll call myself anonymous number 3 since there's 2 other anonymouses, and I'll try to use that consistently throughout. So it seems like a large part of the public correspondence, written public correspondence I said, has actually been cited by the petitioner in their opening statement, so I'm not going to repeat any of that. But I will say that your procedure says only if information exists that was not available at the time of the hearing. And so if any of you believe that maybe some of the information about their citations to being attorney-client privileged, even though I don't think it can be, or about how SB 1421 might not apply, if you don't think that was available to you, the task force, because I don't think it says available to whom. Is it available to the petitioner or available to each member of the task force? If any of you think that any of that information wasn't available to you, I would urge you to vote for a reconsideration. Thank you very much.
Any other public comment?
Yes, anonymous, sir. Can you hear me? Hello?
Yes, we can hear you, sir. You want to speak?
Yes, hello.
Anonymous speaker.
Yes, I'm an anonymous speaker.
All right, sir.
Yes, I fully concur with the lady that sometime before made some comments about Mr. Coors having major concerns. First of all, they get 3 or 4 minutes to explain their concerns. Isn't that much time, but I know you have busy agendas. But I read through that packet. To me, there was a whole lot of new concerns that really relating to the need for transparency. And in that light, I'd like to play a little clip that was provided relevant to transparency and what can happen without transparency. Just a moment.
The doctor stayed left with your client. Pardon me? The doctor was in what car? In the car with my client. He was a friend. The doctor and his brother were friends of his. They were in the party. And did the doctor get out and tend to overhead? The doctor, I think, yes. The answer is he was there and he went to the injured. That's what I know of the case. I also know 911 was called and the police came and paramedics came. Did the doctor leave with your client? He did not leave. He stayed there and was interviewed by the police department.
But the incident report says that all the occupants left the scene prior to the police officers arriving.
That's not accurate. That is not accurate. I don't know where you got accurate.
The incident report?
They're saying they didn't, these people were not there, the brother wasn't there, and the doctor, the passenger wasn't there. That's not accurate. When the police arrived, they both were interviewed. In fact, they talked to the brother, and they wanted to know where he was.
Well, that's one of the reasons why I think we really need all the transparency that we can get. Even right now, the police commission doesn't even want to release the tapes to the SOFT commission. I don't understand that. What are people trying to hide? And I read all of those things that were put into the meetings or the packets. To me, there's a lot of new information there, not only on the things that Mr. Coors got a chance to mention today, but also on going through, the Brown regulations. I don't know a layman, but anyway, we really need to get out of this, to get the transparency, and I fully support having a lawyer, someone read through what Mr. Coors had to say in that packet, review it, approve it, and let the people know. The other thing, everyone that's on SOTF should have read that. Listening to some of the people, I don't think that's happened. Anyway, just my comments. Thank you very much. Bye.
Okay.
Hello. Hello.
Hello, can we help you?
Yes, my name is Naveed Filsuf. After listening, I'm strongly in support of the new evidence provided by Mr. Coors to be reviewed before any new vote has been made. It looks like the new evidence is incredibly detailed. A lot of time was spent on it, and I think that at the very least, it should be reviewed so that it can have due process.
Excuse me, sir?
Can you hear me?
Yeah, I can hear you. You said your name and I didn't hear it.
So my name is Naveed Filsuf, and I think in light of how detailed Mr. Coors was, I think the evidence he provided on 6/27 should be reviewed before the vote before the next vote is taken. Given how much time he put into it, I think we owe it to him to give him full transparency on this. Is there anything else I can say? Did you hear that?
Yep, we heard it. Thank you, sir.
Thank you.
Any other public comment? Last call. Okay, public comment is closed. Okay, members, any last thoughts? Are we ready for a vote? Okay, please call roll.
Just a moment. Member Yankee?
Aye.
Member Yankee, aye. Member Neighbors?
Aye.
Member Neighbors, aye. Member Padmanabhan?
No.
Member Stein?
Nay.
Member Forsley? Absent. Member Schmidt?
Aye.
Member Schmidt, aye. Member Wong?
Aye.
Member Wong, aye. Member LaHood?
No.
Member LaHood, no. Member Highland?
Aye.
Member Highland, aye. Chair Wolf?
No.
Chair Wolf, no. The vote failed because we had we have 5 yes and 4 no.
Okay. Is there any other motions?
I'd like to make a motion to reconsider this case before the full task force.
Okay, moved by member LaHood to allow reconsideration. Is there a second?
I will second that.
Who's speaking?
Member Padmanabhan.
Okay. Moved by member LaHood, second by member Padmanabhan. Any discussion? Okay, let's open it for public comment.
Hang on a second, Bruce. You are opening this matter up, Lila, for reconsideration.
Yeah, it's just the
I made a new motion.
Yeah, it's the other way around. This is to allow reconsideration. Okay, ready for public comment, Ms. Leger?
Just a second. Okay, do we have a speaker?
Sure, this is anonymous number 3.
You ready, sir?
I am.
Go ahead.
Thank you very much. I strongly urge you to vote in favor of a reconsideration. I think that this case, whether it's intended to be or not, can have a precedent that would harm disclosure of police misconduct files. And if a police claims that they hit someone with a car and it was just an accident and is off duty, and that doesn't count as SB 1421, I think that's very dangerous. And I think that whether or not that's how you intend it to be. And so I think that I will, again, my public correspondence, it seems like, has been read almost word for word by the petitioner into the record, but at least the first half of it. So I would strongly urge you to vote in favor of a reconsideration and actually now consider then these provisions of the Brown Act, whether they properly cited it, whether they properly put the agenda, and now whether they can claim any kind of exemption on that basis. And maybe do additional, maybe consult your DCAs about what exactly is part of SB 1421 and not maybe based on some case law. Thank you very much.
Next speaker. Last call for public comment.
Hello, this is.
Yes, please.
Hello, this is Naveed Filsuf again.
Hello.
I just want to make it
Okay, hold
clear.
on, Mr. Naveed. You have to wait your turn, and the administrator, the clerk, will let you know when it's time for you to speak. Let's make sure, because we got a number of people that want to speak here. Let's keep them in order. Appreciate it. Thank you. Ms. Lachey?
I believe Mr. Warfield was the next commenter.
Yes, please.
Go ahead, sir.
This is Peter Warfield. Thank you for the motion, and we certainly are in favor. Basically, if in doubt, if there's any doubt in anybody's mind, I think there should be, as I said, a generous understanding and interpretation. I would certainly agree with what Anonymous has said. And again, a generous and an ample appreciation. I would certainly favor, if anybody is in doubt, having a reconsideration in the interests of fairness, of justice, rather than a closure and a non-consideration. So, supporting the motion. Thank you.
I'd like to speak.
Hold on. Yeah, we have Mr. Naveed first, and then you.
Thank you.
Hello, this is Naveed Filsu. Thank you, sir. In the interest of full disclosure, in the interest of fairness, I strongly urge you to support a reconsideration. There was new evidence provided on June 27th by Mr. Coors. I think we owe it to him, to our system, to give him his fair shot. And I would like for a reconsideration to happen so that he can have his due process. Thank you.
Anonymous here. Hello.
Ms. Leger?
I hear him.
Thank you.
There's a speaker before this last one that goes first.
I'd like to speak. I think that was me.
Correct. Wait for,
Sullivan's on too.
yes, wait for Mr. Leger to let you know when the clock has been reset. Thank you.
Thank you. Can I go?
Not yet.
Okay.
I'm waiting for the gentleman who is anonymous number 4.
No, Ms. Leger, it was the person who was just speaking now. That goes before that.
The woman?
Yes.
All right. How do you want to be identified, ma'am? As anonymous?
Sure. It seems like everybody's doing that. So, yeah.
Go ahead.
Okay, thank you. I'm just confused on what is happening here. I guess the argument is that if a person is in an accident, that's an intentional act, and that becomes a use of force by a police officer. But that seems kind of illogical to me in the sense that you're saying that every time a police person is in a car accident, that they have to report that out, and it's almost like they're intention. It seems to me that a use of force is something intentional, so that Mr. Coors was then intentionally running into that other person. That's pretty bad if he's saying he did that. So I guess you can reconsider, but it seems to me, I don't know why Mr. Coors would admit to intentionally hitting someone. Thank you.
Anonymous here.
Just a moment, sir.
Thank you.
Go ahead, sir.
Yes, in response to the last lady's comments, I don't think that's at all what Mr. Coors was saying, that he intentionally ran into anybody. He was talking about the interpretation of the law that the task force, or some members on the task force, had put in place. And he was discussing that. But other than that, I fully support that we reconsider. We absolutely need transparency. And I don't understand why the police commission or the respondent is so demanding and not releasing a lot of the information. I don't understand what they're trying to hide or cover. So I think we need to proceed with transparency, and everyone should absolutely read that memo that he sent on, I believe it was 6/27, as the last caller stated. That's my comment. Thank you very much.
Last call for public comment.
Sullivan. Can I speak? Sullivan.
Okay, wait for the clock to be reset.
You ready, sir?
Are you talking to me,
Yes.
Sullivan?
Yes.
Okay.
Go
So,
ahead.
all right, California Constitution, Article 1, Declaration of Rights, Section 3(2). A statute, court rule, or other authority, including those in effect on the effective date of this subdivision, shall be broadly construed if it furthers the people's rights of access, and narrowly construed if it limits the rights of access. Top of your complaint procedures. Consistent with the language and spirit of the Sunshine Ordinance, to provide the most open government possible. See City Administrative Code, Section 67.1. All inferences and evidence shall be viewed in the light most favorable to the petitioner. I strongly think that you should see all evidence in light most favorable to the petitioner. Thank you for your time.
Okay. I'm going to close public comment. We're running way
Can I
over.
speak? I've been waiting.
Haven't heard your name come up, sir. I'll allow this last one, and then I'm closing public comment.
I'll start when you're ready.
Go ahead, sir.
Thank you. First off, I just wanted to applaud those that had doubt and were up to reconsider. I believe that there's definitely doubt within the constituents on this board. And I think that being said, I also feel that there's room to go over more of the information. I don't believe whether it be a time constraint or not, or resources, everyone has had the time to thoroughly even understand whether there is new information within the thorough amount and detailed information that Christopher Kors has presented. Therefore, all these things being said, I think it would be to the benefit of the city of San Francisco that this was reconsidered, especially since the esteemed board members here, or this group of people here, that there is doubt within this group. Therefore, I know based on that there is room to look into this further, because I do respect the intelligence of the people within this committee. So that being said, I urge that you do reconsider. Thank you very much.
Okay, public comment is closed. Members, are any further debate or comment? Hearing none, are we ready for a vote?
Okay.
Please call the roll.
Just a second. Member LaHood.
Aye.
Member LaHood, aye. Member Padmanabhan.
Aye.
Member Padmanabhan, aye. Member Neighbors.
Aye.
Member Neighbors, aye. Member Stein.
Aye.
Member Stein, aye. Member Forsley, absent. Member Schmidt.
Nay.
Member Schmidt, no. Member Wong.
Nay.
Member Wong, no. Member Yankee.
No.
Member Yankee, no. Member Highland.
No.
Member Highland, no. Chair Wolf.
Aye.
Chair Wolf, aye. It's 5-4 in favor.
It fails.
Yep, fails.
Okay, so I'm sorry, Mr. Kors, we've gone round and round on this. I would suggest your next stop possibly would be a court. The task force, I believe, has done its due diligence to provide the kind of administrative process, local process, and that is what's required generally by court. And I don't know, there's not much else that we can do at this point. So I appreciate your time. I appreciate everybody else's time and your comments, but we must move on now with our meeting. We passed the 5 o'clock hour, and our next item is public comment.
Are we public comment?
Yes, yes.
Item number 5, public comment. Members of the public may address the Sunshine Ordinance Task Force on matters that are within the task force jurisdiction, but not on today's agenda.
Are you asking for public comment?
Yes, that was the item called. Our next item on the agenda.
Well, yes, please.
This is general public comment.
And if you could cue anonymous number 3 after Mr. Warfield, please.
Are you ready, Mr. Warfield?
Yes.
Go ahead.
Thank you. Peter Warfield here, Executive Director, Library Users Association. Library Users 2004 at yahoo.com and P.O. Box 170544, San Francisco, California 94117-0544. First of all, I wanted to say that we appreciate the win, if you like, at the June 2nd meeting concerning our complaint against the Library Commission for the way that it was running its meetings in such a way that it was preventing public comment. What I'd like to ask for, and I don't think I've ever asked for this before in all the years and all the complaints that we have brought, that it be referred and taken up by one of your committees. The likely candidates are one or both of the Compliance Committee and the Education Committee. And the reason is that there were quite a number of reasons that the Library Commission's actions with regard to running the meeting violated the law. You found at least 2, and but there were a number of quite a number that weren't specifically cited. So I think that there was a lack of real clarity as to what can be expected with respect to a properly running remote meeting. And I think that that's something that would be very worthwhile to get into and to really delineate clearly as to what's expected. I can tell you that subsequent to your meeting June 2nd and the library's attendance to defend the Library Commission, there was absolutely no change since the 2 changes that they made in March when there was a hearing imminent. They had the same incorrect and misleading instructions on the agenda, as an example. And in fact, that Thursday's meeting, there was somebody who kept swatting me down when I pressed star 3 to indicate I wanted to make public comment. So I think there's a whole question of how is it run, how is the instructions given, how is it implemented, and so on, that I think would be very worthwhile, not just for the Library Commission to ensure that they're following proper procedures, but also for everybody else and in the future. I'd also like to say I'm disappointed that Kevin Frazier's resignation is not mentioned anywhere on the agenda. And I think the chair did the right thing and notified supervisors about the resignation, but I think that that should be on the agenda at the end of the where the letter, where the commentary is taken up. Thank you.
Do we have another speaker?
Yes, this is anonymous number 3, please.
Go ahead.
Thank you very much. Good evening, Task Force. This is Anonymous. I don't tell you during hearings about what impact my records requests have because on principle, and according to the CPRA and courts which have considered the constitutional right to access public records, it doesn't matter. Every person for any or no reason has a right to public records. That's the law. That right is limited solely by statutory exemptions and sheer volume of records. It's not limited by subjective importance of those records and importance to whom. So I'll give you some examples from my cases. You ordered disclosed an email thread of an SFPD sergeant doing forensics on a journalist's computer in an FBI task force. What you may not know is that the other portion of that thread is cited by the Reporters Committee for Freedom of the Press in a suit against the DOJ. You found the police commission failed to properly redact and key its emails. What I did not tell you is that those emails contained the non-Brown Act meeting conversations with commissioners discussing how to politically protect the chief of police for that raid on a journalist. You ordered production of SFPD's command staff text messages with their sender and recipient metadata. What I didn't tell you is that my follow-up to that request is what proved that Mayor Breed personally directs Chief Scott to sweep homeless people when they are within her personal proximity. And I certainly could not know, after those texts went viral and were widely reported, a new anonymous requester who discovered those texts would go on to use those tactics to find as many abuses of homeless people in city emails as possible and publish them, including on Jeff Kaczynski, who has apparently recently resigned. You haven't yet heard my complaints about Harlan Kelly's texts or the Public Utilities Commission. The contents of those texts that I found last summer via request are cited in the federal charges against him, but I had them produced first, months before those charges. And I immediately appealed to you and to Herrera when I found out, via the native electronic files, that Kelly was hiding conversations with Walter Wong, a guilty pled city contractor. I was right in the end. Herrera and PUC were forced to disclose the remaining unlawfully withheld messages half a year after my appeal. Indeed, forcing the city to not print and scan is what allowed me to figure this out. That is the incredible power of random sampling records requests, exact electronic copies, metadata, and of appealing every single abuse of withholding, which I will continue to do. But I didn't know any of these effects would occur. They're second, third order effects, and neither did SOTF. Yet you straightforwardly enforced the letter of law in each case, which is your duty, not to judge or gatekeep the right of public access, and I hope you continue to do it. Thank you very much.
Hello.
Hello?
I would like to make public comment. Can you hear me?
Just a moment. Go ahead, sir.
Thank you very much. I have my own timer, so I don't need to be interrupted. My name is James Chafee. I made a complaint consisting of 5 letters and involving violation of 3 sections of the ordinance that are intended to guarantee that certain information is available on the internet. I sent my initial letter describing the violations on February 4th, 2020. On March 10, 2020, I sent a follow-up letter stating that I had received no acknowledgement of the receipt of my complaint and requesting such an acknowledgement. I received nothing. A year later, in February 2021, my complaint was assigned to a committee hearing, and the deadline to submit a reply or additional material was February 18, 2021. A notice informing me of that fact was sent by regular mail, postmarked February 19, the following day. I received that notice in due course on February 22nd. That same day, I sent an email response, which I didn't want to do, pointing out this gross negligence, which was a violation of due process and highly prejudicial to the complainant. The hearing before the Compliance and Amendments Committee was the following day, February 23rd. I sent another letter on March 10, 2021 to address the preposterous defenses offered by the respondent department. I received notice on May 17 that my attendance was required at a task force meeting on June 2nd. I sent another letter on May 27, 2021, stating that there was no authority for such a requirement and addressing additional issues with my complaint. I asked Mr. Warfield to convey to the task force that since I had received no reply to my May 27 letter, I assumed that a lack of response was an admission that there was no such requirement. At the suggestion of Mr. Warfield, I listened to the recording of the meeting and was shocked to hear Mr. Wolf state that I was challenging the task force, which he had invented out of whole cloth. On the agenda of the June 2nd meeting, I noticed that my complaint had been transformed into a records request complaint, presumably so that the respondent department could claim I had received my documents, even though no documents were at issue. This clearly constitutes a pattern and practice of defending sunshine violators against the complainants. You have to understand that these sunshine violators are involved in thousands of dollars in graft and millions of dollars in embezzlement, and concealment of those crimes is harmful to the public interest. Now, there are a lot of things you can do. I know what you're saying to yourselves. What can we do? We don't read the complaints. What can we do? Bruce Wolf is an idiot. Well, in fact, there's a lot of things you can do. You can be proactive in addressing problems of sunshine in this city.
Next speaker.
Sullivan.
Anonymous.
Mr. Sullivan, are you ready?
Yep.
Go ahead, sir.
First of all, I think the Compliance and Amendment Committee made a good motion to get input from the council on my reconsideration at the last hearing. Any entity or other body that is in question before the task force should be considered in relationship to the government, public officials, public money, and the entity's goal. Not doing so ignores the elephant. You should not silo the entity. Requiring a department to be named in the complaint misses the point of jurisdiction. Question of public access is not protecting one entity over another. It is about government activity through an entity for government purpose, regardless of whether they are shared with the entity. Government is to be open for all people. Changing subject. I want to point out to the task force that the mayor's proclamations and suspensions of various parts of the Sunshine Ordinance are still in effect to my knowledge. I noticed the task force is still considering findings on complaints on those suspended parts of the ordinance. In my opinion, they should be using the Brown Act or California Public Record Act, where the incidents of the complaints fall within the period of the suspension. Unless there is some memo or order I'm not aware of, there seems to be an inconsistency as to the task force implementation of public access laws that should be used and what city officials are using during this time of the declared emergency. I looked at some of the past agendas and there are complaints that would be affected. I'm certain this will affect more complaints consideration going forward. I could say more, but I'm just going to say thank you for your time.
Do we have another speaker?
Anonymous.
Okay. Go ahead.
I'm very concerned with some dangerous precedents that have been set by this unconventional way of conducting meetings. There are people I'm listening to on the phone that I do not understand, that I think I would understand if I was in the meeting, in the room, in City Hall, where I've attended many, many task force hearings over the years. There are people who are speaking that I think you have to be a clairvoyant to understand what they're saying over the telephone. It's a severe degradation of the functionality, if not legality, of these meetings. I do honor the people on the task force who are volunteering their precious time to these meetings. One of the most dangerous precedents that we're living with, that I'm very fearful will continue, is the cutting off of the telephone by the administrator, who prior to December and for at least two previous administrators, and probably even further, the administrator of the task force would answer the phone at her office phone. She stopped doing that in December,
and has severely inhibited, if not denied, public access to her communication with regard to the business of this task force. She has admitted in meetings of this group that she works 40 hours a week for the task force. Other records would reveal also that she gets paid $140,000 a year. I don't think we're getting our money's worth. She will not answer the telephone. She is denying the right we all have to anonymity by pretending that if you leave a message, she'll call you back. Well, that would deny my anonymity. The Sunshine Ordinance gives me the right to complain anonymously. The administrator is denying me that right. This is a violation of the Sunshine Ordinance, not to mention due process law in California and in this nation we live in. So I urge that the administrator, as I've done this in other public comments, to set aside at least 2 hours a week when she's publicly announcing that she's available to answer the telephone to communicate with complainants and the public. That has not worked since December, and I feel outraged that I'm being denied the ability to communicate with the task force in its very important business. There are other complaints I've aired with regard to the administrator, but I'm very, very concerned that when and if we ever get out of this COVID crisis, we are going to be assuming this is the new norm. It's a severe degradation, and I wish this to be stopped and reversed. Good luck. You do good work, very important work here, but a lot of it is being denied to the public because inefficiencies in the system. I thank you for your help.
Do we have further public comment?
Last call for public comment. Okay, hearing none, public comment is closed. Let's call the next item, please.
Item number 6, file number 19143, complaint filed by Anonymous against Sheriff Paul Miyamoto, James Wilson, and the Sheriff's Department for allegedly violating Administrative Code Section 6724, 25, and 27 by failing to respond to an immediate disclosure request in a timely and/or complete manner. I'll read the preamble. On January 28, 2021, the Compliance and Amendments Committee determined that the task force has jurisdiction. On April 20th, 2021, the Complaint Committee moved to find that the requested records are public and referred the matter to the task force with the recommendation to combine files 19143 and 20009.
Okay. All right, so this is a regular hearing. We are going to hear from both parties first, and we'll have a period of time for discovery and questions and answers. We'll hear some rebuttals, and we'll have some deliberation to develop a motion. And so we shall begin. Ms. Leger, are you ready?
Yes, I am.
Okay, great.
5 minutes.
Is the petitioner Anonymous here?
Yes. Am I here to discuss just this one or both combined?
Well, they are not combined as of the moment. So we're going to be hearing them independently. There doesn't look like. Oh, it does. Hold on. Let me just ask. Compliance and Amendments Chair, Member LaHood, is there anything you wanted to present here? And I know there is a recommendation to combine these files.
I'm sorry. We just found jurisdiction, but I think the Complaints Committee has more to say about these items.
It is Complaint Committee.
Yeah.
I'm sorry. Yes. Complaint Chair Schmidt.
Well, I think that we should certainly have them in the same consecutive because they involve the same parties. But I don't know if there's any real reason to combine them. They do involve somewhat different requests. The both of the cases, I think the main thing I would mention is that the sheriff's department seems to have been sort of slow on the uptake here, but they did acknowledge at our hearing that they're trying to sort of, I don't know if you'd say make amends, but they're trying to improve their process. And so I do think they concede that there were problems in their responses here.
Okay, so let me ask, it says here that there was a recommendation from the complaint committee as part of your motion to refer to the matter to the task force to combine these two items. Are you now saying you're saying now that that's not your recommendation?
I don't know if I recall specifically. Again, this is Member Schmidt, and I'm not sure if combine would mean that somehow they become the same case number. Though I should allow the other members of the committee to speak to these things also.
Okay. Anybody else from the committee have anything to present? Nope. No explanation on this? All right.
This is Member Wong. I'm not speaking specifically to what the complaint committee found, but I was a little bit confused because it says that we, on the Compliance and Amendments Committee, found that we had jurisdiction on January 28th, but it looks like we didn't have a meeting that day. I think we had a meeting on the 26th, and I don't actually see either of these files on that agenda. Can someone maybe double check that or double check me on that?
One moment.
That would seem to be more what one would expect here is
Complaints and amendments met on the 28th. On the 26th. January 26th.
May the petitioner provide some information here?
One moment. Just give me a moment for a second. Yes. Go ahead, petitioner anonymous.
I believe this is one of those 45-day issues. I believe this was determined for jurisdiction maybe January 28th, 2020, and not 2021. That might be the confusion, but I can't be certain.
Yes, I think that's what happened here, and that's why compliance and amendments is noted, but that in our notes for the cases,
Yeah. Okay,
so we didn't actually have a hearing on the substance of the cases.
This is Member Wong. Yeah, I'm seeing that now in the agenda for January 28th, 2020.
Right. Okay, I see that too. Okay. So, but the second one, 20009, was not heard at that meeting, I don't believe.
Again, if the petitioner may, I can read out your motions. I have them in front of me. So.
Yeah, one moment. It's fine. It's just a. Hold on. Is it just a motion for the for finding jurisdiction? Because I'm not understanding why it was heard for jurisdiction in one committee and then somehow it ended up in another committee. This was not made aware to me.
This was back in 2020. It looks like there's a typo on the agenda. It
Yeah,
says January 28th, 2021. It should be January 28th, 2020.
Yeah, but then it says on April 20th, 2021, the complaint committee moved to find the records that are public. So is that for the other one? 200?
No, we found jurisdiction for because of the 485-day rule.
You only found jurisdiction for the first one, not for the second one.
Sorry.
Member Schmidt, 20009, did that come before your committee?
Yeah, both of these did on the same day. And, again, it seems like they should be combined for hearing purposes. I'm fine if we wrap them together and we just hear it all at once, but I don't think that's what what we were thinking the word combined necessarily requires.
Okay, because we have a provision to allow combining of two cases if it involves the same petitioner with the same respondent in order to, if the merits are close enough together, so that we don't have to have a duplicative hearing one right after the other. So we combine them together, and we would, if there, and the respondent can claim that there's a difference between them if we choose during the discussion about combining. Okay, because the motion to combine is public comments open to everyone, including parties for that. So that's what this is. That's what we're trying to ascertain here.
Okay. So it sounds like you're saying that there'd have to be a motion to combine here. And, right. Okay. And that's not something I necessarily need to go into as a motion to combine. Let's just hear them one after the other.
Okay. So here's so we have an issue here. One, that item 19143 has been heard twice by committee for jurisdiction. Okay, that's the first thing I want to notate. Second thing is 20009 was heard once by the complaint committee on April 20th. Okay, and the motion on April 20th, you heard both these. You heard 19143 first. And then you heard 20009 second, and in the second one, the motion was moved by Member Stein, second by Member Forsley, to find that the task force's jurisdiction, find the requested records are public, and to refer the matter to the task force for hearing, with the recommendation to combine the files. Okay, so that's where we're at right now. Okay. So if you have any information, or any Member Stein has any information, because Member Forsley's not here, to help the rest of the task force out as to whether this should be combined or not, then let's deal with that first, so we can move this forward.
I don't think I have anything to add. This is Member Stein.
Okay. Okay, so, all right, so we have, so Then let's proceed with them to be independent. I'm not hearing any compelling information to combine them at this time. I've read through these. I would take them independently or combined, either way. If somebody wants to make a motion to combine them, happy to take it. Otherwise, let's proceed. Okay, let's proceed. Ms. Leger, you're ready with the clock.
Yes, I am.
Okay. Is there a representative from the Sheriff's Department or Sheriff Paul Miyamoto or Mr. Wilson, James Wilson?
This is Allison Lambert on behalf of the Sheriff's Department.
Okay, thank you very much. Okay, Petitioner Anonymous, you have 5 minutes.
Thank you very much.
This is for file number 19143.
Thank you. Ms. Leger, please let me know when I may begin.
Yeah, go ahead.
Thank you very much. So this is only the first complaint, and it is on page P714 or page 88 of item 6. Basically, I had done my standard 10 to 20 sent emails, 10 to 20 received emails, the department head, and a future and past 1 week of calendars of the sheriff. They responded, their IDR was untimely responded to. And the big thing here is that they basically, their response cites almost every CPRA exemption instead of reviewing the records and only citing the specific exemptions that apply. And when they cited all of those exemptions, they also cited a number of exemptions that are not allowed in San Francisco. And so I've listed them here. The CPRA requires you to, quote, provide a reason, for why records are disclosable. I don't think citing all possible exemptions is, in fact, a reason. It also doesn't constitute the written justification for withholding. They've already admitted that they untimely responded to the IDR. They've admitted the unlawful use of deliberative process privilege. They do not admit the unlawful citation to Government Code 6255, an impermissible balancing test, but it's literally right in there. They claim, as those other agencies have claimed in the past, that, well, balancing tests are sometimes allowed. Whether some other balancing test is allowed is not at issue here. They claim they were using the one under 6255, which is explicitly prohibited by the Sunshine Ordinance in 6724 G and I. And finally, they cite that all drafts are exempt. That's not true. In San Francisco, that all draft CPRA exemption is not valid, and only a very small subset of drafts can actually be exempted. And I guess in this complaint, that's all that matters. And no, I was asked this during the complaint committee. Metadata and other things aren't relevant here. We're just talking about this fact that they believe they could use all these different CPRA exemptions when they cannot. And they've admitted some of these violations and not admitted some of them in their response to you. Thank you very much.
Are there any persons or witnesses providing facts or evidence on behalf of the petitioner and complainant? Okay, hearing none. Sheriff's Department, Ms. Lambert.
Thank you, Chair and committee members. This is regarding complaint number 19143. The Sheriff's Office has taken remedial action on how all public records requests are handled. We've implemented new practices and procedures to improve our response times and responses to all public records requests. We have learned from our errors in responding to Anonymous's public records request. And since the records request at issue came up, all 3 staff members have attended public records courses offered through the California Peace Officers Association, 16-hour training class. And as of the middle of June 2021, the Sheriff's Office has implemented a new public records portal. It is public records management software to help us streamline and keep better track of our responses and requests. This type of error that occurred with the response to this public records request is not going to happen again. We are making every effort to be in compliance with the San Francisco Administrative Code and California Public Records Act. Thank you.
Thank you. Any persons or witnesses providing facts or evidence on behalf of the respondent? Okay, hearing none. Members, Questions and answers, clarifications? Vice Chair Yankee.
Thank you. First of all, I would like to say that I think this is the first time I've ever heard that a respondent has actually sent folks to additional training, and so I just wanted to recognize that. I think that's commendable, and I appreciate that. I guess just my simple question would be: are there any portions of the presentation made by Anonymous and the violations that he alleges that the Sheriff's Department does not feel are proper allegations?
I would like to respond that the letter that is sent out to acknowledge public records requests, the one that Anonymous has objections to and the allegations to, we have stopped using that letter in its entirety. Staff that is assigned to public records consults with our legal counsel before we ever cite any exemptions and looks at and reviews records before any type of denial letter is sent out. So the denial letter that was originally sent in response to this request it's no longer in use. Thank you.
So just to make sure I understand. So like I said before, I really appreciate the work that the Sheriff's Office has done here to make corrections. But at the time of this alleged violation, it sounds like you're pretty much admitting that the violations that Anonymous found at that time, you're acknowledging them?
Yes, this predates my coming to this position in the office. So okay. I can only say that it went out before I started.
Gotcha. Okay, thank you. That's all I had.
Member Stein.
Yeah, so I was actually going to ask Ms. Lambert if they still mentioned possible exemptions in their letter, but I think she spoke to that. So I guess I have a question for Anonymous, which is, have you seen a current copy of the letter, and would you concur that they're not sort of preemptively trying to mention all possible exemptions?
Thank you for that question. I would have to demonstrate what they did after they claimed a change in the next complaint, which is why I was asking them to be combined. But yeah.
Okay.
If you want me to go into that, I can.
Yeah, could you just answer that question?
So in the next complaint, you'll show that they didn't give any justifications. They would just give records, and there's no justification, there's no keys, no nothing. So.
No, not justifications, but I mean, have you seen their revised sort of form letter that they send to people that mentions possible exemptions that they might invoke in answering a request?
No, I haven't, because I think they've changed the procedure, as they told you, to committee twice, once after this complaint and once after the second complaint. So I haven't seen after that.
I'm just wondering, maybe for Ms. Lambert, if it's possible for us to get a copy of whatever generic letter they send now when they get a complaint.
Yes, it's public record, so I certainly would be happy to provide any number of our standard response letter to the committee.
Okay, thank you.
Member Schmidt.
Yeah, it's first, I want to ask a couple questions of Anonymous just to make sure that I'm clear on the scope of what's going on here. It sounds like only 6255, specifically the deliberative process privilege, that's the only balancing type of state law that you feel is implicated in this case. Is that correct?
No, it is. That is not correct.
Okay. Are they asserting other balancing tests that you contest with regards to the matters in this case?
Yes, they are. At least at the time when they responded to me, they were. So that's bullet number 3 and bullet number 4. So they said, we will not produce documents exempt from disclosure under the deliberative process privilege. That's one thing that's prohibited in San Francisco. And then they had a separate paragraph that says no documents will be produced where the public interest served by not disclosing the record clearly outweighs the public interest by the disclosure of the record under Government Code Section 6255. And those two are explicitly banned by G, H, and I. You're asking, I'm not in this thing, and nor were they raising about official information privilege and other types of possibly balancing tests.
Okay, so we're not in that here. I know we'll get to it at some point, but we're not in that here. I just want to make it clear because at some point I think there's going to be some law that's going to have to come out on some of these state balancing issues, and there may be disagreement, etc. The second thing of 2 for you is in the record, I noticed that at page 679, you took this to the supervisor of records, and they invoked the rule of reason. Am I correct on that?
They invoked the rule of reason? The supervisor of records did?
I believe that you got a letter, and I'm.
What page is that?
679 in this record.
Oh, yeah, I see what you're saying. So this is badly threaded. That is a response on their ability to respond to a petition, not about the records at issue in this request. It's about the city attorney's response to the petition.
Okay, so, but that in itself, do you feel that their invocation of the rule of reason was in compliance with Sunshine?
I don't think I can argue that in this complaint because the respondent isn't the city attorney's office.
Oh, I know you're not. I know you're not bringing that right now, but do you feel like there was a violation there by the supervisor of records in those circumstances by invoking the rule of reason?
How is that relevant to the sheriff?
I'm sorry, could I just get an answer from the witness, please?
I don't know. I have to decide whether I want to. I did not dispute it at the time, if that's what you're asking. I did
Okay.
not. That's in January 2020. But
yeah. If the chairman wants me to, I don't have any further questions.
If you can answer my question, how is that question regarding what the city attorney responded to relevant to the actions of the sheriff?
It's relevant because I want to know. Do I have to somehow demonstrate relevance for my questions?
Not necessarily, but unless it's way off topic.
Okay, so you're asking me, like, you're pre-clearing my questions?
I'm not pre-clearing your questions. I'm asking a question now of how is that relevant? Maybe it's of interest for the rest of the task force to know.
Because I want to know if this person considered and maybe made a complaint, because the rule of reason, I think, being invoked there is very questionable. And so I want to point that out. That's why I think it's relevant.
Okay.
Yeah. So that's I don't want to get deeply into that. I just wanted to ask that one question about it, Chair.
Okay. May I clarify my response?
Please do.
Go ahead.
I want to be clear. I did not concede that it doesn't violate the rule of reason. I said I did not file anything at the time, and I haven't considered it. So I want to be clear. I'm not conceding something in the future. Thank you.
Okay. Okay. Thank you. Thank you. No more questions for me.
Okay. So I'm going to ask you, Petitioner Anonymous, on page 678, that thread of what is that all about? Why is that in the record?
I mean, I don't know why things go into the record or not. This is, I need to read what this is. This is a email that's me responding to Cheryl Leger when she was sending me a response from the sheriff's department, and I just replied, and that's the remainder of the thread.
Okay, so that made that particular response is, I mean, it says here on January 4, on page 679, January 14, 2020. It's the subject line was complaint filed with the task force, file number 19143, which is this one. A response by San Francisco Sheriff's Department, Dear Anonymous, and then attached is the response from the Sheriff's Department to your complaint. Okay, so on January 13th, there's a response. There's a response from Bradley Rusi from the city attorney's office. Was that in particular directly particular to this case?
I don't know. I mean, I am guessing, but I don't know that he's responding to a petition about these same records that I sent to the supervisor of records. That's my assumption, but I can't be certain because it doesn't tell me who it was, when it was, like who it was sent to or anything.
Okay.
It just has a subject line.
All right, thank you. Ms. Lambert, I'm sorry, what is your rank again, please?
I'm a civilian employee. I'm a legal assistant.
Oh, okay, thank you. When you were mentioning about the additional training, has Sheriff's Department done a review of whether employees have also completed the Sunshine Ordinance training?
I do not know the answer to that.
Okay, thank you. Any other questions or clarifications? Okay, are we ready for rebuttals? Okay, let's go to rebuttals. Ms. Lambert, you're first. You have 3 minutes for rebuttal. Ms. Leger will tell you when to begin.
Thank you. The Sheriff's Office wants to reiterate that we've taken remedial action and are no longer claiming blanket exemptions to any and all public records requests. Thank you.
Thank you. Petitioner Anonymous, you have 3 minutes. Wait for Ms. Leger. Thank you.
Go ahead.
Thank you very much. They are correct that they claim that they are now no longer doing any of these things, even though I think in their original response, they were only willing to admit some of them. So it's great. That's good to hear. I don't know that myself personally. I think one of your members asked them to give you that letter. And that's great that if maybe, I assume that kind of thing review would happen at compliance if you agree with me that there was a violation here. I would simply ask that you find the violations on page P714, which is page 88 of the PDF. Citation to written justifications that do not apply to the responsive records, untimely immediate disclosure request response, unlawful use of deliberative process privilege, unlawful citation to Government Code 6255, an impermissible balancing test, and unlawful citation to CPRA draft exemption. If there's any confusion on that last one, they are able to cite the far narrower version of the Sunshine Ordinance's draft exemption, just not the fact that all the preliminary drafts and memoranda are exempt. And that is, and please do send it to compliance so you can review what they're doing now. Thank you very much. I'm done. I don't know if you guys can hear me, but thank you.
Okay, thank you. Okay, members. Any further discussion or motion? Member Stein.
Yeah, so, you know, my understanding is Anonymous is asking for a violation of 67.25, 67.27, and 67.24. I just want to say I'm more reluctant on this idea of a violation of 67.24, which talks about the kinds of public information that must be disclosed, because although I don't think the sheriff's office was correct about the exemptions they were saying might apply to a request, I think it is kind of, I mean, it's not great practice because it might turn off some petitioners, but I think what they were saying in that letter is that these are exemptions that might apply. They weren't citing them as exemptions that they were using or utilizing in any, you know, in this particular case or any particular case, right? So it wasn't that they withheld the information for these reasons. They just said these are reasons that might apply, and they were incorrect, but I'm not sure that that's a violation of 67.24 because they didn't actually use those exemptions. That's just all I want to say.
You're basically refuting that they admitted it by mistake?
I'm saying they wrote a form letter that said, oh, we've seen your request, and in replying, we might take this slew of exemptions into account. They were incorrect about what some of the exemptions were, but they didn't take them into account.
Yeah, but was that in response to the request? Or
my understanding is that I read the letter,
hold on.
is that they list out all these exemptions that they say in like one of the later paragraphs may apply. They don't say like these are exemptions we are applying. They can apply to this case.
My question is are you stating that that was what they said to the requester, or was that what they are telling the task force as their defense?
I'm just saying that I'm not seeing necessarily a violation of 67.24. They said this to all the requesters. They sent out a form letter. They said these exemptions might apply. These are potential exemptions, but they don't say that we are using these exemptions in any, in that requester's case or anybody else's case.
But my question is are they using that as a defense here before the task force? Are they saying to us they didn't provide, they weren't providing these records because of that?
I don't think they are.
Okay, because that's what what they tell the requester is one thing. What they tell the task force is their actual reason for not disclosing the records. Now, if they tell us that at the time before, as the agenda is being created and they're requested to provide their response, and it's in there, then we can determine whether that was correct or not. They could say whatever they want to the requester, and whether that's correct or not is part of the complaint. So I'm trying to discern.
I don't know how I can be more clear, but my understanding of this case is that Anonymous wants us to find a violation of 67.24, which talks about the different kinds of information that must be disclosed, because in that form letter, they suggest that they would hold those exemptions, or they would utilize those exemptions in some cases.
Okay. I guess what the big concern I have here that's missing from this hearing is that we're not hearing from the sheriff's representative what exactly their defense is. So if you look on page 773.
No, but to me that would be about not offering justifications for withholding. That's 67.27. Okay.
I'm going to make a tertiary comment here.
Okay, sorry.
The comment is if we did not hear from Ms. Lambert, the representative from the sheriff, what the response is from the sheriff's department. as far as what their defense is for either they are pleading no contest, or are they citing certain sections of the code in defense of not providing the information properly that the complaint is about, so on and so on. So what I'm saying is that if you go to page 773, that is their response to the task force. Essentially, should have been, well, actually, Ms. Lambert's signed it there. So this was her writing. So they're citing that the requester was provided all relevant response records according to their request just 2 days later. So they're saying that they did not violate 6725. I mean, I don't necessarily have to or want to make their case for them, okay? But it's all listed here. The question is whether you're refuting any of those citations, which it sounds like you are, for 6724. Was there a particular?
Sorry, I'm looking for page 773 because
It's printed on the PDF at 773 at the bottom. It's PDF page 147 out of 242.
Yeah, I'll have to look at that. You can go on. I just
okay
at that point.
Okay, so Member Schmidt, go ahead.
Yeah, I would say that we are looking at a 6255 citation and a deliberative process privilege citation, and there seem to be violations in citing those. I think if we make it clear that we're finding violations of those two, then that's maybe what would belong in a 67.24 violation, in maybe also adding in unlawful citation to the draft exemption. That I'm not sure if that belongs or not, but I don't know if we have to get into 1040 and all these other things that really are not part of this, as far as I can tell.
Would enjoy a motion. Go ahead, Member Schmidt. Raise your hand.
No,
okay.
Just load. Okay, I'll be happy to make a motion, which is pretty much down the line of what's requested, although I'm going to make some small edits. 6727 citation to I'll just say written justifications that do not apply. 6725 untimely IDR response, and then 67.24 violation involving the deliberative process privilege, citation to government code 6255, and to the draft exemption in the CPRA. So those are the violations that I see, and that's my motion.
Okay.
So can I just get some clarification on that? You are moving to find a violation of 6727 for written justifications that do not apply, 6725 for an untimely response, and 6724 for the deliberative process. Is that correct?
Yeah, deliberative process privilege citation. Citation to 6255 government code. and also citation to the CPRA draft exemption, improper citation.
Is there a second?
This is Member Neighbors. I'll second.
Moved by Member Schmidt, second by Member Neighbors. This is to find a violation of 6727, that written justification does not apply. 6724, deliberate process was incorrectly applied. That's the 6725 on timeliness. Okay. Any further debate or discussion on the motion to find violations of these three sections? Okay, let's go to public comment. Is there any public comment on the motion? Public comment on the motion. Okay, last call for public comment. Okay, public comment is closed. Any further comments, discussion, members? Are we ready for a vote? Okay, please call the roll.
Member Schmidt?
Aye.
Member Schmidt, aye. Member Neighbors?
Aye.
Member Neighbors, aye. Member Padmanabhan?
Aye.
Excuse me. Member Padmanabhan, aye. Member Stein?
Aye.
Member Forsley, absent. Member Wong?
Aye.
Member Wong, aye. Member Yankee?
Aye.
Member Yankee, aye. Member LaHood?
Aye.
Member LaHood, aye. Member Highland?
Aye.
Member Highland, aye. Chair Wolf?
Aye.
Chair Wolf, aye. The motion to find for 6727 of written justifications that do not apply, 6725 for an untimely response, 6724 for the deliberative process incorrectly applied, and Government Code 6255 improper draft of exemptions. Second by Member Neighbors.
Thank you. Please call next item.
Item number 7, file number 20009, complaint filed by Anonymous against Sheriff Paul Miyamoto, Lieutenant Quantico, and the Sheriff's Department for allegedly violating Administrative Code Section 6726 and 27 by failing to justify withholding and keeping withholding to a minimum. It is the same preamble as the previous case.
Okay. Let's hear from the, first of all, Member Schmidt, is there anything you want to present on behalf of the complaint committee?
Just quickly that I think this one is also, the sheriff has, Sheriff's Department has acknowledged that they're making changes, which I certainly commend. And so I think there's also going to be, you'll see that there's some acknowledgement that they didn't properly redact and then give citations for the redactions on a lot of these documents. I think that's pretty much it. Anything else? Member Stein, you're here. Anything else that you recall?
No, I don't have anything to add.
Okay, thank you. We'll hear from the parties next. I imagine both parties are still here. We'll start with Petitioner Anonymous. Mr. Leger, please wait for Mr. Leger and the clock.
Anonymous, you ready to speak?
You have 5 minutes.
Yes, I am.
Go ahead.
Thank you very much. If you still have the previous case open, I'm not sure why, but I put these in both files. It doesn't seem like the presentation for this one is showing up in item 7, but it is in item 6, page 89. Even if you can't see it, this is a very simple complaint. Once I realized what they were doing with these cover letters to me, I actually requested all of their records request responses to all other people for about 1 year back, and to see how extensive this was, who else was getting this. And I believe every single requester had been getting this for at least the past year. And when they gave me those records, which are the records about their responses to other people, they didn't key their redactions. They didn't justify at all why they were withholding information. And as I believe they also acknowledge, they had withheld the names of the records requesters, which is not exempt. I do have a supervisor of records response, and I don't know if it's actually in here, not against the sheriff, but against SFPD, where they say that records requesters' names are not private and should be disclosed. That was not a ruling against the sheriff. I'm just telling you because that's a ruling that the supervisor of records has made, and I think they accept it. So it's pretty simple. They had stopped by this time using those blanket exemption letters at this point, and but instead now the new problem was they weren't giving any justifications or any redaction keys, which is, I think they're going to tell you they revised their procedure again after this complaint. So the 3 violations I would ask you for are 6726 for failure to provide a key or other clear reference from redactions to justifications, 6727 for failure to provide written justification for withholding, and 6726 for non-minimal withholding for redacting the names of records requesters. I don't believe there's actually on this one anything in dispute, unless they're claiming still some of those names are exempt. And they made some sort of argument like that possibly at the committee, where if it's a prisoner, there's some extra exemption applies, but I'm sure they'll explain to you if they're still, I don't know if they're still arguing that exemption for prisoners who make records requests. Thank you. That's all. Thank you.
Okay, thank you. Are any persons or witnesses providing facts or evidence on behalf of the petitioner, complainant? Hearing none, I imagine the same representative, Ms. Lambert. You have 5 minutes.
Yes. Yes,
Please
thank
wait.
you.
Please wait for Ms. Leger.
Go ahead.
Thank you. This is Allison Lambert on behalf of the Sheriff's Office regarding complaint number 2009. We reiterate that the Sheriff's Office has taken remedial steps on how all public records requests are handled. The history behind this request is that it was received on a Saturday. Seeing that it was an immediate disclosure request, we went ahead and tried to respond as quickly as possible, and later offered to send justifications, keyed redactions to the requester. Having not heard from the requester, we went ahead and sent an updated production on February the 20th with all of the redactions justified and keyed for the reasons why. In terms of a prisoner making a public records request, we do not release any identifying information on a prisoner that is a criminal history that is exempt from disclosure. And as with the previous complaint, we want to reiterate that this came in while our unit was in the process of receiving training and how to handle these, all of our public records requests. And we're making every effort to comply with the Sunshine Ordinance and government codes. Thank you.
Okay, I'll assume that that's the end of her testimony. Are any persons or witnesses providing facts or evidence on behalf of the respondent? Okay, here, none. Members, the item is with you. Let's see. I have a question for the petitioner, Anonymous.
Yes.
With regards to the redactions, there were we just heard in testimony, from the respondent, they said that perhaps some of those redactions were in fact prisoners. Was there any information relating to that that you received from the respondent?
No, so they're not telling you the difference between their two responses. They responded to me, responded to my request, redacting all, without any justification, without any keys, all names of records requesters. Then I filed a complaint, and then they went back after that complaint and did this other process of only redacting prisoners' names. And it does sound like they are still holding those exempt under CLETS.
Okay, so I'm not sure what your complaint is focusing on. Is it focusing on what they provided you first and then corrected, or what they corrected later?
As always, my complaint is written as it was whatever I knew at the time, which was all the names were redacted at the time, which is why I asked for that in 26.
Yeah, but didn't they make the correction later by making the redactions?
Correct. They have now. They're now saying only prisoners are exempt, and that's their argument now. So they've gone back and taken away the redactions on every name that is not a prisoner. I believe their argument is. I don't think that the prisoner name is exempt under CLEPS. It's just someone happens to be a prisoner when you send a records request.
And when did you receive those corrections?
After I filed my complaint.
After you filed your complaint. Okay.
That's correct. Yeah.
Got it. Okay, that was what I was getting at here.
Yep.
Okay. All right. Are you talking about the responses from the Office of the Sheriff, starting on page? It looks like 33 out of 242.
Let me get to that page. Sorry, the PDF number is what?
The PDF printed on the page is 659. The page, the actual page is 33 out of 242.
Yes, that's correct. And yeah, that was their response to me before I filed the complaint. They just redacted all of the names everywhere with no justification or keys. Correct.
Got it. Okay. And Ms. Lambert, are you aware of the requirement?
Yes, we are aware of the requirement that the Sunshine Ordinance requires that there are justifications or footnotes for anything that is redacted.
Okay. Thank you. Member Schmidt, go ahead.
Yeah, just specifically on the CLETS issue. Question for Anonymous: do you want to assert here that there was a violation by withholding that information under the CLETS exemption or objection?
So again, I don't know what your rules require. I originally said it's just about all the names being redacted. That's all I knew at the time of my complaint. If you're asking me now that I know they only want to withhold the CLETS names, yes, I would still argue that I don't think that if I'm a prisoner and I send a letter to someone, my name, just the existence of me being a prisoner, is CLEPS information. I believe the CLEPS exemption specifically exempts information derived from a specific law enforcement database that is shared amongst various agencies. And I don't think just because someone's a prisoner, that means it was derived from that database. Thank you.
Okay. Yeah, I think that I'm with you on that argument. I wanted to figure out if that's what you wanted as part of our order. Ms. Lambert, would you have any substantive response on that legal issue as to why CLETS is a valid exemption basis in this case?
At the Sheriff's Office, we can only confirm if somebody an inmate's records if they are currently in our custody. So anytime that we release any kind of information about anybody who was formerly in our custody, we consider that criminal history information, and we are not able to release that. Once they leave the sheriff's custody, we cannot release any more information about their identities because it's criminal history.
Okay, and so you're saying that it applies to some of the deletions
there was actually just, I'm sorry to speak over you. There was actually just one PRA from an inmate. So we're talking about one record.
Okay, just one in the batch here. Okay, thank you.
Correct.
Thank you. I appreciate that.
Member Schmidt, can you or Petitioner Anonymous or Respondent Ms. Lambert explain what, and for our own edification, what the CLETS provision is?
Who would you like to answer that?
Well, whoever, if you're all talking about it. And for the edification and education of the rest of the task force and the public, I think it's worthwhile to mention, to describe what that is, because we have no reference of it.
I'm happy to if no one else wants to.
I would defer for now because it seems like, I guess it's an issue here. I was trying to figure out if it is an issue, and it sounds like it is. So let's allow the parties. Anonymous.
Okay, go ahead.
Sure. So CLETS, I apologize for speaking over you. CLETS stands for California Law Enforcement Telecommunication System. There's a special exemption, I believe it's in the penal code, that allows you to not provide any information from that database or derived from that database. And I don't see how that applies to the fact that a prisoner happened to make the request. The actual part of the response that may be that person's criminal history or law enforcement database derived information, I'm not contesting that. Just their name. You don't have to give me their prisoner number. You don't have to give me anything else, which prison they're in, just the name. That's all. Thank you.
And Ms. Lambert, can you expand on why you applied that and how it's applicable to this request?
Yes, our policy with the sheriff's office is we will not release any information on any individuals who are no longer in sheriff's custody. So we, once somebody leaves the sheriff's custody, we cannot identify if, they were ever in prison. It was considered criminal history, and that is why we will not release it.
So you're saying that if a prisoner were to make a PRA request while they're incarcerated, that is exempt. Their identity is exempt.
No, if they are still in sheriff's custody, then their identity would not be exempt. So it does change. So say the request came from a former prisoner, we would not release that former prisoner's identity because it is criminal history information.
Oh, I see. Okay. How would anyone know that they were a prisoner?
I'm sorry?
How would anyone know from the information on the PRA that they were a prisoner?
In this particular instance, there actually was an inmate number following the individual's request.
Okay, and so if you redacted that and not their name and put it and keyed the citation correctly, would that not be sufficient?
I don't believe so.
Okay, thank you. Okay, any other questions? Okay, should we move to rebuttals? Okay, let's move to rebuttals. Ms. Lambert, respondent, you are first, 3 minutes. Wait for Ms. Leger.
Are you ready, ma'am?
Yes, I am.
Go ahead.
Thank you, committee. The sheriff's office offered to provide updated redactions and justifications to the requester. And upon not hearing from the requester, we went ahead and did this anyway in conjunction with updating our procedures for handling public records requests. Thank you.
Assume you're finished with your testimony, petitioner. You have 3 minutes. Wait for Ms. Leger.
You ready, sir?
Yes, I am.
Go ahead.
Thank you very much. I want to clarify again, because I don't know why they're not making it clear to you. That was only after I filed a complaint that they offered to do this, and then they did it. The point, as I've made in now, I don't know how many complaints, and this task force has discussed, you have to follow the Sunshine Ordinance, not because some magic words are issued, not because Anonymous knows how to file complaints, but for everyone, for each request. And when you respond and you redact something, you have to key that redaction. I don't get special privileges because I know how to file Sunshine complaints. The point is everyone gets this for every request, every time, and not because it's optional. In fact, I even discussed at your education and training committee, there's even training from a city lawyer that says the rule automatically applies. There's no invocation of the Sunshine Ordinance. Anyway. So 6726 for not not keying the redaction, 6727 for just not providing any written justification at all, but 6726 for non-minimal withholding of the names, which they admit because they changed it. And then the only real question, I think, is I would say that what the chair and member Schmidt has said is correct. This information, you don't need to give me the criminal law enforcement information. You don't need to give me any history. But if I'm just a random person who used to be a prisoner in the jail, and now I make a records request, why my name would somehow be magically exempt doesn't make a lot of sense. I don't see how that has anything to do with criminal history. I'm not asking you to give me that person's criminal history. Just redact whatever you think is criminal history, prisoner numbers, whatever it is, and just give me the person's name. But even if you don't agree with me on the fact that that is not a valid quest exemption, you should agree with me that all the other names should have been provided initially as well, as it would appear that the supervisor of records agreed in the case with SFPD. Thank you very much.
Okay, so the item is now back with us for debate and a motion. Member Schmidt, you have your hand up.
Yeah, just that I think I would back up the anonymous side on that Kletz issue, and I think it may be a good idea that we note it in an order if we do have an order on this, because it just doesn't seem like these letters and the names on the letters would be covered by that exemption.
Okay, thank you. Anybody else? Is there a motion? Is there a motion? Member Stein. You're muted, Member Stein. Member Stein, you're muted.
Okay, how is it now?
Yes, we can hear you.
Okay, sorry. So I will make a motion to find a violation of 67.26 and 67.27 for failing to justify withholding and keeping withholding to a minimum.
This is Member Wong. I'll second that motion.
Okay, moved by Member Stein, second by Member Wong, to find violations 6726 and 6727. Can you give a little just narrative as to what actions you're finding the violations for each of these? We've been requested by many members of the public in the ODs that they're not descriptive enough.
The information was, I'm there, right? The information was redacted with no explanation, or improperly redacted with no redaction keys, that the names of requesters were withheld.
And for 6727, is the same thing, no justification for the withholding?
Yeah, I mean, no, that was to cover both of them.
Okay, got it. Okay. I would just ask, is there a timeliness issue here? So it seems on I think what I'm looking at here on, let's see.
It was filed on December 7th and it was received on December 18th, right? It was an IDR.
Right. I think that's the right one. Everything's better there. It's hard to separate which one's which from these. Let me just get clarification from the petitioner. Can you point us to the page for 20009, this case, this file number, with regards to the when you file the request and the chronology thereafter?
I can tell you there is no timeliness violation, and you can see it, and I haven't asked you for one. It's on P875. I made the request on January 11th. They responded January 14th, but there was a weekend in between, so there's no timeliness issue.
Okay, great, thank you. It's just because the other file is also all together with this, so it's hard to tell. Okay, very good. Okay, any last thoughts, members? Okay, let's open up for public comment. Ms. Leger, I hand it to you.
Just a second. Do we have any public commenters?
Yes, please.
Are you ready, Mr. Warfield?
Yes, let me know when to start.
Go ahead.
Thank you. Peter Warfield, Library Users Association, Library Users 2004 at yahoo.com, and P.O. Box 170544, San Francisco, California 94117-0544. We're not a party to this complaint, and we're not particularly familiar except for what we have heard. So first of all, I'd like to say that certainly there appears to be support in the facts, and so we support the motion. I wanted to say additionally that I wish it were pointed out explicitly, and I don't know if you think it has been sufficiently, but discussing changes to procedures, particularly procedures that haven't been questioned in any way, is not a defense for what happened. You know, if you get a speeding ticket, it doesn't suffice to say you should not have the requirement to pay because you're promising not to do it again. And I could be more dramatic, but I won't. I'll just leave it at that. It seems to me really a diversion and an evasion of accepting forthrightly the responsibility that what you did was not lawful, and that's the reason you're changing. We've already heard now 2 changes, and so there's a real question as to whether they are doing adequate changes. And that's why I would support what the petitioner has said, Anonymous has said, which is that it would appropriately be referred to a committee such as compliance and amendments to see whether there is a continuing violation or whether they have adequately dealt with the issues of illegality that you are raising. I don't understand why a prisoner is not a public record. It seems to me that arrest records are public. I don't understand at all where a prisoner, even if it was known that it was a prisoner, would be in any way protected under any particular law. I guess I haven't heard it stated.
30 seconds.
And I also thought, I was kind of alarmed when we heard that there was training being given by some police officers association at the state level. And I think Chair Wolf rightly questioned that, but I would be more particularly saying it clearly omits the key thing here, which is the Sunshine Ordinance, which has different and more stringent rules. That's what needs to be trained. Thank you.
Any other public comment?
Last call for public comment. Okay, hearing none, public comment is closed. Members, are we ready for a vote? Okay, please call the roll.
Member Stein?
Aye.
Aye. Member Wong?
Aye.
Member Wong, aye. Member Padmanabhan?
Aye.
Padmanabhan, aye. Member Neighbors?
Aye.
Member Neighbors, aye. Member Forsley? Forsley absent. Member Schmidt?
Aye.
Member Schmidt, aye. Member Yankee?
Aye.
Member Yankee, aye. Member LaHood?
Aye.
Member LaHood, aye. Member Highland?
Aye.
Member Highland, aye. Chair Wolf?
Aye.
Chair Wolf, aye. Moved by Member Stein, second by Member Wong to find a violation of 6726 for failing to justify withholding and 6727 for failing to provide proper redactions.
Okay, thank you. The order of termination is approved. I would request that we take a 10-minute recess, and we will return. It's 7:09, so let's see. So 7:29. Let's make it 7:30. Okay?
Yeah, okay.
Okay.
2 minutes.
You realize that's 20 minutes.
I'm sorry, I made a mistake.
I think you mean 7:19.
7:20.
Okay.
7:20. Okay, thank you for the correction. Okay, we are in recess till 7:20. Thank you. Okay, we are back. Ms. Leger, can you please call the roll? Ms. Leger? Ms. Leger? Ms. Leger?
It's odd. She was just here a couple of minutes before you all showed up. So.
Ms. Leger? Victor, are you there?
Yes, I am. I'm calling to try to let her know that we're ready to start. Give me a moment.
Thank you.
I'm trying to contact her right now to
I
let her
appreciate it. Thank you.
Bruce, Chris here. You said 7:30.
Sorry?
You said 7:30.
No, we corrected it as 7:20 because it was 10 minutes. It was 7:09.
Yeah, I don't know if people heard that correction. I didn't, so
Okay.
just saying.
All right. Well, thanks for being here.
Well, Chair Wolf, I can go ahead and get us started.
Okay, great. Thank you.
Give me a moment. I wasn't keeping track of the rules, so please forgive me.
I want you to call the
On the
roll.
roll to reconvene into open session.
Yeah.
Member Schmidt. Present. Schmidt present. Member LaHood.
Present.
LaHood present. Member Padmanabhan. My apologies.
Present.
Present. Member Wong.
Present.
Wong present. Member Stein.
Present.
Stein present. Member Yankee.
Present.
Yankee present. Member Highland.
Present.
Highland present. Member Neighbors.
Present.
Neighbors present. Member Forsley. Forsley not present. Chair Wolf.
Present.
Wolf present. We have a quorum.
I believe we were on item number
8.
Number 8.
Item number 8. Item number 8 is complaint filed by John Hooper against the Office of Economic and Workforce Development for allegedly violating Administrative Code Section 67.21 by failing to respond to a public records request in a timely and or complete manner.
Apologies, group. I just stepped back in.
Okay.
Yes, Administrator Lejar, we just took roll call, and I just called item number 8. We have not called any members to speak yet. Okay. I will turn it back over to you.
All right, thank you.
Ms. Leger, if you can read the byline for item number 8, please.
On December 2nd, 2020, the task force requested that the petitioner provide a bullet point list of missing documents to the Office of Economic and Workforce Development, and that the matter be referred back to the complaint committee once the records have been identified and exchanged. On February 16th, the complaint committee continued the matter to the college chair with a request to Mr. Hooper to provide details or documents or not documents that were provided based on the 21 bullet points.
Okay. Complaint committee chair Schmidt.
Yeah, I'm not sure if I was a chair at the time, maybe I was, maybe I wasn't, but I'll try to report what I recall. Yeah, we definitely, with this first case, which is against the OEWD, as you can see, it's quite a lot of documentation here, and this thing's been going for quite a long time. But Mr. Hooper's been just kind of fighting to get records, and it appears that finally he's still getting some new records, even as of May or June. And those are the records he's been looking for a couple of years. And it involves it involves records from, he wants records from a private entity, Parks Alliance, and that's a major issue in the case as to, how he can or should go about getting records that would be held by Parks Alliance. I'll leave it at that. Any other members of the committee at that time who want to say anything, please do.
I just want to note for the record that the members of the committee at that time was, Member Hinsey was the chair of the complaint committee, you yourself, and Vice Chair Yankee. Vice Chair Yankee, do you have anything to add?
I don't believe so. I think there was still some dispute about whether some records existed related to contracts and so forth, and and I believe we felt that OEWD needed to look a little harder, that Mr. Hooper needed to zero in on what exactly he felt was still outstanding, and so my understanding is probably now we're at that point where we can take a look at that.
Okay. And on that particular day, I actually stepped in for Member Hinsey for that particular meeting. And I recall the same as far as that's concerned. Okay, so let's begin. Mr. Hooper, are you here?
Yes, Mr. Chairman, can you hear me?
Yes, I can hear you perfectly.
Okay, great. Thank you.
Great. And
Mr. Chairman, members.
Hold on a minute. Hold on. I just want to ask if the respondent is present.
Yes, I'm present.
And who is speaking?
Mary Yamazuko Thompson from the Office of Economic and Workforce Development.
Okay, Ms. Thompson, thank you very much. Okay, Mr. Hooper, you'll have 5 minutes for your opening testimony. Please wait for Ms. Leger and the clock. Thank you.
Mr. Hooper, are you ready?
I'm ready.
Go ahead, sir.
Mr. Chairman, members of the task force, thank you for this opportunity to carry on this discussion. I realize, going over my notes since the December 2nd meeting that was referred to, that this will be my 9th time speaking to you, either on the agenda or in the form of public comment. So I do have a couple of new things to add, but by and large, I think one of the main points I'd like to focus on, because it appears to have been something that has been confusing for the task force, is in this situation where the city is running and financing programs involving more than one department. Who does one ultimately expect to disclose documents that have been referred to? And as you may recall, at your December 2nd meeting, you decided this was a multi-agency effort involving both OEWD and the Department of Public Works, and it was appropriate to keep the complaint separate. And what that really means is that you understood that the responsibility remained with both of the agencies to disclose the public records involved. Now, it got complicated after that, and you may recall that at a complaints committee meeting on March 5th, the complaints committee essentially contradicted that former decision and I guess you'd say released Public Works from further responsibility to provide documents. So since that time, you know, having been told repeatedly there's nothing more, and you may have it, I submitted the reference last week in my written comments, but the attorney Hank Eckel submitted something like 1,740 pages of information within the last month or two. And within that, there's a lot of stuff that we've all seen before, but within that, there were a couple of pieces of information that I wanted to make sure, and certainly hope you don't have to read 1,741 pages, but that you be aware of. On the 2nd of January, 2018, responding to a question from Beverly Ng of the Recreation Park Department, Chris Corgus of OEWD wrote to her, GWD is run by the Department of Public Works. GBD, Green Benefit Districts, which is what this is all about, is run by the Department of Public Works. Later, can you hear me? I'm getting a lot of static.
Yes, I know. Miss, can you please stop the clock, please? Member Stein, can you please mute your, wherever you're doing is running over your microphone? Thank you. Okay, please restart the clock for Mr. Hooper. Thank you. Sorry for the interruption.
Not at all, Mr. Chairman. Do you want me to continue? Were you able to understand what I was saying before?
Yes, I think we've got where you just got up to right now, that the GBD is, you're claiming the GBD is part and parcel to OEWD. Please proceed.
Right. I'm not claiming it. I'm quoting an employee of OEWD clarifying that for a member of the Recreation Park Department staff. The GBD program is run by the Department of Public Works. That has been a source of past, which is why I want to pay some attention to it now. Another quote that emerged from the Henkel of information, also a quote from OEWD's Chris Corgus in a communication with Brooke Ray Rivera, who then for Parks and Science. The quote is, I am merely a conduit for a grant to get through. Jonathan Goldberg being the
all right, we're losing you, Mr. Hooper. We're losing you, Mr. Hooper. We can't hear you now.
Can you hear me now? Can you hear me?
Yes, I can hear you now. Please repeat.
Oh, sure. Mr. Chairman and members of the task force, just parenthetically, I live in the Haight-Ashbury part of San Francisco, and we have had no power since 8 o'clock this morning. So I'm running kind of on the low side off a battery on my cell phone, no access to my computer and so forth.
Okay.
So if I disappear entirely, PG&E said they'd have it all back on, at the close of ordinary business, but we still don't have power out here.
All right. Let me ask you, Mr. Hooper, if we do lose you in the middle of this, would you like for us to continue the item?
I can't imagine anyone would. I think the risk, God bless us all. I believe if we have technological difficulties, that the materials that I've provided you, even just going back to the 2nd of December of 2020, should give you more than adequate information to base a decision that I have yet to receive what I've asked for. So I would hope, even if I get, if I disappear into the ether because of low battery, that you would feel free to continue. And I also believe there may be a member or more of the public who is very concerned about this issue, and they might be able to chime in if I suddenly disappear off the radar. But anyway, I hope so. Anyway, Mr. Chairman, the reason I emphasize that issue is that that was the principle.
All right, give him another 30 seconds for the input that I made.
Yes, just to clarify, members of the task force, that was really the main point of confusion that you were all struggling with. Should the responsibility be placed only on OEWD or both OEWD and DPW? I contended, for reasons that I won't bore you with and you can read in the next 10 minutes, that both, it's a joint venture, so to speak, a multi-agency effort, and both agencies are equally responsible for providing the information. So that's really all I have to say, and I appreciate the time.
Thank you. Are there any persons or witnesses to provide any facts or evidence on behalf of the petitioner, the complainant?
Sullivan.
Okay. Thank you, Ms. Sullivan. Go ahead. You have.
Well, I just want to start off with saying that we did a number of public record requests, and Mr. Heckel gave us documents that were new that he should have received within the date of his request. I don't know if they've been submitted or not to the task force. I do want to talk about city contracts have a number of clauses stating city ownership of all documents and work product. The city expects to receive the work it pays for. Records produced by city contract are city records, and they are therefore public records. City Administrative Code 2134, audit of contract records, allows for the city to inspect records related to the performance of all contracts. Quote, such books and records shall be maintained by the contractor for 3 years from the date of the final payment under the contract, unless a shorter period is otherwise authorized in writing, end quote. This is echoed in city contracts. Failure by contractors to retain records is failure of Sunshine Ordinance 6729-1. Originals of these documents shall be maintained consistent with the retention policies of the city and county of San Francisco. In this case, the retention policies for the contractor is mentioned in the previous code 2134 that I cited, and in all city standard city contracts. The city OEWD has the right to get city records. The contractor, SF Park Alliance or TGS, must retain those records. Reason for these clauses are for accountability of the contractor spending the city's public money. Public record and access laws are for public ability to hold public officials accountable and those acting on behalf of the government. The right of the people to know what their government and those acting on their behalf of their government are doing is fundamental to democracy and with few exceptions, this right exceeds any other policy interest of government officials, and I'm adding those acting on the government's behalf, may use to prevent public access to information. Sunshine, Section 67.1D, and I thank you for your time.
Are there any other persons or witnesses providing facts or evidence on behalf of the petitioner or the complainant? Okay, hearing none. Respondent, Ms. Thompson, you have 5 minutes. Please wait for Ms. Leger.
Ms. Thompson, you ready?
I'm ready.
Go ahead.
Okay, thank you. So I just want to clarify a few things. First of all, in the February meeting, the task force asked us to support Mr. Hooper by matching our responses, the 1,700-page document that we had sent Mr. Hooper in his original request. You asked us to support him by matching our response to his original request. I also want to clarify that Mr. Heckel was responding on my behalf as I was deployed to the COVID Command Center. So I need to clarify that the response that Mr. Heckel gave Mr. Hooper, Anonymous, and Mr. Sullivan were the original 1,700 documents that I gave Mr. Hooper. So on May 3rd, Hank gave Mr. Hooper, Anonymous, and Mr. Sullivan an index of 21 category of records for the Green Benefits District. We did this at your request, and we responded to all 21 requests and all 21 questions. What's noted is we don't have documents for 5 of the items, potentially even more of the 21 questions that Mr. Hooper provided us with, and we have told him that we don't have those documents. And just also to clarify, Mr. Hooper, in his original response, was given all 1,700 documents. Post that, when we went back after the February meeting, we found additional documents that came in after Mr. Hooper's original request. We provided Mr. Hooper, Anonymous, and Mr. Sullivan with all of those documents. And to remind everyone, the documents we provided him did not exist at the time of his original request. While doing his request and indexing, we discovered that there were a few documents that we did not provide to Mr. Hooper in the original request. This wasn't an oversight. It was probably and potentially more a functionality of Microsoft Outlook, which search capabilities changed from 2019 to 2021. So we never intentionally withheld any documents from Mr. Hooper. Since the February meeting, we provided him with all of the documents. We've indexed them to respond to his 21 questions as they were presented to you and to us, and we have given him everything that he is required. And that's my response.
Okay, thank you. Are there any persons or witnesses providing any facts or evidence on behalf of the respondent? Okay, hearing none. Members, the item is with you. Vice Chair Yankee.
Sure. Mr. Hooper, I'll ask you first. It sounds like after the February complaint committee hearing that we had, that there were additional records that were turned over that you had not previously received. Can you elaborate on how many additional records you received after that complaint committee hearing that you had not received from OEWD prior? Looks like perhaps this happened, I'm guessing, looks like somewhere in April or so, from what I could tell from the attachments that I've read through.
The new information, well, not new information, some of it I've seen before on several occasions, but the latest disclosures that I've seen and that Ms. Thompson referred to were the ones that came, the 1,700 pages that came from Henkel, and that's where the quotes that I gave you a few minutes ago from where the OEWD representative clarified that the Green Benefit District program is run by the Department of Public Works and so forth. So I'm trying to be responsive to your question.
Let me ask it more succinctly. Could you just give me an approximate number of, let's say, pages that you received from Mr. Heckel that you had not previously received, that was not part of the initial group of documents that OEWD had given you? Like, was it 50 more pages that were new to you that you had never seen before, or 100 more?
I understand what you're asking. I've highlighted the pages that I got from the Heckel disclosure packet, and let me just quickly. Well, I would say there, by page numbers, there's probably something like 60 documents that I had not seen from prior disclosures from either DPW or OEWD. So if that's approximate. I was just going through my highlighting of pages that were new to me from the Heckel disclosure packet.
Okay. So that's fairly significant. So with those additional documents now being turned over, do you still believe that there are even more documents that are still outstanding that you've not received, or do you believe that those additional ones from Mr. Heckel now fulfills the remaining documents that you thought may have been out there? Well, clearly were out there.
Well, the short answer is I still do not have all the information which I need to understand how the city has spent this money, and which I believe must exist because the payments were required under contract. I will say, though, that the gap has narrowed. I do understand more fully than I ever have previously the city's budgets for these several green benefit program publicly financed campaigns that were run. I now have seen, and I consider it new information from the recent Hank Heckel disclosure, several requests for payment from Parks Alliance or its predecessors, Build Public or Place Lab, which I don't believe I've seen before. But what I still can't figure out, so the budget seems clearer, certain requests for reimbursement from the contract agency, Parks Alliance, are now there, but I don't see any records of city payments. So what I'd like to be able to say, when I talk to my supervisor or the mayor, is why has the city spent whatever it is, $1 million on public campaigns to foist programs upon an unwilling public instead of providing basic public services? That's what this is all about. So this is a long answer to say, no, I still cannot figure this out. And I still believe that the data I require is very simply right. It's required by contract. So, now the complicating thing, in fairness to everybody, is that these efforts funded by DPW and OEWD and staffed by them failed. So it's not clear that all the money that may have been budgeted actually got paid out.
Okay, so Mr. Hooper?
But yes, please.
Yeah, so to follow up, is there a way that you could very succinctly describe, what you believe is still outstanding? Like, is it
yes,
payments from the city? Is it a contract? Just very succinctly describe what you think is still you have yet to receive.
I can reply to that very simply. The information which I have not received is the records of payment from the city. I have requests for payment, in other words, invoicing, but I do not know what the city paid in full or in part, depending on how far these failed efforts actually got.
Gotcha.
So it's a simple answer. I haven't gotten any records of the city making payments to the nonprofit, which we all know goes by various names: Build Public, Place Lab, Parks Alliance.
Gotcha. Okay, so From my experience, at least my personal experience, I know disbursements are often done by the controller's office. Has anyone reached out to? Actually, this is a good question, I guess, for the respondent, Ms. Mizuko. Could you maybe speak to? Did you contact the controller or whichever office in the city handles disbursements to try to get this information from Mr. Hooper?
First of all, I need to clarify something. We did, in fact, give Mr. Hooper the payment records. That was in the TGS system, and that was the documents we found post his original request. We were at least in our office, myself and Chris Corgus, who manages that program, that those payments are processed through something called the TGS system. And those are the additional documents that we provided to Mr. Hooper. So in total, we gave him 24, potentially 25 extra documents from the original 1,700 documents that we gave him. I want to also explain something, just really to clarify this. The 1,700 documents that Mr. Hooper received from Mr. Heckel were not new documents. They were, in fact, the original 1,700 that I gave Mr. Hooper. What Mr. Heckel did was he matched them, he indexed them to specific questions that Mr. Hooper provided us post the February meeting.
I understand that.
Okay. So then the one last thing about that, Mr. Hooper, Anonymous, and Mr. Sullivan, I believe, have all made requests to the controller's office for those documents. But we did provide Mr. Hooper with the payments, and those were the ones that came through the TGS system.
Okay, so then let me go back to Mr. Hooper. Mr. Hooper, do you recall seeing those payments that Ms. Mizuko just spoke of through this TGS system in what you received?
No, I do not recall seeing so-called TGF documents that represent records of payment for those two Green Benefit District efforts. And I also, in the format, I think Ms. Thompson is saying that I should have received information keyed to the 21 revised questions that you asked me to submit, and I submitted last December in response to the task force requirements. I got 1,741 documents from Mr. Heckel, but I don't recall seeing any way of that they were cross-referenced or keyed in any way so that I could easily or in any way see, my question number one, oh, that's how it was answered, that's fine, et cetera, et cetera. I'm a little bit baffled. I'm sure everybody's going forward in good faith, but I don't remember receiving so-called TGF records of payment, and I don't recall receiving the Heckel, the more recent Heckel documents formatted in such a way that they were intended or meant to coincide or reply specifically to my 21 questions. That would be great. Then it'd be much simpler to figure out what may still be missing. But that's my understanding, and I've spent a lot of time going through these things. I think I've been thorough.
Okay, Ms. Mizuko,
can I interrupt for a second? Vice Chair Yankee, I think it'd be better. The task force had asked OEWD to provide this information, Mr. Hooper. The question should be really to OEWD as to if they did so, and it was indexed. Was that provided to us in the record today?
That's exactly what I was just about to ask. If Ms. Mizuko could point out
where
absolutely. Documents are.
Sorry, I didn't mean to interrupt you. Yes, actually, I do believe that Cheryl was CC'd on the response to Mr. Hooper, Anonymous, and Mr. Sullivan. But to point Mr. Hooper directly to the documents, one of the documents he's received is labeled SSPA May 2019. 00858548 is a responsive document to the invoice. SFPA March 2019-008-00013 is responsive.
Ms. Mizuko?
So, I mean, I could go through, but I don't want to list all of them. But yes, he has received them.
Okay, Ms. Mizuko, but it needs to help the task force. Can you point in the packet? I mean, I'm sure that you provided information to Ms. Leger before this, and so could you point to in the attachment so that we can all look together here, as in this meeting, to see what those documents? Do you know where they are? What page number they're on?
I would actually defer to Ms. Leger because we did send her the complete file, and I will have to. And actually, to be honest with you, as I click on this where it says attachments, it's not opening up for me. But we did indeed send those documents to Ms. Leger.
Okay, if I received documents, they were put in a file. There were several emails from Mr. Heckel with multiple attachments. They were included in the file. That's all.
Okay, so yeah, the problem here is this is a massive file, okay? And it really, I'm sorry, Ms. Thompson, I'm going to put the onus on you. This is your defense. This is what the task force had requested you to do. And we want to find out, if you're saying that it was done, then we need to see if Mr. Heckel had in fact indexed all the documents based upon the 21 bullet points. Then we'd like to see that. That's why we're here today.
Correct, and we did send that to Ms. Leger.
And can you, fine, but can you?
But I can't. What I'm saying to you is, when I go to your agenda and I click on attachments for my specific item, number 8, it doesn't open up for me.
Okay.
There are items underneath, but it says item 8, part 1, part 2, part 3. Do you see that?
I do.
And if you hover over that, they're actual links.
Correct.
And
so let me go back.
Okay. All we're looking for is a page number because we've got thousands of pages here.
Member Schmidt, I know that what I saw was that Mr. Heckel did, he sent an email answering one of the 21 or two of the 21 at a time, and then he lists the documents that were responsive to that request. And so he did this sequence of different emails, and that's what a lot of these files are that we got in our document compilation.
There's no way to discern what documents apply to bullet number 1, bullet number 2, bullet number 3. That's what we requested. That's what we're asking for here.
Well, that's what I just said. He says he matches each number in a series of emails that were in our documentation. I don't know where. This thing is huge. I didn't mark every one, but I'm saying that they're there.
So this is member Stein.
Right. So,
can I just say it? Like I'm.
Go ahead, member Stein.
Go ahead, Cheryl.
Yeah. So I'm looking at like item 8, part 7. I'm on P2069, and this is a list that I've seen in a few places. Where you have the response to your numbered requests are set forth below, and it has like number 1, OEWD is not located responsive files, number 2, responsive materials produced at pages, and then it just gives kind of a long list of document pages, but we don't have a way, well, I guess we can click on some of them, possibly? No, when I click on them, nothing happens. And then the list goes on like that. Which ones were found, which ones were not found.
Okay.
So if you're looking for the invoices starting at item 8, part 6, page 2030, you will find the invoices.
Part 6.
Item 8, part 6, page 2030.
really like your rug. It's not in its right spot. What? You like your rug because it's not in its regular spot.
Yeah, well, it's backpack.
Perhaps you might want to mute your committee
Yeah,
members.
use that one.
Sorry.
You're right.
Okay, 2030. I'm there. Okay.
I'm just seeing an email that says, please see attached supplemental file, but no attachment.
Right.
Yeah, Ms. Mizuko, maybe you could show us where those, I think you called them, what was it, a TGS or something? I forget
TGS
the
files,
acronym.
yeah. I think that part of the problem may be the way that these, I think the problem is the way that this request was uploaded in PDF to you, but the TGS files are in here, or they were in the ones that we provided to Ms. Leger.
Yeah, what we're seeing, if you look on page 2033, that regards or relates to category number 12, the bullet number 12. And if you go to the next page, to 2034, it jumps to category 15. So it's
yeah.
And then there's
Go
ahead.
I think it's the way that this document has been PDF'd and presented to you, but the invoices were given to Mr. Hooper and Ms. Leger in the responsive document.
Let's all, while we're on this particular PDF, let's all look at page number 2036. That's PDF page 100 out of 130. Those are the 21 bullet points, and those are the kind of the responses for each one of those. And I guess the materials are scattered around this record, this file somewhere. That's dated March 16th, 2021. So,
Can I just say, as Member Stein, like I went through this pretty carefully, and I don't recall seeing anything that looked like records of payments that were made from the city to, the Parks Alliance.
Okay.
So I saw many times this list reappear, but and in fact, I will also say there were many links that I tried to click on that didn't go anywhere, or that went to kind of dead space. But I don't recall seeing a list of payments.
So the list of payments were included. The numbers that you're seeing, the index that you're seeing on 2036, had this been a live document, those numbers would have taken you to the actual documents. What I'm saying to you is we have provided these two documents, and we've to Mr. Hooper and Ms. Leger. It's that the fact that this has been PDF'd in a way that does not allow you, for you to have been the original recipient of this document, to see that the invoices and all the documents are in there.
oh, so they're hyperlinked?
They're hyperlinked.
Oh.
We did that to make it easier for Mr. Hooper so that as he looked at his question, like if he looked at question number 21, he could then click on the hyperlink, which says 00069. That would have provided him. And so that's the problem that we're seeing, is that those documents were provided to everyone. It's just that the way that this PDF, it doesn't allow you to click on those links.
Okay. Member Stein, any last thoughts?
My problem, I guess, is that I feel like Mr. Hooper doesn't seem to have access to these or have seen these, and we can't access them or see them. Is Ms. Thompson able to look at examples of these and read them off to us or something so that we have some sense of what they contain?
I would probably be better to corroborate it with the petitioner. Did he actually get them?
Said he didn't see it, and now he doesn't have, tech access. But yeah.
But I guess I would ask Mr. Hooper, when he received the response from Mr. Heckel, was he able to click on links, and did those links take him to documents?
Exactly.
Because if it didn't, then he should have responded back to us and said, these links don't work for me, instead of waiting till now to say those links don't work. So Mr. Hooper, was he able to click on those links?
Right. So before I get to Member Schmidt and Member Neighbors, other hand, let's get this question answered first. Member Stein, then you can finish up.
Can I just say, if we can also, if Mr. Hooper wasn't able to do that, I think there were 2 other people who had also requested that data. If we can also ask them whether they received it, if Mr. Hooper didn't.
Mr. Sullivan is now party to this, so he can certainly answer it, but Anonymous is not party to this, so we cannot ask him. Mr. Hooper, are you still there?
I'm still here, Mr. Chairman.
Okay, so of the email, from the email that Mr. Heckel had sent you, looks like there was an email on March 16th, 2021, where it lists your responses for each of your 21 bullet items. Were you able to access any of the documents that were hyperlinked in that email?
Mr. Chairman, no, and I'm not sure I received the information that Mr. Heckel dug up in an indexed format. It was page numbered, it was paginated, but it didn't. Actually, I didn't even think he was trying. It didn't even occur to me that it was an attempt to answer the specific 21 questions, which we've all been trying to get to the bottom of. So I'm not sure. In a way, it's sort of gratifying that you guys, who are experts on this, are having as much trouble as I am. But I saw it as another, because there have been, a number of different times where first we're told there's nothing more to give you, and then 2 weeks later you get something more. I thought this was just another of those situations where the city had come up with additional information that it hadn't realized was pertinent or hadn't disclosed earlier. So I can't say I understand or did grasp that Mr. Heckel was formatting his 1,700 documents in such a way that they were intended to represent answers to specific questions. Okay. I actually went through an exercise myself of going through and saying, well, is this responsive? This is irrelevant. I've seen this twice before, and so on and so forth. So anyway, I apologize if I'm being dense about this, but
no, it's not that. We're getting closer, but we're all a little confused. I just want everybody to notice that on these emails from Mr. Heckel to Mr. Hooper, that they are referencing emails that were being sent to someone else. Someone called Mayor Sunshine Requests at, well, that's a general, someone called A Records Requester at protonmail.com. That is not Mr. Hooper. And so all of these that Mr. Heckel is sending to Mr. Hooper are messages that he sent to somebody else that he then forwarded to Mr. Hooper. And so I'm wondering if at that point it made it so difficult to track for Mr. Hooper. I'm not sure, and that's what I'm trying to ascertain. Let's go to Member Schmidt, then we'll go to back to Vice Chair Yankee. You're on mute.
I guess you're done on that line. Okay. I've got a couple of somewhat of a shift here. To Ms. Mazzelko. First, are you saying that you sent the TGS documents that would be responsive to Mr. Hooper's requests to him already?
What we're saying is the TGS documents are in fact the documents we found after Mr. Hooper's original request.
When did you find them?
We found them when you asked us to go back and index the records for Mr. Hooper. We found them in that process.
Okay. So the TGS documents you then did produce to Mr. Hooper in 2021, is that right?
No, there was an original Sunshine request in 2019, and then these were additional records in 2021.
2021. Okay.
Yes. And I believe that Mr. Heckel just resubmitted these documents, just replied to Ms. Leger so that she can see the 21 records request and how it's connected.
Okay. Make it brief, please.
Well, so Mr. Heckel just sent all of these, resent them to Cheryl, Mr. Hooper, Mr. Sullivan. And to clarify for you, the Proton email that you are referring to was from Anonymous. That is Mr. Anonymous's email address. Post the February Sunshine Task Force, Anonymous helping Mr. Hooper to get clarity on his questions, resubmitted Mr. Hooper's questions in 21 points. And that's how we responded to both inquiries, because they're the same inquiry. They're from Anonymous and from Mr. Hooper.
So what you gave to one, you gave to the other, correct?
Correct.
Okay, great. Now, I've got one other topic I want to ask you about. The OEWD does business with the Parks Alliance, correct?
Yes.
Okay. And there are contracts that are signed between the OEWD specifically and the Parks Alliance, correct?
Correct.
Okay. And Parks Alliance is it anything different than something called Place Lab and Build Public, or are they all sort of the same thing?
To provide clarity, Place Lab is the original contract holder.
Okay.
It folded, and that contract was then awarded to Parks Alliance.
Okay. And what's Build Public?
It was a nonprofit that supported public space. It supported public space activation. It's no longer in existence.
Okay. Now that the Parks Alliance, have you ever made contact yourself with Parks Alliance to ask them for documents to respond to the Hooper requests?
Yes, we did. And those documents were given back in 2019 to Mr. Hooper. We reached, based on what the Sunshine Task Force asked me to do in 2019, we went to the Parks Alliance and asked them if they had any additional documents, emails, other than what we currently had in our files, and they did not.
Okay, so did you show them the text of Mr. Hooper's requests that were made to OEWD at that time?
Yes, we did. And this was all addressed in a previous Sunshine Task Force meeting in 2019, and it was decided then that we could not compel Parks Alliance to give us any additional documents. And I had reached out, and I made this presentation at the task force 2.5 years ago and said I reached out to the Parks Alliance and that they said that they had given me all the documents that we had. So all the documents they have is what we have. All the emails that we have is what they had. And they had no other additional documents. And this is a very different line of question from what we are here to respond to today.
I'm sorry, please don't tell me what to ask you, okay? Because this is very important to the case. The Parks Alliance documents you're talking about in 2019, was that the Hooper case or was that a different case?
Yes, that was Mr. Hooper and Mr. Sullivan.
Mr. Sullivan. Okay, so that wasn't
That
Mr.
was Mr. Hooper and Mr. Sullivan.
Oh, they were together at that time.
They've always been together.
Oh, they've always been together. I see.
Mr. Hooper, Mr. Sullivan, Mr. Tomasevich, and Anonymous.
Okay, but who decided that Parks Alliance didn't have to give up any documents? Was that you?
When I presented to the task force, and you had received a legal opinion from one of the city attorneys, and I said that I had made every effort to get those documents, and if there were any additional documents, and Parks Alliance said that they did not have any additional documents, that was the task force.
So, but why would anyone have said Parks Alliance doesn't have an obligation if they were actually giving you everything? How would that have happened? I don't understand that.
The task force asked me to ask the Alliance if they had any other additional documents over and above what OEWD had.
Okay.
We went back to them and we asked them, and they said no, they did not.
So they didn't say, so nobody in this whole process said Parks Alliance doesn't have any obligation. Because I thought that's what you just told me. That someone said the task force
had decided that. I believe the task force decided that 2.5 years ago at a previous hearing.
But they said that Parks Alliance doesn't have an obligation, but Parks Alliance would have an obligation to OEWD if OEWD asked, correct?
Correct, and we did.
Okay, that clarifies, as opposed to a request made directly to Parks Alliance. Okay, thank you. I have no further questions for the witness.
Okay, great. Member Stein, did you have something else to add? Or Member Neighbors? Go ahead.
I don't think I do. This is Member Stein.
Okay, Member Neighbors, you had your hand up before. Did you have anything you wanted to ask?
No, it was covered. Thank you, though.
Okay, great. Has everybody gotten everything they need? Okay. Can we, so at this point, Mr. Hooper, are you still there?
Yes, sir.
Okay, so at this point, the question becomes of the multitude of emails that you got from Mr. Heckel, there is in some of them attachments, and some of them have actually an index from 1 to 21 with responses for each of those 21 items that we requested to be made. And in those, there are links in there that you can click on to download those items. Do you recall seeing those?
No, it sounds mind-bogglingly difficult. I do not recall seeing those. Unfortunately, I don't have electricity, so I can't go to my desktop and verify. But have you been able to do exactly what you're describing?
Well, we see the emails. We don't see we cannot check the attachments, but we're not so concerned about, the attachments or the records, except for the ones that you're concerned about. So we just want to make sure that you received all the documents that you requested. Ms. Thompson claims that everything has been provided, including the contracts and the accounting. So that's what we're trying to ascertain here at this time.
Well, the same thing. Do you want me to respond?
Well, I just the question I have here is, these are emails that are being sent on a regular basis to you. June 11th, June 14th. This is 2019. Then jumps to May 3rd, 2021. And then another May 3rd, and another May 3rd, and another May 3rd. I mean, it goes on and on.
Well, maybe there's another way of looking at this. Is there a lower technological method? I mean, we used to send things to one another called letters. I wonder if rather than hyperlinks and, all this kind of thing, since apparently OEWD is making a good faith effort to get the data to me, and they are convinced that I really should have it all. And, you know, maybe it's as if somebody sent someone a response to a question they'd asked, but they sent it in a language the person didn't understand. The person might say, well, I really need that in English.
Okay.
And maybe that's what
Go ahead.
giving.
Okay, go ahead.
You want me to?
Yeah, go ahead. Finish, Mr. Hooper.
Well, I just wanted to say that I certainly give the city agencies all credit for proceeding in good faith, but you know, if it's really just a matter that I can't open a hyperlink or I don't understand what PGF is, or isn't there a simpler way? Just print the stuff out.
You're going to be charged for it.
Oh, big deal.
Okay. Member Stein.
I've spent 2.5 years on this.
Yeah, this is Member Stein, and I feel like I'm getting hung up here because I'm trying to understand if really the documents that are on hand or should be on hand have been delivered, and because of our PDF we can't tell, and because of the power outage and the hate, you know, Mr. Hooper can't tell. So I'm wondering if Ms. Leger has the original things that were sent to her before they were PDF'd, and if she can maybe share with us what she's seen, or if, I guess it's Ms. Thompson, I'm a little confused who the respondent is, if she has the original documents and can drop us a link to them in the chat, or if there's any way for someone who might have access to these pre-PDF'd actual documents can, like, you know, because I'm on Zoom calls all the time, people drop links into chats that we can all then go and check and see what's there. Can Ms. Leger or Ms. Thompson or Mizuko do that? No.
Yeah, I don't think that's
It's very hard for us to decide this case if we don't know if the information has been delivered.
I don't think it's going to be helpful to have Ms. Leger try to go dig all those up in the middle of a meeting right now.
Even one would be helpful.
Just for the record, thank you. Sorry to interrupt you guys. Ms. Leger was just sent all those links and all those documents from Mr. Heckel. So if she is near her desktop or her computer, she can actually go through it. He was gracious enough to actually format them for her so that she can see which were compliant. So, for instance, Mr. Heckel just sent Ms. Leger an email, and it's the heading is Forward GBD Paper Trail 19061-19062, and again, she does have those.
What date is that, Marianne?
Pardon?
Can you tell me the date of that email? Forward.
Oh, he just sent it to. He just resent it to you right now, so that you would have it at the top of your email.
I'm going to interrupt this for a second before I take Vice Chair Yankee's hand. Mr. Sullivan is party to this. Mr. Sullivan, did you get these records?
Okay, yes, I got some. I'm looking at them right now, and they're not in your packets.
No, we're talking about, did you get the actual email of these documents, not what's in our packet?
Yes.
Okay, can you confirm getting the records that Mr. Hooper is looking for?
I can confirm I have records of transaction voucher IDs and invoice numbers with numbers that came from OEWD and Mr. Heckel.
Does that include invoice amounts?
Yes. So we have payment date 4/23/2019 for $45,650 USD from Bank of America.
Okay, I'm looking at an email that I just received from Hank Heckel. The payment records copied to Mr. Hooper, the task force, and Mr. Sullivan on May 25 2021. Would you like me to forward it to everyone?
Yes, please.
All right.
Okay, Member Yankee, Vice Chair Yankee, go ahead.
Yeah, I was just going to note that, and this might be part of the problem. I was looking on page 2036, and this is one of the various emails. It looks like was sent with the 1 through 21. And I noticed that one of the sentences in there says the responsive materials be provided through an FTP link with associated credentials. And so I don't know if there's like some type of login password or something that may have been a separate email that maybe Mr. Hooper didn't receive, or how it worked. But it sounds like it might be more than just clicking a link. It looks based on associated credentials. And so
look at the headers above that, and you'll see that that particular email is forwarded to
right.
Mr.
Hooper.
It
right.
is
So that's
not
my point.
addressed
So
to
I
him
wonder I wonder if the actual credentials were ever sent to Mr. Hooper, because it looks like it was a forwarded email that was sent to anonymous, and if Mr. Hooper never received the associated credentials, he obviously couldn't look at them.
Exactly.
He didn't need credentials to look at them. He doesn't need credentials to look at them.
Okay.
What it basically is saying is that we are allowing you access to a file that sits in one of our shared services. That's what that is saying. He doesn't need a credential. He doesn't need a password. It just is saying that we are allowing you access to a file that sits in one of our servers.
It would have been good just to say that. I don't even understand what an FTP link with associated credentials means, and I'm a chief information officer.
There was one email that Mr. Heckel sent that you had to get a code for to access the documents, and I took screenshots of that. That's how I know the invoices.
Okay. All right, folks. We are way over time on this. Are we satisfied with the discovery portion here at this point? If not, let's consolidate and get to it. Yeah, I've not received the email yet either.
I sent 2, Bruce. Both of them from Hank Heckel.
Yeah, I haven't received it either.
I haven't received it.
They're large files, I think.
May not be able to receive it then. Email will only allow up to maybe 20 megabytes or so.
It would have sent Ms. Leger a message that said this file is too large to send. So the thing about Microsoft is that it won't let you send a document. It won't let you send it if it's too large. And it bases it off of understanding its knowledge of other people's email capacities.
Okay, now I got it.
Somebody got it.
Yep. Oh, this is going to take a while to download. Gather. It says I need a passcode.
I think you can just, this is never wrong. I think you can just get one sent to your email.
Right. Yeah.
I just signed in with Google and it let me sign right in.
It just says that I need a one-time passcode.
Yeah, it'll send it to your email address where you received the email.
I see.
I was just going to bring up one concern with the way we're approaching this, in that these records that are being emailed to us now have been made available to the public. I don't know if that's a concern for us, as they are.
Well, supposedly there are records that were supposed to be that were sent to us properly with hyperlinks in the forwarded emails, but got stripped out through the scanning process. So yeah, I hear what you're saying. I'm not sure how to, whether, what to do about that at this point. If you want to stop and not consider this, then say so. I would, if we can, if you make an active statement or request, then let's do that. If you feel uncomfortable about the way we're going about it now.
Were these not already a response to a public records request and therefore public records?
They were part of emails that were sent to numerous people.
Well, I mean, I thought they were sent as a response to a public records request.
Yes.
Ergo, they are public records.
Yeah, but Member Wong is suggesting that if they, as part of our hearing, if they weren't part of our record, then there are other people here in the at the meeting that have a right to see those as part of the record. So if we're the only ones that get to see it,
oh, I see.
And Mr. Hooper can't even see it, then that's the problem here. So
can we not drop these links into the? Oh, they might not have the chat access.
No, they don't. Everybody else is called in by phone.
Right.
And Mr. Hooper has basically expressed that he has some technology difficulties, possibly in tracking these down. So the question I would say here is, Member Stein, you had the question of whether there were, you wanted to see the invoice voucher number of vouchers. Are these the documents that you were looking for? If they are part and parcel to the emails that were sent to Mr. Hooper or forwarded to Mr. Hooper and were sent to Anonymous, a records requester at Proton Mail. If those emails that Mr. Hooper received actually retained the links in them, then he should be able to see what we're seeing right now.
Mm-hmm.
Okay, Member Wong, does that satisfy you?
Perhaps. I just worry that folks who are part of the public that aren't party to this case may not be able to make, the comments that they'd like to make with the same level of accuracy that we would be allowed to as members who can see some of these documents, and or folks who are party to this case. So
well,
I would say I still have concerns around it, but
I would say if that is a concern, and it's a concern of the task force in general, then I would say we continue this item so that it can be redistributed in the record. And because right now we're going on over an hour on this, and we have one more that is similar to this. So just in the matter of time. Okay, I have Member Neighbors, then Vice Chair Yankee. Member Neighbors? Member Neighbors?
I don't have my hand up. Do I?
Oh, I thought you had your hand up. I'm sorry. Vice Chair Yankee.
I think that Member Wong's point is good, but I'm not necessarily sure that we even need to look at the records for this stage. I think it's already been admitted that certain records were not initially turned over in the last 2.5 years. I don't think that even OEWD is disputing that at this point. And so I think just based on the testimony alone, I'm thinking that there's enough to find a violation because, obviously here we are 2.5 years later, and we're now finding out that additional records did in fact exist after being told multiple times they did not. And so my line of thought and see what anyone thinks here is that perhaps we finally find a violation here. And since I think that's very clear that there was one, then we send it off to compliance and amendments and then make sure that all of these files that we're speaking of now that didn't make it into the record are included into that agenda for compliance and amendments for follow-up to make sure that Mr. Hooper can then access those new files that he wasn't able to see prior to this meeting. That would be my suggestion.
That's a good suggestion, but you got a little ahead of the bus here.
I know. I'm sorry, because I know we were talking about continuing, and that's the only reason I went there.
I got it. So you'll probably need to repeat that after rebuttals are over.
Yeah.
So we can arrive at some decision. I appreciate that. Thank you.
I didn't want to continue too early.
I got it. It's all good. I hear you. Okay. Any other questions for the parties here regarding discovery? Any other information you need to be able to arrive at some conclusion? Okay. Is there a call for a continuance necessary or not? No? Okay. Then we'll move to rebuttals. Ms. Thompson, you have 3 minutes for rebuttal. Wait for Ms. Leger.
You ready, Marianne?
I sure am.
Go ahead.
I have no rebuttal. I'll take the violation, and thank you all for your time this evening.
Mr. Hooper, please wait for Ms. Leger. You have 3 minutes.
Go ahead,
Standing
sir.
by.
Go ahead.
Thank you. Thank you. Mr. Chairman, members of the task force, I think it's well nigh time that a violation is found. I would urge you to move ahead in the direction of the task force member who just suggested that. And I think that would move things in the right direction. I do think that just as a matter of policy for all of you to consider, that I don't think we want to get to a point where the only citizens who have a right to transparency in their city government are those who have an internet technician standing by their side, or a staff that can, I'm noticing it with some, frankly, gratification that you're all having a lot of trouble with this. You're the experts, and I'm just a member of the public. And I mean, I use email, and I, go to use FaceTime and stuff like that. But I mean, if everything you have to access requires hyperlinks and special passcodes and layers of, confidentiality, it's almost as if you're just going to provide the information in a language that the person who is interested doesn't understand. So I think part of the problem, it may just be one of, let's keep it simple.
Okay, thank you very much. Okay, members. Now, Vice Chair Yankee, you can launch.
Okay. I'm not sure I have much more to add, but I'll just elaborate. I mean, just for the record, though, I find it, I certainly feel Mr. Hooper's frustration. We have all met on this multiple times. This has gone through the task force, I think at least the full task force, 3 times at least, several committee meetings. And, Mr. Hooper, all along the way insisted there were more documents, and sure enough, there were. And I think that's, extremely frustrating for a member of the public to have to go that long to find these records. And so I certainly do think that there is a violation here. At a minimum, I'm seeing 6721B, because obviously it says within 10 days, and here we are a lot more than 10 days later. I guess I'll go ahead and throw that out there. I can make a motion unless anyone else wants to add or has additional points they want to bring up. No?
Any other discussion or comments? Okay.
All right, so I'll go ahead and turn my proposal into a motion. I'll find a violation of 6721B for not supplying the requested records in a timely fashion. And I would also recommend this be referred to the Compliance and Amendments Committee for follow-up, and to ensure that Mr. Hooper can, use the links to obtain the invoice and other information that he was unable to view prior to this full meeting, and to have those records included in the agenda packet for that Compliance and Amendments Committee, so that they're public record before Compliance and Amendments meets.
Before there's a second, I want to ask if you'll take a friendly amendment that since Mr. Sullivan has stepped up to be party to this file now, that he also helped Mr. Hooper.
Yes.
I find that because it seemed clear to me that he was looking at one of these documents, invoices. So.
Yeah. accepted. So that's my motion.
Is there a second?
This is Member Padmanabhan. I will second that.
Okay, moved by Vice Chair Yankee, second by Member Padmanabhan. Any further discussion? Okay, let's open it public comment. Cheryl, hand it off to you.
This is anonymous number 3, if I may speak.
Yeah, just a second. Go ahead, sir.
Thank you very much. I am the anonymous who received these records originally. I'm going to tell you the real story because Ms. Thompson has misled this task force, which is really infuriating. Ms. Thompson and Mr. Steinberg told this task force and Mr. Hooper at the committee that they refused to do the indexing by 21 items that he had asked and that you had told him to do because he had not separated which of those were and were not already provided to him. So what happened at the end of that meeting, that committee meeting, is I issued 21 records requests to DPW and OEWD to force them under the CPRA to tell me which of those had records and where they were, which they did do. They did not do it when you asked. They did it because I issued separate 21 records requests in February. They then responded to my request. They did not provide any index, or they provided an index, but they did not hyperlink. That's not true. That you can't go find out which of those records. You have to go through the page numbers.
Mm-hmm.
Their own system, me as a person who runs a computer software company and has done software engineering for years, I could not figure out initially how to get access to those records until it took some time to figure out how to do that. It is also the case that the records that weren't given were not because they put in the work. It's because I found the system called Total Grant Solutions in their website, which is their financial tracking system. And I told them, hey, even in my request, you did not provide these records. Now go search those in April. And then they provided them to Mr. Hooper, to Mr. Sullivan, and me. And there was another set of records that they didn't provide until I demanded, which is the January 22nd, 2019, which predates his very first request, attachments, funding requests, deliverables, email threads between them and Parks Alliance. And that was not provided either until I made the records request. And this should never be acceptable, that you just need some other person to come and barrage the city with more records requests until they do a full search. It is unacceptable that OEWD apparently had not fully searched their own financial tracking system, which is what Total Grant Solutions is. And you can see that all in the email threads. It's all in the back and forth. This violation is absolutely appropriate, but it's frustrating that Ms. Thompson isn't giving you the full story of exactly how they got to even finding these records. Thank you very much.
More public comment also, please.
A second, Mr. Warfield.
And I'd appreciate a 30-second warning. My timer is unavailable right now. Let me know when to start, please.
Go ahead.
Thank you. This is Peter Warfield, Executive Director of Library Users Association, Library Users 2004 at yahoo.com, and P.O. Box 170544, San Francisco, California, 94117-0544. We're not a party to this, excuse me, but we do have, as usual, a strong interest in Sunshine because we have certainly benefited from Sunshine and from the task force's many findings over the years in our favor with respect to difficulties in getting information. First of all, I want to congratulate and thank Mr. Hooper for his evident persistence. Second, just so you know, technical problems, I tried to hover over any part of this item and the next one and could not see, well, there was no link, basically, in your own agenda. And that's happened to me before as well. I think this is very well worth something that you might want to look into in general, but in particular here, it made it impossible for the members of the public to see, as you were discussing, what you were talking about. There was also something I think very important, and that is you shouldn't have to be a computer tech or have one next to you to understand what the responses are, which I think Mr. Hooper said, let's keep it simple. It seems as though the wonderful computers that are supposed to make everything so available and accessible are very often basically hellholes that are used to obscure and basically hide information. And one of the most difficult things is links. I've gotten links to something that supposedly went away sometime before I looked at it. I've gotten links that don't say where I'm going, so I'm clicking blindly into who knows what place. That should not be appropriate or, well, considered an answer. And finally, the idea that Mr. Hooper was getting into some place that was their cave of information, that is not the same as supplying somebody with the information so they can have it, keep it as long as they want, do with it what they want, and so on and so forth. So I think there are some serious issues here. I would certainly say next request is an example of obfuscation in responding, but this is a very interesting case. I'm glad Mr. Hooper pursued it. Certainly support the motion. Thank you.
Is there further public comment?
Last call, public comment. Okay.
Bruce, you muted yourself.
Oh, sorry. Are there any last comments? Hearing none, are we ready for a vote? Okay, let's call the roll, please.
Member Yankee?
Aye.
Member Yankee, aye. Member Padmanabhan?
Aye.
Member Padmanabhan, aye. Member Neighbors?
Aye.
Member Neighbors, aye. Member Stein?
Aye.
Member Stein, aye. Member Forsley is absent. Member Schmidt?
Aye.
Member Schmidt, aye. Member Wong?
Aye.
Member Wong, aye. Member LaHood?
Aye.
Member LaHood, aye. Member Highland?
Aye.
Member Highland, aye. Chair Wolf?
Aye.
Chair Wolf, aye. The motion to find a violation of 6721B for not supplying records in a timely manner and to have the matter followed up with the Compliance and Amendments Committee. So, and that the record should be provided for that committee.
There was also an additional amendment that the other person in this party, Mr. Sullivan, would assist Mr. Hooper.
Got it.
And that's not an order from Mr. Sullivan. That is, he's party to this. If he so wishes, we would be delighted if he would help.
I will.
Thank you. Okay, let's go to our last item, next item, our last hearing.
Item number 9, file number 19062, complaint filed by John Hooper against Public Works for allegedly violating Administrative Code Section 6721 by failing to respond to a public records request in a timely and/or complete manner. Shall I read the preamble?
Please.
October 20, 2020, Complaint Committee determined the records of public are referred back to the task force. On December 2nd, 2020, the task force requested that Mr. Hooper produce the same records list as provided in 19061 to the respondent and referred to the Complaint Committee to review and ensure that the petitioner receives his records. On February 16, 2021, the Complaint Committee referred the matter back to the task force with a recommendation to find no violation.
Okay. Complaint Chair Schmidt.
Yes. again, that's February 16, and I think that maybe that was that same hearing where Member Yankee was there, Chair Wolf was there, but it was the chair, the regular chair was Chair Hinsey, and I think maybe you two were the mover and a seconder on the motion to recommend, and so I certainly want you to be able to respond to it. Although I will say that I don't at this point stand by that recommendation based on certain documents that I've seen come out in the interim. But if you all have any ideas about that, go ahead.
Okay, I think what might be helpful and important here is it's a very short paragraph for the minutes of that meeting, just so everybody can get up to date on it. I'll just read it into the record. John Hooper, the complainant, provided an update on his complaint and status of the document's disclosure. Mr. Hooper stated there is some confusion regarding a custodian of records responding on behalf of two departments. Mr. Hooper stated that he did not receive the requested invoices, records of payment, and other requested documents. David Steinberg of Public Works, the respondent, provided a summary of the department's position. Mr. Steinberg stated that Mr. Hooper did not provide a list of specific missing documents, but instead provided a broad list of missing document category. Mr. Steinberg stated that reference invoices, presentation, other requested, records are present in the task force packet. Mr. Steinberg stated that Public Works does not have invoices as they do not have a contract with Parks Alliance, and assumes that OEWD, the contracting department, would have the invoices. The action was moved by Member Yankee, seconded by Member Wolf, to refer the matter to the task force with a recommendation of finding no violation. So that's it. This particular one is now against Public Works based upon the findings of the committee. Okay. Are we ready? Is the respondent, the petitioner here, Mr. Hooper? You still here?
I'm here, Mr. Chairman.
Okay, great. Glad you still have some battery left. And is there a representative from Public Works?
Oh, yeah, I'm here.
Who is this, please? Your name?
David Steinberg.
Okay, Mr. Steinberg.
David Steinberg.
Okay, so let's begin. Mr. Hooper, you have 5 minutes for your opening testimony. Wait for Ms. Leger.
Thank you, Mr. Yes.
Are you ready, Mr. Hooper?
All ready.
Go ahead.
Thank you, Mr. Chairman, members of the task force. I've submitted detailed information to you earlier, which you accepted at your December 2nd meeting. That is that this effort was a government effort by two entities, OEWD and DPW. DPW provided the employee, DPW provided a great deal of the funding and did a lot of the legwork. OEWD had to sign the contract, but was also involved organizing meetings of neighbors, doing footwork to promote the campaign to privatize city services. And the only thing I would have to add, which is what I've already said under 1906-1 before, is in the Heckle disclosure, we just have a little bit of further elaboration. Again, OEWD's representative stating to a Rec and Park employee, the GBD program is run by Department of Public Works. That's Heckle page 1389. Again, Ms. Fergus, OEWD, being asked who questions and billing should be sent to. I am merely a conduit for a grant to get through. Jonathan, meaning Jonathan Goldberg, DPW, would be a better person to ask. This was a question about billing. So I just think it's very hard to the agencies who are very integrally involved in this. I'm done. If you're telling me I'm out of time, I'm done.
No, we think you may have dropped out there. That's why I was.
I think we didn't hear your last sentence, sir.
Oh, okay. Well, I guess if you can hear me now, I was just trying to say that you already had enough information so that at your December 2nd meeting, you, in my view, accurately determined that both city agencies, OEWD and DPW, are responsible for getting the information the public has asked for, the public information has asked for. And I'm just giving you some more information that makes that even more abundantly clear now than you had in December, that DPW is much too up to its ears in this program to say, well, we didn't sign the contract, so we have no responsibility. If you have a full-time employee, if you provide the funding, if OEWD points to you every time somebody asks a question, it's hard to figure out how you can't somehow be responsible for responding to the public's questions about this issue, about this program.
Are you through, sir?
Oh yes, excuse me, I'm done.
Okay, thank you. Are any persons or witnesses providing facts or evidence on behalf of the petitioner or the complainant?
Sullivan.
Okay, Mr. Sullivan, go ahead. You have 5 minutes.
5?
Yes.
Talking to Public Works' responsibility to get records from the contractor or another department. Public Works funded most of the contracts for GBDs, 84% of the last contract. In the contract and acknowledged by Public Works next request 20-4913, the Public Works GBD program manager was the approval manager in the contract's Appendix C, saw and could get all records. He was the central contact person with SF Park Alliance contractor. People versus Ashley, 1954. It should be and is an established principle of law that the substance and not mere form of transaction constitutes the proper test for determining their real character. If this were not true, it would be comparatively simple to circumvent by sham provisions of statute framed for the protection of the public. This the law does not permit. In this case, OEWD would be the mere form of transaction, as in contract, and the substance is Public Works money and the GBD program manager giving approval of work for dispensing of that money. This is the substance that constitutes the proper test for determining. If allowed, the circumventing of who clearly is responsible will happen again and will probably be more complex, further eroding public access statutes framed for the protection of the public. Your decision is about protecting public access. Not holding Public Works responsible is allowing a department to circumvent responsibility for their money and program. Public Works under 6721(9)(c) should at least assist the requester to get records from either OEWD or a contractor if those entities do not fully cooperate. In my opinion, the task force often gets too caught up in the form of how something is presented and ignores the substance of what is happening or has happened. Words can be twisted, actions almost always tell the true intent, and money trail is clear path. Thank you for your time.
Thank you. Any other persons or witnesses providing facts or evidence on behalf of the petitioner? Okay, hearing none. Mr. Steinberg, you have 5 minutes for your opening testimony.
Thank you. Chair Wolf and task force members, my name is David Steinberg. I'm custodian of records for San Francisco Public Works. As you are aware, this is the third time I've appeared before the full task force regarding Mr. Hooper's complaint, and nothing has changed in all that time. Public Works has provided to Mr. Hooper all of the responsive records in our possession. Mr. Hooper repeatedly raises issues that are not germane to his request or to our obligations to respond to that request. In a statement to the task force, which you can read on page P2573 of your packet, he writes that although it is true that OEWD contracted with Parks Alliance to promote GBDs, should Public Works be absolved of any responsibility to help provide complete information? End quote. We've never disputed that we have a responsibility to help provide information. In fact, we did fulfill that obligation by providing all of the records we had and repeatedly appointed Mr. Hooper to OEWD for any remaining documents. Mr. Hooper asked that the task force find a violation and order Public Works to produce relevant information. We can't produce something that we don't have access to, and don't have a legal responsibility or ability to obtain. Public Works has complied with the task force's instruction to provide all records requested by Mr. Hooper that are in Public Works possession, approximately 240 pages of documents directly and an additional 600 documents through a link to a previous request. I ask that you follow the recommendations of the complaint committee and find no violation in this case. Thank you very much.
Are there any persons or witnesses providing facts or evidence on behalf of the respondent? Okay, hearing none. Members? Vice Chair Yankee.
Thank you. My question is for Mr. Steinberg. Do you or does Public Works have access to the TGS system that we discussed in the prior case, where invoices and disbursements are recorded?
I've never heard of it before, so I don't know.
Okay. That was the other question I had.
Member Stein.
Yeah, I have a few questions for Mr. Steinberg. Did the DPW, to your knowledge, give money directly or indirectly to either of these GBD projects?
From the records I've seen, it appeared that some money from Public Works was transferred to OEWD that was used, I believe, in the contract that OEWD had with the various nonprofits.
Okay, and then you also did have a managerial position that was overseeing the GBD project?
We formerly had an employee in our community outreach group whose job was to work on GBD programs. Yes.
Okay, and is it
He's no longer with the department.
Is it typical for DPW to be overseeing and funding programs and private entities that they don't formalize through contractual obligations?
I wouldn't know how to answer that. It's not my policy area.
Okay, because I mean that to me is a key question here. And then I noticed that there are now some GBD contracts with an organization in the Dog Patch and with an organization in Northwest Potrero Hill that are between the DPW and these GBD projects. Why would some GBD contracts be through OEWD and some through the DPW?
I couldn't tell you exactly why certain decisions were made, but I can explain a little bit. The Dog Patch GBD is the only established GBD in San Francisco. And under the legislation that was passed by the Board of Supervisors, GBDs have certain obligations for reporting, and Public Works is essentially the monitoring agency for it. So as an established GBD, they have to produce a yearly report, and we have to provide it to the Board of Supervisors and things like that. The groups that Mr. Hooper, Mr. Sullivan, Mr. Tomasevich were asking about were never, they never came to fruition. They were community individuals who were investigating the idea of starting a GBD. Parks Alliance, Build Public, and I'm blanking on the third one's name. Place Lab. They were contractors of the city who were helping community groups investigate the idea of formalizing and forming a GBD. But the only one that actually made it to that far was the one in Dogpatch, and under the legislation, Public Works is responsible for monitoring those districts. I'm not sure if that exactly answered your question, but maybe.
Yeah, I guess I'm trying to understand as a person who's not associated or doesn't know that much about DPW and OEWD, why the same kind of program, just because it's in a different neighborhood, would be administered by either one of those agencies, and why it doesn't fall under the heading of one or the other to oversee those programs.
I couldn't give you a definitive answer. I mean, I could speculate that it might have to do, anything from politics to where money is available to, who knows what. I mean, one of the, Anonymous, as he pointed out, is submitted records requests related to this as well. And, he showed that Public Works did have a contract with, I think it was Build Public or Place Lab. And that happened to be for the investigation into possibly setting up an Inner Sunset GBD. Again, I can't tell you why one would have been OEWD, one would have been Public Works. Other than I think in one of the cases, what a former supervisor had access to a pot of money that he wanted to use in his community, and neighbors asked, about working on possible GBD, and so the ad backs were sent to one department or another to investigate it. But I couldn't tell you exactly why. That's not my area of expertise.
Yeah, I'll just follow up and say that I did look at one of the contracts that was referenced, I think, by Anonymous in the documentation, and it was a full contract with the GBD, but it was for Dogpatch and Northwest Potrero Hill GBD. But anyway,
yeah, because that one actually does exist. Yeah,
right. That's
an actual established one. Yeah.
Those were my questions.
Okay. Member Schmidt.
Yeah. Also for Mr. Steinberg, I just wanted to confirm. I think we talked about this before, but nobody at DPW ever asked Parks Alliance to give documents in response to the Hooper requests. Is that accurate?
That is correct. As I said, we provided all the documents we had, and then we told Mr. Hooper and Mr. Tomasovich and Mr. Sullivan that if there were other documents, we have a duty to redirect, and we, they were already in contact with OEWD, so we told them they might be the ones to have it, because again, we didn't have the contract with Parks Alliance.
Okay. And so you deemed it that you would redirect them to OEWD in order to get anything having to do with Parks Alliance, correct?
Yeah, I mean, honestly, again, we didn't have the contract with Parks Alliance, so I wouldn't even know who to go to at Parks Alliance to ask if they had the records. And from, going for 2.5 years through this journey, my understanding is that OEWD had made that request and had gotten, what they produced, what they had or what they could, and they had the contractual relationship with Parks Alliance.
What is it specifically that OEWD requested and obtained from Parks Alliance in terms of documents in response to the Hooper request?
The only things I know are is what I've heard by attending however many hearings, 6 or 7 hearings that I've attended, that Ms. Thompson has spoken about.
Okay, so it's based on what she said that happened. But it's your belief that despite the working relationship on the GBD at issue between DPW and Parks Alliance, DPW can still just tell Hooper, no, you got to ask OEWD if you want anything from Parks Alliance.
Well, I mean, yeah, I mean, we gave him everything we had, and well, when Mr. Goldberg was still with the department, I asked him, and he produced lots and lots of documents for me, including lots of emails, and I had our IT folks do it. But again, our obligation to fulfill the request was to produce what we had, and if we didn't have it, to tell the requester where we believe he would be able to find it, which is what we did.
Okay, that's all for now. Thank you.
Okay, Member Stein, did you have your hand up again? No. Okay, Member Neighbors, go ahead.
Thanks. Just to clarify, Mr. Steinberg, just to make sure I'm understanding this, but so even though the responsibility and the documents were shared, when Mr. Goldberg was still with you, he was the Green Benefit District Program Manager, right? So in that sense, he was the only staff member for the program and managed the program out of your office, right? Is that right?
I'm not sure if that's an exact characterization. So again, the only established, voted on, approved by the board, approved by the voters, GBD is Dogpatch, and it has its own nonprofit and its own executive director and its own staff. Public Works' role is to monitor and do certain oversight. It has certain oversight responsibilities that the Board of Supervisors put into the law, which includes, as I said, getting an annual report, producing that report to the Board of Supervisors and things like that. The other parts of Jonathan's job, he did community programs, so that was everything from monthly neighborhood cleanups in all the districts to helping work on different projects in the supervisorial districts and things like that. And he was also the GBD manager. And that mostly meant working with community individuals who were, interested in trying to set up or investigating setting up green benefit districts. And so he would help those community members with things like setting up neighborhood meetings, helping to, and this is all based on the thousands of emails that I've read and had to review. Hosting community meetings, doing presentations, meeting with different neighborhood groups, things like that. So it was kind of a community outreach role, I guess you'd say.
Okay, that's how I read it too. Thanks.
Okay. I have a few questions myself. Mr. Hooper, you mentioned that in your opening testimony that there was some admission made by, I believe, I think it was Mr. Heckel with a page number. Can you give that to us again?
Were you asking? I had found in the recent Hank Heckel information some new emails that contained from OEWD's employee Chris Corgus, which I quoted earlier. I'm looking for them now as we speak. I think that's what you'd like me to state.
No, I don't want you to, if it's in our record, if you can just give us the page number.
Oh, it's in the statement that I gave you. I don't have it in the record I submitted to you a week ago in anticipation of tonight's discussion. I give you chapter and verse using not your pagination, but Heckle's pagination. So, for example, at Heckle page 1389, Chris Corgus of OEWD writes, the GBD program is run by Public Works. This clarification is reinforced in several other points, which I then quoted, page Heckle 1566, Heckle 1579, and so forth. And those were the ones that I thought would further amplify the point that you found compelling enough back in December to require that DPW remain integrally involved in helping get to the bottom of this. I don't think that Mr. Steinberg's assertion that he gave everything in our possession really does the trick. The real issue is that the work done by the third-party contract party, in this case Parks Alliance, belongs to the city. And one of the city agencies absolutely up to their ears in involvement is DPW. And so that's why I think you were correct back in December when you chose to realize that it was a multi-agency effort and it was appropriate to keep DPW involved. And in my judgment, you misunderstood the situation in March when you contradicted yourself and released the Department of Public Works from further responsibility. I think they bear a further responsibility.
Okay, can you give me the name of the parties in that message again? Because I'd like to see it. I'd like to see that document or those references, and if they're in the records that you submitted for this hearing today, I think it might be helpful for us to ask for.
Sure, glad to. An employee of the Recreation and Park Department wrote the Department of wrote OEWD on the 2nd of January 2018, asking about getting involved. Her name is Beverly Ng. Her last name is spelled N-G, and she works, or at least then worked, for Rec Park Department. And she asked about getting involved in the Mission Dolores, the then beginning campaign by the city to convince neighbors to set up a GBD in the Dolores Park neighborhood. And because Dolores Park was potentially involved, Beverly Ng was interested in possibly having her department involved. When she asked Chris Corgus who to go to, his answer was, the GBD is run by the Department of Public Works. And that's at Heckle 1389.
What's 1389? Is that a page number?
Yeah, in the Heckle emails, they are numbered in a different way than your own in your own reading file. So in the Heckle emails, once you get there, it's probably pretty easy. But you would go to page 1389 of his 1,741 pages, and you would find that quote between OEWD and Rec Park right there.
If I could jump in real quickly, it's 2544 on our.
Yeah.
2544.
Okay.
Yes.
Yeah, I'm sorry, I didn't have access to a computer to get your pagination. And then again, Mr.
Hold on a second. Is that in item 9, part 6?
Part
page
5.
are you guys?
Part 5.
Part 5.
I'm sorry, and the page number again is?
2544.
Okay. Okay, I don't need any further explanation, Mr. Hooper. That's all I wanted. I wanted to make sure that it was here.
Sure. Well, thank you, Mr. Chairman. Just for clarification, in my written statement, I submitted for tonight, but I submitted it a week ago to be timely. I do provide some additional page numbers, Heckle page numbers, which apparently you can easily, translate into your own reading file page numbers. So that's only one of several additional pieces of information that makes it very clear that OEWD thought DPW was running the show.
Okay, got it. Okay, thank you. Mr. Goldberg, you stated that you had contracted with one or two organizations to explore creating a GBD in the sunset. Was that before the community set their sights on doing that, or after the community's required first step?
I don't know. There was one grant, I believe, with Build Public or Place Lab to help the neighbors in the inner sunset to explore the possibility of setting up a GBD. I don't know what the timing of it was.
Okay.
I don't know which was the egg and which was the chicken.
Okay, because I think that's part and parcel to this particular discussion is where is DPW's involvement in the process. You've stated that for the current GBDs that exist, that DPW's responsibility is for monitoring, but that's after the GBD's been created. But your testimony was that you had contracted with one or two organizations to explore GBD prior to it. So where is DPW involved in this GBD process from soup to nuts or not?
I'm not really sure how to answer your question. I mean, I believe that in the past, the department has had a policy of assisting neighbors who were interested in exploring the option of creating GBDs, because we would be the oversight agency if and when an actual GBD was approved by the voters and ratified by the Board of Supervisors, because we would have to, follow the annual report. So I believe that our goal has been to help people who are interested in doing it. But again, the Inner Sunset one was they gave up. They decided that the neighbors decided not to do it, and that ended our involvement.
Well, that's like most of the other GBD attempts, Buena Vista and some of the others. The question I think here is, where does DPW's involvement begin? Does it begin prior to the community's exploration, during the exploration, after the exploration is done, and that they found, positive support for it? I mean, where in the process is this happening? I think that is what the request, the petitioner here is asking for information for. Is, because you basically, I feel like in the committee meeting, based upon your testimony there, that you basically said you don't have any involvement in this at all when it comes to prior to the GBD being implemented.
No. I never said that. I mean, we've never denied being involved in GBD programs. What we said is that we, well, specifically on this request, is that we released to this group everything we had, and we can't give them what we don't have. The degree to which our employee may have been involved in meeting with neighbors and helping organize committee or community meetings I mean, I don't want to say it's irrelevant, but it doesn't have any bearing on our ability to, or our obligation to, get records that are not in our possession from an entity that we don't have a contract with. I mean, I have no ability to ask this outside organization. I don't have a contract. I can't threaten to withhold payment, I mean, obviously, my understanding is that the contract's over, but it's like when we get a records request and someone asks for, 10 different categories of things, if I have records for 4 of them, I give them the 4, but if I know that Rec Park has the other 6, I send them to Rec Park. I don't try to get them from Rec Park for various reasons, if only for efficiency, but also because I have no control over Rec Park. And, if I'm late delivering those records, I don't have I have the ability to tell my own employees, you have to provide this for me within 10 days. I can't go to another department or an outside nonprofit that I don't have a contract with and say, you have to give me these things.
Actually, you can. Actually, under the Sunshine Ordinance and CPRA, one department can do that of another department, and one branch can do that of another branch, and it's happened before in the city. Sunshine Ordinance.
Yeah, well, I have always been told that best practice is if I don't have the records, I have a duty to redirect the requester to the people who have the records.
Correct.
And that's what I do.
Okay.
Because as I said, I can tell someone in my Bureau Street use of mapping, you have to get me this by Friday. We have a deadline. I can't necessarily go to a Rec Park employee and say, hi, you don't know me, but I'm telling you, you have to spend some of your work hours to get me records that I need. No, what I have an obligation to do is tell the requester, go to Rec Park. They have those records, and make the request of them, and the clock starts ticking when you make the request to them, and it's on them to get it to you.
Got it. Okay, thank you. Member Stein.
Yeah, so I'm not sure exactly how to word this, but the part that seems really unusual or problematic to me is that DPW is at least in part overseeing these programs, it's at least in part funding these programs, and has this connection to these private entities that aren't in any way seemingly formalized by any kind of obligation or contractual obligation. And I'm wondering, and I don't know what the other members of the committee think, but like Sunshine Ordinance 67.32 says that the city shall not give money and services to any private entity unless the private entity agrees in writing to provide the city with financial projections. Now, the city did contract with them, but the person who signed the contract was, the OEWD, and yet it seems like it would have been proper if DPW was also a signatory to that contract, because it was also providing funds and services through the position of a program manager. So that's kind of like what I'm struggling with here, like why DPW wouldn't have been party to that contract.
Okay, so we one thing I just want to clarify, we cannot talk in generalities because this particular complaint was focused on the Mission Dolores GBD. And in the committee, Mr. Steinberg had stated that he had no records responsive to this particular GBD. So,
okay,
no, I'm sorry. I don't mean to jump in to clarify. I didn't say we didn't have any records responsive to the GBD. We gave Mr. Hooper the 200 records we had, plus pointed to the 600 records that one of his colleagues had received in another request. What we didn't have were some of the financials and invoices and things like that, because again, we didn't hold the contract, and so we didn't get them. That's what OEWD presumably gave.
Okay, okay, got it. Okay, so correct. I'll stand corrected on that. That the records that they didn't have were the invoices. Whoever is making that noise, can you please stop? On the phone. Thank you. According to our minutes, Mr. Steinberg Steinberg stated Public Works does not have invoices as they do not have a contract with Parks Alliance, and assumes that OEWD, the contracting department, would have the invoices, which we heard about in the previous hearing. Okay, so Mr. Hooper, let me ask you now, that was part and parcel to your request from DPW, was it not?
Yes, I saw the obligation on the part of the city as coming from both agencies.
Hold on, I'm going to say something. Okay, go ahead, Mr. Hooper.
I have always viewed, because of my own experience in my own neighborhood, the Haight-Ashbury, I have always viewed DPW as really being more involved. I mean, Jonathan Goldberg, incidentally, DPW still has a Green Benefit District Manager position, and I believe it's filled. So this is not all ancient history. It's still of some great concern. But in any case, DPW started sending out its GBD program manager about a year before anybody at the local neighborhood organizations, Hank or Coal Valley or Buena Vista, none of the established neighborhood organizations knew about it. And yet we later learned, which was one reason the whole thing fell apart, that Jonathan Goldberg of DPW was helping organize a kind of whole new group of neighbors, most of whom unaffiliated with existing neighborhood groups, and in fact, one might say in competition with them. So again, it's not giving you an accurate impression to say that, oh, we just sat around and maybe someone would give us a phone call and ask for some help. This was a very aggressive, in the inner Sunset, in the Haight, and in Mission Dolores, it was the aggressiveness on the part of the city. This was not bottom up percolating from interested neighbors who wanted to have cleaner streets. This was the city going in and campaigning actively, incidentally, I believe in violation of the city charter. But that's why people are so angry about this and want to understand it and have it stopped.
Okay, so Mr. Hooper, I understand that, and that is not necessarily in our jurisdiction per se. If we're able to provide some transparency that others might find that conclusion, that's not really what our purpose is for. I'm trying to focus on, though, Buena Vista is not Mission Dolores, and you're trying to make a comparison that, what happens in one potential GBD could possibly happen in another GBD, and you're doing your own investigation by asking for records. I get that. So the question here is for this particular GBD, we're hearing from the respondent that they don't have any responsive records with regards to invoices or financial records with regards to Mission Dolores. So the question I then have to you is, do you have any evidence that you provided as part of your complaint that that would say otherwise, that then we can ask DPW about?
Well, I think a couple of things. One is, I think the legal citation, City of San Jose versus Superior Court of Santa Clara County and so forth, make it clear that the city agencies own all that information. So the other thing I would say is in addition to grant money that DPW provided for these city-funded programs, they were paying a full-time guy. So I don't know how much money went to the city employee whose formal title is Green Benefit District Program Manager. That's certainly a piece of information that, even if Mr. Steinberg's contention that they don't know nothing about nothing concerning invoicing, they certainly know how much they paid.
Well, let me ask Mr. Steinberg, let me ask you this. I mean, Mr. Goldberg, let me ask you this. You had a fellow that was, I'm sorry, I'm getting your names mixed up. Mr. Goldberg was the one who was the employee. Is that right?
Green Benefit District Manager.
Yeah, Goldberg. Okay. So, Mr. Steinberg, Mr. Goldberg was in DPW's employee. Is that correct? Hello?
He appears to have dropped off.
I don't believe he's dropped off. You accidentally muted him.
Did I?
Yes.
Hold on. There's a lot of noise coming from a particular. Save on. Oh, they're all disabled. Oh, wait, up here. There we go. Okay, there we go. Are you there? Mr. Steinberg? Hello?
I think I just was able to unmute myself. Can you
Okay.
hear me now?
Yes, I can.
Okay, there we go.
There was
Sorry, my phone must have been making noises.
Yeah, it was hard to hear. So, my question again is, Jonathan, I think his name is Jonathan Goldberg, right?
Yes.
Okay.
The former GBD manager, yeah.
Right. So he was in DPW's employ, correct?
Correct.
And he was in DPW's employ during the Mission Dolores Green Benefit District potential formation.
Correct.
Okay. So the question Mr. Hooper is asking for now, you had stated to our committee you had no invoices with regards to Parks Alliance, but also part of his lengthy request was to find out if DPW was involved in the process prior to when the community had its responsibility, and was there any activation of Mr. Goldberg by DPW to involve himself in the creation of a Mission Dolores Green Benefit District and a formation?
That was never part of his request.
Okay.
I mean, he's insinuated a number of times, but and as I said, all I can say is, we gave him everything we had.
Okay.
Mr. Goldberg provided a lot of those documents, most of them to me. Other ones I had IT do searches, and I went through email to get additional documents. And that's all. I honestly don't know what Mr. Hooper wants us to do. We gave him everything we have. We don't have any more. We don't have a contract with Parks Alliance where we could ask them. But even if we did, according to what Ms. Thompson said, they don't have any more either. We've sort of gone around in circles for the last 2 years on this, where I keep saying I've given him everything. I don't know what else I can give him. I don't know what he's asking for. He can make all sorts of insinuations that we're the dark power behind the GBD cabal, but tell me a document that he thinks I have that I haven't given him. I'll give it to him. Yeah.
Okay. Thank you. All right, Member Stein, do you have something else? No. Okay. Okay. Anything else for the parties here on discovery? I think we've spent quite a bit of time on this. Okay. Let's move to rebuttals. Mr. Steinberg, you have 3 minutes for rebuttal. I'll hand it off to Ms. Leger.
Sorry, David, you ready?
Yep. Tell me when.
Go ahead.
Okay. I really don't have much more to say than what I've been saying for 2 years, which is, again, we've complied with the task force instructions to provide all the records requested by Mr. Hooper that are in our possession. About 240 pages of documents directly, and then another 600 documents that we sent him a link to for a previous request for one of his associates. Yes, of course, Public Works is involved in GBD programs. We've said repeatedly, what we said is that we have released to him, to Mr. Hooper, all the responsive records that we have. We don't have any more, and I honestly don't know what more we can do or what Mr. Hooper wants us to do, based on what is in our possession, our obligations, our legal relationship or non-relationship with Parks Alliance. I can't give him something I don't have and don't have any ability to get. So again, I ask that you follow the complaint committee's recommendation to find no violation. Thank you very much.
Thank you, Mr. Hooper. You have 3 minutes.
Hang on.
Thank you, Mr. Chairman. Well, I would just say that because of the obligation under the contract itself, under state law, the city owns the work product of a third party, in this case, Parks Alliance. And Mr. Steinberg is asking what possibly more could I ask him to do? Well, I think a perfectly simple and straightforward thing to do would be for the appropriate person in his department, presumably I guess there's an acting head right now, to write a letter or the modern equivalent to the San Francisco Parks Alliance and say, having been an integral part of your various attempts to set up green benefit districts, we hereby are requesting you or requiring you to send in all evidence of payments you received under those documents, under those contracts. And, that would be responsive to, I think, to continually say we ain't got nothing or we've given you everything is to miss the point. That's the same as saying we don't have any obligation toward a third party private contractor that we work with. And that's not what case law or city contracts themselves say. It's quite clear that, so I think it's not complicated. I think the Department of Public Works has a further obligation to demand of Parks Alliance the information that the public is very concerned about.
Are you finished?
I'm finished. Thank you.
Okay, thank you. Okay, members, the matter is with us for determination. Member LaHood.
Yeah, we keep running into this problem with third parties doing work for the city, and we know that they, by contract, are supposed to be providing information about their work to the city. They don't necessarily provide it. The city doesn't ask for it, and I don't under the current arrangements, I don't know that we have the ability to reach farther, even though I understand the frustration expressed here by the petitioner, because this is not just with this entity. This comes up across the board in so many other situations. And is there anything we can do? I don't know. I'll hand it off to.
Okay, so go ahead, Vice Chair Yankee, and then Member Stein.
Sure. To start with, I totally share Member LaHood's frustration. This is something we see come up over and over again. In this case, though, I think part of the frustration here with these GBDs is that it seems to be two departments that are involved. Sometimes one has a contract, sometimes it's the other. And so I think Chair Wolf brought it up earlier, though, and I think is what's kind of focusing me on this case is that even though one agency or department in the city may have had a contract in other instances, we have to focus on this particular one. And I think it's been established in this particular one that it's OEWD that has the contract with Parks Alliance. And so it's the question on this one is what more can DPW do, specifically because they don't even have a contract with Parks Alliance. OEWD does, and that was a lot of what I think the problem was in the prior case we heard. But I think DPW's hands are pretty much tied for getting anything more than what they already have. That's why my first question on this was, do they even have access to the financial system on this? And Mr. Steinberg said they didn't. So I'm having a hard time seeing what more at this point DPW can give. Obviously, in the prior case, there was more information to give. I just think in this one, it's, for whatever reason, OEWD is the one that seems to be holding this particular contract for this particular set of information that, at least for the finances, that remain outstanding. But I totally share the frustration. It seems that a member of the public trying to find this information, it's like a never-ending maze. And we've all been on this, and there's how many people on this task force, and here we are 2 years later, and we're still kind of confused about it all. But I'll leave it there.
Member Stein?
Yeah, I'll just say I pretty much agree with both of the members that spoke ahead of me. And I just want to mention, in response to what Member LaHood said, that in the kind of state of the art or what's considered best practices in freedom of information law now around the world, many countries now require that any private entity that is subsidized in any substantial amount by the government is subject to the freedom of information laws that also apply to that government. And this might be something that we want to recommend to the Board of Supervisors as an amendment to the Sunshine Ordinance. That's my comment.
Thank you. Member Schmidt.
Yeah, just right on that same point that you all have been on. I don't know if I buy the idea that, okay, I didn't actually sign the contract, so therefore I'm out. Like I don't have any need, even though I work constantly with this Parks Alliance day to day. We meet all the time, but no, they don't have to do anything if I ask them for all the documents. I don't know if that's true. I don't think it's that like clean cut. And I know that Mr. Steinberg says I couldn't do anything else. I couldn't ask him. I couldn't force him. I don't think so. I don't think that's true. And the law says that the city's got an obligation to go to Parks Alliance. And so Mr. Steinberg says, well, it wasn't me, but I was told that someone else was doing it. So how could I do that? I don't buy it. I'm not sold. And I think that Mr. Hooper is on to what I think is a violation in this situation.
Anybody else? Okay, so I'll say this. OEWD is a department and DPW is a department within the executive branch. This is all part and parcel to city and county government within the same branch. The contract with regards to Parks Alliance, the executive branch has multiple contracts with Parks Alliance, as we know, not just with DPW and OEWD, but with various other departments. It's now a well-known fact. So as far as I'm concerned, they have an obligation. Now, asking for, I would say the executive branch has an obligation to produce the information. Okay, somebody has a contract with somebody, and somebody has a contract. That contract has a purpose for producing some sort of outcome or some sort of labor or some work. Okay, there is an office of contractual of contracts through the city administrator's office. The controller is the one who cuts the checks. They obviously have a contract. Everybody has their hands on this contract at one point or another. It doesn't really, it's the purpose of a requester asking one department or another for records is for corroboration lots of times. And sometimes one department actually doesn't have the information, and they then try to help the requester find it through another department that may have it. That is a requirement of the Sunshine Ordinance. Absolute requirement. Okay, so that's the first question that we have to answer. Okay, the second question is for this particular request, it does it or does not rise to a violation. It doesn't mean that there may not be a problem, or there may not be some concern about it, or it may be something that we want to take up and investigate ourselves based upon is this a shell game where at any one point somebody says, okay, for this community, this green benefits district, OEWD, you do this one, and then this other green benefits district, ODPW, you do this one. Okay, I don't have necessarily any evidence of that, but if records are being requested by members of the public and the public finds out about something like that, then then that's on the public to do. Our job here is to determine, are there records? Are they being withheld? If they are they being withheld properly or not? And it will asking any of our questions or bringing out some sunlight in our hearings here will start to reveal certain things. Okay, our job is not necessarily to root out any problems. If we notice that there are problems based upon our findings, yeah, we should report them, absolutely. So I just want to say that if this particular request on DPW does not, rise because there's the records that were specifically being requested don't exist for this particular department, for this particular activity, then okay, another request could be asked by a member of the public for a different department that might have involvement, and they might get satisfactory results. Member Schmidt, do you still have your hand up, or do you want to say something else?
Yeah, one thing I forgot to include is that I am very I really am suspicious as to really whether all these whatever the documents that Parks Alliance would have, and none of us knows, none of us knows, but that's not as important as knowing that they might have things, and so the approach has to happen. There has to be somebody from the city who goes to Parks Alliance and says, you got to give us things. And I would think there'd be a paper trail for that contact too in this situation. Now, I'm really suspicious as to whether anyone, even at that other agency, OEWD, really did that. And I think that tonight was the first time I ever heard anyone say that they did it or they even thought they had to do it. So that's why I'm not sure if I would rely on that for thinking that, anyone at the city helped Mr. Hooper out with Parks Alliance.
Okay, I'll get to you in a second, Vice Chair Yankee. Just in response to that, Member Schmidt, I would say the request is not being made of Park Alliance. The request is being made of DPW. If DPW had said, we've had these cases before where people have brought requests similar to this from the department says, I don't have those records. Okay, so the next request that's made when the petitioner gets that response from us and we find no violation because they don't have any records, then requester then goes out and makes a request of the contractor itself. Now the question here is this a nonprofit organization that is covered under 12L, or is this a contractor with the city? There's a big difference, okay? A nonprofit that receives, let's say, a grant for managing, let's say, a building, would and they operate it unto themselves. We've had this case come up for the Bayview Opera House. Then that's a 12L issue. But if a contractor, for-profit, nonprofit, doesn't matter, if they are providing a specific function and service for the city that the city would normally have staff for, and they're actually doing that, like filling potholes and things like that, then they are a contractor. It's not a 12L issue. Go ahead, Member Schmidt.
I half agree. I think that the member of the public can go to the nonprofit and ask them for documents, and that's one procedure. But they don't have to do it just that way. They can do it this way.
I
go
get
to
that.
the city, and the city goes to anyone who has whose records they have what's called constructive possession of, and so the citizen goes to the city and says, "Here, you go get those for me, because I'm entitled to that under CPRA and under Sunshine. You do it, and you take care of it for me."
I get you. I understand what you're saying. I do. Okay. And you're saying that the department should go the extra mile to get the records from their contractor for the work that they've been contracted to do, right?
You could call it the extra mile, or I'd say it's still within the first mile.
Well, you know, we've had problems. I mean, this goes to a lot of different things. I mean, there are, for another example, right here in the Haight where I live, there were problems with construction in the street. Okay, and when information was requested from DPW about the contractor, there was no responsive records until the contractor was contacted directly. Mm-hmm. Okay, so yes, I get you. You know, the question is for perfect sunshine and transparency, every piece of information from every fingernail, grain of fingernail, should be in the possession of the contracting agency. I get that. Doesn't always happen. Vice Chair Yankee.
Yeah, I was mainly going to echo what you said earlier. To me, in this case, this case is frustrating, and it's difficult because it involves, there's a third party, Parks Alliance, if not more, third parties. There's multiple city agencies involved, but I think we need to focus in on this particular case, and it's with DPW. In my opinion, in this case, there's looking at 6721. Did they give records over? Yes, we know that DPW gave hundreds of records over that they did have in their possession. Obviously, it wasn't everything that Mr. Hooper was looking for. So did they then fulfill 6721C to assist the requester in identifying the other department that may have them? In this case, I think they did. Mr. Steinberg, talked about referring them back to OEWD. OEWD testified here that they did reach out to Parks Alliance. I think it was telling that when Mr. Heckel responded with the missing records that for 2 years, they wouldn't turn over, he did so on behalf of OEWD. He did not do so on behalf of DPW. He specifically wrote that I'm responding on behalf of OEWD. So I'm not sure what else DPW can do in this particular case. It sounds like they've turned everything over and made the referrals to the other places where records may exist. In fact, they did exist there. We just heard that in the prior case. So I kind of the same place I was at the committee level. I don't see a violation here.
Well, I would say also that the executive branch is the primary responsibility is the mayor, and nothing happens without whoever the mayor is in any year. They have full control over decisions that are being made in the executive branch, unless they give away that authority to somebody. And so while we're trying to meander between one department and the other, or I should say the requester is trying to meander, and we're trying to help fulfill the retrieval of certain public records. if they aren't available in one file cabinet, then, you know, somebody's got to keep looking. And we, you know, I think we've been round and round with this enough. I don't see anything that necessarily points to, for this particular issue around the Mission Dolores GBE, that DPW has any involvement with it. That instead it was through OEWD, through their contract with the Parks Alliance. I'm not saying that there isn't any involvement, because DPW has admitted that they are positively involved in Green Benefits District, but that's, you know, in one case for one Green Benefits District, but not this one. And they're involved in it once the Green Benefits District gets formed after the community effort. So leave it at that, and we'll enjoy a motion, because it's 10 o'clock.
Yeah, all right, this is Vice Chair Yankee. I'll go ahead then, at least to move this along, and make a motion to find no violation against Public Works for 6721.
Is there a second?
Member Highland, I'll second that.
Okay, moved by Vice Chair Yankee, second by Member Highland, to find no violation of what is it?
6721.
6721. Okay, any further debate or discussion? Let's open up public comment. I'll hand it to you, Ms. Lachey.
Do we have public commenters?
Yes, please.
Okay. Do we have other public commenters?
Anonymous number 3 after Mr. Warfield.
Okay. Anybody else? Okay, Mr. Warfield.
You'll give me a 30-second warning and let me know when to start, please.
Yeah. Go ahead.
This is Peter Warfield, Executive Director of Library Users Association. We can be reached at libraryusers2004@yahoo.com and at P.O. Box 170544, San Francisco, California 94117-0544. Thank you for a very interesting discussion. First of all, again, I want to say that your agenda packet does not have, your agenda online does not have any link to the documentation for this. And that's certainly a problem for informed public comment. This was a very interesting discussion. So let me just point out key elements here. 67.21C says a custodian of a public record shall assist a requester in identifying the existence, form, and nature of any records or information maintained by, available to, or in the custody of the custodian, and so on and so on. Available to, that seems to me to include a department or an agency of the city being able to say to somebody they're working with, you have blah, blah, blah records. We would like to see a copy. I also appreciated a member, I believe it was LaHood, who talked about elsewhere what the practices are. And section 67.29-6 is a very interesting one that I think has very little, to my knowledge, been used. But it refers to sources of outside funding, and basically has such kind of a provision with respect to folks giving money to an agency or official. And what it basically says is, no official or employee or agent of the city shall accept, allow to be collected, or direct or influence the spending of any money or any goods or services worth more than $100 in aggregate for the purpose of carrying out or assisting any city function unless the amount and source of all such funds is disclosed, and so on and so on. And it says when such funds are provided or managed by an entity and not an individual, that entity must agree in writing to abide by this ordinance. The disclosure shall include the names of all individuals or organizations contributing such money and a statement as to any financial interest the contributor has in involving the city. So I think you may very well have something that should make you vote no on this, and that is that records are available to the respondent. Thank you very much.
Anonymous, you ready?
I am.
Okay. Go ahead, please.
Thank you very much. This is Anonymous number 3. There's one misunderstanding and another misconception, and for those reasons, you need to vote no on this. First of all, the 9 original requests made by Mr. Hooper to DPW include Mission Dolores and Greater Buena Vista, not just one of them. And then the other part is the discussion that's very accurate that Member Schmidt has made about the obligations under Community Youth Athletic Center versus City of National City, where the city is obligated to properly instruct its contractors. And if it doesn't do so, its unwillingness or unableness to do so is equivalent to withholding that information from the public. And so that proper instruction hasn't occurred here. The question of whether DPW in this request, in this contract, is involved can be answered by those supplemental records actually that OEWD gave me and Mr. Sullivan and Mr. Hooper. In that, there's a January 16, 2019 email from Parks Alliance to OEWD. They have deliverables for Greater Buena Vista, Dolores Park, and Inner Sunset. That thread goes on to say that gets, I'm going to read it to you. I have reviewed these and spoken with Jonathan. Jonathan is Jonathan Goldberg. Quote, they meet public works needs for the GBD program. Please submit this approval email with your submission to TGS. That is OEWD telling Parks Alliance that they reviewed the records with with Jonathan Goldberg, the public works employees, and quote, they meet public works needs for the GBD program. In this contract, in this request, DPW was extensively involved. In fact, they were the ones reviewing the so-called, quote, funding request deliverables from Parks Alliance through, for some reason, they get funneled through an employee of OEWD first. So I would urge Member Schmidt maybe to explain more about Community Youth Athletic Center. I think it absolutely applies here, and I urge you to vote no. Thank you.
Any other public comments?
Yes, hi, this is Mary Ann Thompson from OEWD, and I would like to make a public comment.
Just a second.
Thank you.
Are you ready?
Yes, I am. Thank you.
Go ahead.
Okay. I think you are right in not finding DPW in violation. I think it's really important to understand two things. DPW and OEWD worked together to respond to Mr. Hooper's requests. OEWD did indeed provide Mr. Hooper with the contracts with the Parks Alliance and with the deliverables. It also needs to be made clear that the funding for the Mission Dolores Greater Green Benefits District was funding that was given to us from a previous supervisor. And that's why that contract went through OEWD's office. It was an add back that came from the District 8 supervisors. And finally, I'd like to point out to everyone here this evening that Mr. Hooper, who claims he has no access to technology, tonight has been citing the emails he received from Mr. Henkel to support his argument against Mr. Steinberg. So he either did or did not receive the emails from Mr. Henkel, or he is somehow finding these mysterious documents. So I would like to point this out to you, that he's quoting emails that he said to you, in my case, that he didn't receive and he wasn't able to open. So I'm not sure where he got this information. And that's my final comment.
Any other public comment?
Mr. Chairman, John Hooper, may I just correct the record?
No. I understand that that something may have been said that you may not agree with, but I can't allow a debate from a party, a public commenter.
That's fine.
Okay, thank you. Okay, members, I will say this. I'm reading on page 2126 of item 9, part 1, PDF. This is the original request dated February 11th, 2019 to OEWD Public Works, Rec and Parks Alliance, and the organizing committees of Greater Vista Green Benefits District and Mission Dolores Green Benefits District, the formation committees. Okay, and the requests are made from all of them for the original, what started out being 9 requests. So what's ended up happening here is that the complaints were brought independently of each department at this point. And so I'm just listening to what folks are saying. I hear that the department has provided all that they think they have, or they know that they have, that there is some concerns from task force members and from the petitioner that there most likely is more. I hear from one of the public commenters that, citing case law, that that the information is to be treated from the contractor itself, is to be treated as such. And frankly, there is actual verbiage in the Sunshine Ordinance that is specifically to be used in every contract. And I know, because I'm on the board of directors of a nonprofit that receives city funding, and there's all kinds of Sunshine Ordinance requirements in those contracts. So, you know, I think that there is some obligation here. I'm not, while DPW may not have the records in their hands right now, I am compelled by another public commenter's reiterating 6721C, and I think that that is compelling to me, that a custodian shall assist a requester in identifying the existence, the form, and nature of any records or information maintained by or available to or in the custody of the custodian, whether or not the contents of those records are exempt or not. So the question is the question here on C is a little, it's not quite as extensive, because it's whether it's maintained, available to, or in the custody of the custodian. Are any of this information with regards to contracts with Parks Alliance available to the custodian? I'm pretty sure if DPW went to Parks Alliance and said, hey, can I see your invoices from OEWD, that they would probably give it to them. Okay, I think Member Schmidt was implying that that should be done. That should have been done. This is all part, again, I say this is all part of the same executive branch. Because the request is being made of each and every department that didn't comply or didn't, that were part and parcel to this, that may or may not have records, is, sure, it may be considered a fishing expedition, but okay, you're going to get some records from one department, you may get the records from it, you might not get records from another department. But I think the real focus is on the contract is with the city, okay? And the question is who has full control and access to that contract? Because if Parks Alliance is providing a service to the city that it would normally have staff do, then again, it's like filling potholes. That anything that is within the jurisdiction of that contract is public information. So versus, as I explained before, receiving like a grant or funding to operate a third-party operation of some sort that doesn't provide a direct benefit to the city government or as a service to city government. So I'm compelled by this in a way, and I'm a little torn about which way to vote on it because of that. So I'll just stop there, Vice Chair Yankee.
I absolutely understand where you're coming from, and I'm sure everyone's kind of torn on this. I think, in fact, and I forget when it was mentioned, but there was a chain of communication brought up not too long ago about something in the contract being approved, and I believe it went from Parks Alliance, the communication, to OEWD. OEWD then went and checked with DPW. DPW responded back to OEWD, and presumably OEWD then communicated with Parks Alliance, the contractor, right? So I think this demonstrates to me that it's OEWD and Parks Alliance who are the two parties in communication with each other. It showed that Parks Alliance wasn't, in this case, reaching out directly to DPW and saying, hey, did this fulfill things? No, they went to OEWD. OEWD forwarded that to DPW for approval. We all know both departments are involved in it, but so the question is, can DPW directly go to Parks Alliance? And not just could they, but is it a violation of the Sunshine Ordinance if they didn't? Maybe they could have. They could have asked potentially, but does it mean they violated the Sunshine Ordinance? I just don't see that, because they knew OEWD was in communication with Parks Alliance, because we saw those emails showing that OEWD and Parks Alliance were the two parties in communication with each other. And so I don't think it's a violation on DPW's part to refer those requests back to OEWD. So I'll just leave it there. I know it's getting late and probably should wrap this up.
Okay, Member LaHood.
I'll make it quick. I agree with Chair Wolf. I think it was definitely available to if they had taken the additional step of asking for it.
Okay, are you ready for a vote? Okay, please call the roll.
Okay. Member Yankee?
Aye.
Member Yankee, aye. Member LaHood?
Member Highland
No.
seconded it.
Sorry, Member Highland. I apologize. Member Highland?
Aye. Aye.
Member Padmanabhan?
Nay.
Member Padmanabhan, no. Member Neighbors?
Nay.
Member Neighbors, no. Member Stein?
Nay.
Member Stein, no. Member Forsley, absent. Member Schmidt?
Nay.
Member Schmidt, no. Member Wong?
Aye.
Member Wong, aye. Member LaHood?
No.
Member LaHood, no. Chair Wolf?
No.
Chair Wolf, no. 1, 2, 3, 4, 5, 6. The noes have it.
Okay. I'd like to make a motion to find a violation of 6721C and order the DPW to request such records from Parks Alliance that may be available to them because they currently have contracts with them and access to them. And for this to be referred to compliance and amendments for monitoring. Is there a second?
I'll second the motion.
Who is that speaking?
That was Member LaHood.
Okay, moved by the chair, Wolf, second by Member LaHood, to find a violation of 6721C and to order DPW to assist the requester in identifying, and just you can take it right from 6721C. Assist the requester in identifying the existence, form, and nature of the records that the requester is requesting, and or information maintained by, available to, or in the custody of the custodian, whether or not the contents of those records are exempt from disclosure, and shall, when requested to do so, provide in writing within 7 days following the receipt of the request. Well, actually, in this part, I would say, let's give it 2 weeks, okay? Because I know everybody's trying to get back into their offices and get back to work. So give it 14 days, and that compliance and amendments will monitor. Okay, public comment.
Sure.
Hang on a second. Lila, you were the second? Is that correct?
That's correct.
All right. Okay. Do we have any public commenters?
Hearing.
Yes.
Okay. Do we have others?
Yes, anonymous number 3.
Okay. Mr. Warfield, you may begin.
This is Peter Warfield, Library Users Association. I'm happy to hear this motion being made, and I'm happy to hear Chair Wolf's comments as well as the others that were commenting on this motion. I guess it's looks like it's going to be the reverse in terms of yeses and nos of the previous motion, which was for no violation. This is for a violation. I'm glad it's going to compliance. I'm glad you have a time limit. Excuse me. So yes, I think this is absolutely a yes vote, and basically cuts through attempts and practices of basically baffle gab and sending people running around in circles because on some technical level you haven't got the goods in some file drawer or in some database or something like that, which shouldn't be done to folks who in good faith are seeking information. So thank you for the motion and certainly support it. Thank you.
Just a second, anonymous. I'll be right with you.
No problem.
Are you ready, sir?
I am.
Go ahead.
Thank you very much. Agree with every single point Mr. Warfield made. This is going to be a hard motion. It's going to require all 6 votes that were no on the last one to be yes here. Otherwise, I believe if there's no motion, Mr. Hooper loses by default. And so I'm going to give you some more reasons why you should vote yes. This is the Appendix B, definition of grant plan from an OEWD supplemental record provided as we discussed in the last hearing to me. It has project definitions. There's a term called Cities Team. It has 3 members: Christopher Corgus, Senior Program Manager, OEWD, Jonathan Goldberg, Program Manager, Public Works, and Helen Marr, Project Specialist, OEWD. It mentions 2 project areas surrounding Buena Vista Park and Dolores Park, and it mentions Inner Sunset GBD. The Public Works is integrally involved. They are part of the, quote, cities team, a defined term in the appendix of the grant plan. They should, and not just under the Sunshine Ordinance. To be clear, I, of course, believe the Sunshine Ordinance requires them, but I'm saying even under the weaker CPRA, courts have found that they should properly instruct their contractors under Community Youth Athletic Center versus City of National City. And so you absolutely should vote yes. This is finally a way to cut through how do you get at the contractors. And I urge you to vote yes. Thank you very much.
Any other public comment? Last call, public comment. Okay, public comment is closed. Members, any last thoughts? Are we ready for a vote? Okay, please call the roll.
Chair Wolf.
Aye.
Chair Wolf, aye. Member LaHood.
Aye.
Member LaHood, aye. Member Padmanabhan.
Aye.
Member Padmanabhan, aye. Member Neighbors.
Aye.
Member Neighbors, aye. Member Stein.
Aye.
Member Stein, aye. Member Forsley, absent. Member Schmidt.
Aye.
Member Schmidt, aye. Member Wong.
Aye.
Member Wong, aye. Member Yankee.
No.
Member Highland.
Aye.
Member Highland, aye. Moved by Chair Wolf, second by Member LaHood, to find a violation of 6721C and order DPW to assist the requester in identifying the existence, form, and nature of the records the requester is requesting.
Yeah,
Can I ask for clarification, please?
who's speaking?
This is David Steinberg.
Yes.
I just want to clarify exactly what records am I supposed to ask Parks Alliance for? Presumably not the same ones that Ms. Thompson already asked and they said they didn't have, but what is there anything specific I'm supposed to be asking for?
I believe it's the financial documents. The ones that you said that you didn't have.
The ones that Ms. Thompson already provided to them. Okay, thank you.
Mr. Steinberg, I just want to say that just because one department provided it to somebody doesn't mean that you're absolved from it. Okay?
Yeah, I know. That's why I redirected them to OEWD.
I understand that, but the records that were provided at the time of the request, not now, but at the time of the request, that's what we're talking about here. This is happening in the period of time that the request was made and not fulfilled.
Okay, I will ask them for that.
Okay, thank you.
Thank you very much.
Thank you. Thank you for.
One more notation about the motion. I did not include that the request must be fulfilled within 14 days and refer the matter to compliance and amendments to monitor.
Right, thank you. Okay, let's go. And I just wanted to note there was a public commenter about not being able to download the items from the agenda. Underneath the description, there are a list of the parts of each for each item. Those are the links that are there. And yes, probably there should have been some directive there that these are the links. Click here. I just wanted to notate that for everyone. I know that was it's a little off the reservation than what we usually do, but that's how this was set up. Okay, let's go to the next item, please.
Member Schmidt's been waving his hands around. I think.
Oh, I'm sorry, Member Schmidt.
Yeah, I wanted to say to Mr. Steinberg that we don't have any idea what actually was requested, like the scope of what was requested from Parks Alliance. We don't have any idea what was received from Parks Alliance. There's no evidence of any of that. And so to say, oh, well, I'm just going to re-request what they already requested, unless you can find out exactly what those things are, then I think basically Mr. Hooper needs you to go and ask Parks Alliance for what he's looking for. Because we have never been told those things. I just wanted to add that in because there's this assumption that like somehow it happened, and I don't see it. Okay, thank you for letting me have my 2 cents on that.
Okay, please call the next item.
Item number 10, Sunshine Ordinance Task Force Chair's Report regarding possible response to the San Francisco Chronicle, June 27, 2021, entitled, I joined the SF Sunshine Ordinance Task Force to expose corruption. Instead, I'm a cog in the machine.
Okay, thank you. I'm bringing this up because there was some commentary and by a former task force member, and this is where I was going to make that announcement. Kevin Frazier had submitted his letter of resignation a week or so ago, without really just kind of stating that it was not necessarily up his alley, and so he was felt that it was imperative for him to resign. In that, since then, he had written and came out, I believe, the following day, a op-ed in the San Francisco Chronicle, and I'm sure everybody saw it. I got tons of messages about it, and I think there are some unfortunate misunderstandings about what we do, and what this is about. I understand his sentiment. I think there's some value in some of his sentiments, but not in all of them. And I don't really think he's been here long enough on the task force to understand the history and how this operates. And he may not like the way it operates. Some of us may not like the way it operates. But that's where we are now. And as everybody knows, it's been somewhat of a big struggle for a lot of us, and folks currently here. So I felt it important to open this up, have an open conversation about it. I think I know member Wong and Vice Chair Yankee and I, there was some discussion about writing a possible response to it. We thought we'd bring it to the task force, and I think Member Wong, if you have I think you wrote up some comments or points that maybe to get the discussion going, that'd be great.
Sure. This is Member Wong. A couple of things I had pointed out was just in the article, it's not mentioned that we are in a massive backlog currently, being that prior member Frazier was only part of the task force for about 4 months. I think he just couldn't see past the fact that we were stuck in this backlog. I think there's several other things that I took issue with. I thought the title of the article was unfortunate, given that he was resigning as a member. I think that would just make things more troublesome for us to actually find someone to replace him and fill his seat. Other things that I had issues with was just that, we are governed by the Sunshine Ordinance itself. There are specific rules and regulations that we must follow. There are procedures that we need to follow. It's not, I don't know, it's unfortunately or fortunately not the Wild West here, the Sunshine Ordinance Task Force meetings. Also, what else was I discussing? Oh, we're in the middle of a pandemic. So, you know, being that we are stuck in this virtual world, it makes things much more difficult for everyone, you know, not just us as the task force, but folks who attend, folks who, the petitioners, the respondents, for everyone, you know, who's in attendance, who's just observing these meetings as well. What I also really took issue with was the fact that, as far as I know, Member Frazier did not bring up these concerns to anyone on the task force before he resigned. As far as I know, there weren't extra projects that he took on in order to try to further, you know, the reach of the ordinance or the reach of the task force itself. You know, and there are people on this task force who do take on those projects, who put in the effort. We are all volunteers, and we put in an effort outside of these meetings and outside of our committee meetings. There's an education committee that's specifically for educating the public. And on top of that, I mean, I don't know, there's just quite a lot. I have many, many bullet points, and so I'll just leave it at that and open it up for more comments from the rest of the members.
Member Neighbors.
I appreciate you covering all the comments, or all your bullet points, and your bullet points are my bullet points as well. Number one thing that I'd like to underscore, for me, my first reaction in reading the opinion was that it felt very demoralizing to the people who work so hard to bring their petitions to us. And by dismissing the request that they're making as insignificant, I thought that there was nothing that could be further from the truth. I know that it doesn't seem like every day we're making revolution here with all of our decisions, but there's never been a single case we've heard from any complaint that I thought was petty or not significant or couldn't be mapped to a social justice outcome in some way. And I know for me, that's why I worked really hard to get on this commission. And all of those other things aside, with the letter to me, in a response, I want to make sure that the public knows that that is not the way that I hope that the rest of you feel about the cases that they bring to us, and that we do see the significance, and we do see ourselves as critical to helping them achieve very important goals.
Thank you, Member Stein. Then Member Padmanabhan.
Yeah, so I mean, I just want to say I did read that opinion piece as well. My biggest reservation about spending time trying to write a response to it is that I don't think I've ever seen a response to an opinion piece published. That's just kind of not something I've seen newspapers do. I did think that he had one or two valid points, or there was some truth to some of the things that he had to say, but I mostly felt like I just saw a lack of understanding of the rationale behind freedom of information laws, the mechanisms of democracy, the important work that the task force does. I would love for us to write op-eds that helped people in San Francisco understand what the task force does and how they can use this law, but I probably wouldn't bother with a response to this particular opinion piece.
Thank you. Member Padmanabhan. Unmute. There you go.
So I do agree with Member Stein. There's just one point I want to make here, and that is when we talk about backlogs, I'm not sure about the history, but how, there's always likely going to be a backlog. And so I think that point needs to be separated from all the other issues. I think that the prior member, Frazier, was touching upon. And really, he doesn't mention any well, he doesn't give a substantial enough reason for why the Sunshine Ordinance does not work. All he said is that the task force does not spend enough time in doing our high-level work, which is monitoring the effectiveness of the ordinance and recommending ways to improve it. I think perhaps because of the backlog, that might be an issue, but maybe not too. I think that's one point I think we need to consider. Maybe spending a little time doing that, maybe once every 3-4 months or so. So yeah, that's the point I wanted to make.
Okay. Member LaHood, then Vice Chair Yankee, then Member Highland.
Thank you. And I think others have said this before. I don't think he was really around long enough to have a full understanding of how we do what we do and how it works. Even if you come in with an understanding of the ordinance and California Public Records Act, it's only when you've been here long enough that you start to see patterns and trends. And I think that's when we can really start to make a difference. And yes, our meetings are long, and I know there were some other issues that he pointed out. But I have to say, in my experience on the task force, I appreciate all of our petitioners, because in my mind, they are helping us, and I've said this before, so if you heard me say this, they are helping us stress test the system so that we can make sure it works the way it's supposed to. And sometimes it's the cases that look small that can help us identify chronic issues and address inconsistencies. And I know we've talked about this before, but what would really help us would be to have a database so that we're not trusting, our own memories or sort of collective institutional memory to say, oh yeah, this is how we've done it before, but to be able to have a way to refer back to collections of cases that have things in common and know that we're addressing them consistently, all across the board. So that would be a dream improvement that I think would really help all of us do our jobs better and would help us do what we're doing faster. So get rid of the backlog.
Vice Chair Yankee.
I echo what everyone else said so far, and I'd actually add that I think our backlog is in a strange way actually reflective of how well we do actually work. Obviously, the Sunshine Task Ordinance envisions a variety of different city agencies and players to help enforce it, right? It talks about supervisor of records, which is the city attorney. It talks about the ethics commission. It talks about the DA, the attorney general, the mayor being in charge of implementing it. And yet, so many members of the public actually come to us because they know that we'll actually take them seriously, that we'll listen to their complaints. We don't take them as being insignificant requests, that we spend hours during a meeting. And so I'm actually, for as much as I would love to get through the backlog, and I think that's a great goal, and we do need to do things to get through it. I'm also encouraged by the fact that there's that many people who want to come to us and see us as the functional part of government, right? That actually gives them a voice and gives them a place to hear their concerns heard. And I just don't see how the article that former member Fraser really reflected that. I'm proud to be part of this task force, and I think that we do a lot of good work, and we spend the time necessary to go through those things. I don't consider us part of the machine as he put it. I actually think that that's why, like I said to start with, why we do have such a backlog, because people want us to weigh in on those things. And so I think that's good in a way. I'll leave it there.
Member Highland and Member Schmidt.
Yeah, just to chime in with what everyone else is saying, but particularly to echo Member Stein's sentiment. I don't think we should rise to a response that would legitimize or perhaps add weight to this piece. But for the record, I'll say that Member Fraser was a member of my subcommittee, EOTC, and I'm going off the top of my head here, but his attendance was very low. I'd say 1 out of 5 meetings he actually made it to, and those that he did, he had to leave early. So he already missed what was happening at the subcommittee level. And at that level, you're really dealing with the public one-on-one and sorting out apples to apples, oranges to oranges. So, did he, a short 4-month stint was not really long enough to see the work that we do. And coming from someone that's been on this task force for 10 years, we do a lot of good work. Maybe the small sampling of what he saw was, maybe a 20th of what I've seen in my time, or even less. And was it a bad patch, perhaps? But I also wanted to point out that, we have had repeat requesters in the past. I think the repeat requesters that we have right now are very knowledgeable and have educated us. And I think it's good for Sunshine. I think, they've helped us move along. Now, our meetings are long. Well, guess what? That's because we actually have a full complement of members for once. Just to give you guys some perspective, we've had 6 or 7 members only, and it's been very hard to get quorum and let alone agreement and anything passed, because it only take 1 or 2 votes, and justice delayed is justice, or justice was never served. Yeah. So that, just wanted to pass on those sentiments. I don't think we should write a response, though. That makes it looks like it just gives weight to his article. I think it's one of those things that will be read yesterday and forgotten tomorrow, honestly. And you guys are doing great work, which is why I sit by and listen most of the time, because I've said all these things in the past years, and I like to hear it from you guys. But keep up the good work, and I like the direction of what we're doing, and really the nitty gritty of what we're getting to. And lastly, yes, database, yes, database, yes, database, please. If we keep mentioning it, keep saying it, keep asking for it in our budget, one day we may get it. That's all. Thanks.
Member Schmidt. Yeah, unmute.
Okay, thanks. I was on mute. Yeah, it didn't really resonate too much with me. I didn't feel like it would reflect what other people here would have thought. The main thing I wanted to point out is that I was a little bit put off by identifying a member of the public and criticizing them. I thought that was just bad form, because it's hard enough to go through our process and deal with all the bureaucracy, but you guys don't. None of you. And I know it was anonymous, and anonymous can certainly defend anonymous, but I just thought that's a cheap shot to go after someone. So just wanted to make that one point. That's all.
Okay. Just a couple of closing thoughts from me. Again, just one, as you may have already heard, I did send an email to all you folks letting you know, and I'll let everybody else know, that we did not get our funding request. It was didn't make the cut, even though we were pretty high up. We were under number 300 for ADVACs, and we did not get it. So we will not be enjoying another staffer, especially that would help us in much needed legal memos that we have been missing now for well over a year. And we will not be getting a formal database sooner than later. The contract for the Legistar system for the whole legislative branch is still being worked out, and it could take another, for all I know, another year before that gets settled. So in the meantime, we can't even get access to the current system. So I did also send out a reference, and I want to thank the anonymous speaker who is here tonight for loaning us a publicly available database. It's not the best. It's not, we can't do a whole lot with it, but it at least may offer some help, in a kind of slow train way to be able to research past orders of determination. And I appreciate that offer from the public when on a $10 billion budget, we can't afford $250,000 to help this important law and process out. So I'll stop there. Let's open it up for, so there's no, obviously it doesn't sound like there's not going to be any action. Let's open it up for public comment. We still have the administrator's report to get through, and then we'll be done. So I'll hand it off to Ms. Leger.
Do we have public commenters?
Sure.
I hear Mr. Warfield. Do we have another one? Okay, Mr. Warfield, it looks like you're it. Hang on a second. Are you ready, sir?
Yes.
Go ahead.
Thank you. Peter Warfield, Executive Director of Library Users Association. We can be reached at libraryusers2004@yahoo.com and PO Box 170544, San Francisco, California, 94117-0544. As I've said before, I repeat this because it's not possible, as in a personal real meeting, in-person real meeting, for people to approach each other, and this is the minimal way that that might be possible, at least in one direction. Much of what you say, most of it, I would certainly agree with, but some of the things that are important, I think, haven't been said. The first thing is that I think that much of what Fraser complained about is within your power to do. Taking up the larger issues, that's something that I have quoted to you from 6730 repeatedly. Read 67.30. You have broad powers to report, to basically agitate, to persuade, to contact. You haven't turned out a report, an annual report, since 2016. So I think that a great deal of when you have the ability to do larger things, I mean, for example, what about objecting to the continuation of the restrictions on sunshine, even though everything in California opened up presumably June 15th? What about more publicly? I didn't know you were going for funding specifically, nor for how much. I don't know that that ever came up. Maybe the public would help you with that if you would make it visible. There's a range of things that you can and perhaps should do, and I think have even in some cases discussed, but it hasn't come to any action, all of which is in your power to do when you set your agendas. And like I said, read 6730 and some of the ones beyond. I think you should also be asking for support from the city attorney, who has apparently abandoned you fairly recently. The dumping on complainants, I think, was really very poor and completely irrelevant. It's like blame the victim, blame the customers. All the problems are because too many people. Well, maybe we should just lock the door or shoot them when they approach us. It was a ridiculous argument there. And that's mostly what I would say. I think you have a lot in your power to do, and I would love to see you do more of it. Thank you.
Any other public comment? Public comment is closed. Okay, thank you, folks. Let's move to the next item. Let's try to get out of here.
Item number 11, Administrator's Report, Complaints and Communications. So if you just hang on a second, I will get into my report and then we can talk. Okay, this report was prepared July 1st. I have listed all of the relevant dates for July, August, and September for each committee. And I'm assuming that each committee will be meeting throughout September. If we hear otherwise, we'll know. I will let everybody know. We got 1, 2, 3, 4. 7 new cases in June. Uh, 2021 has increased by about 14 complaints. That's for item number 3. Item number 4, minutes from the committees. I did not provide the May complaint committee minutes last month, so I included them this month. And I also included the June 15th complaint committee minutes. We had 3 separate communications, public communications from anonymous to the task force, which were included. And we received a lot of emails in addition to the numerous telephone calls that take place. I counted about 317 emails. Let's see. There was also, Victor put together a chart because we've had complaints about when members of the public have been receiving their packets. And to avoid that disruption, on page 39, let me take a look at what page it is. Page 2717, Victor provided us with a chart that he drafted for each day of the month. And when, you have to excuse me, when the agenda packets are posted online, when we need to get document submissions before the agendas are uploaded, notice of hearing sent to parties. It's a chart. If anybody has any comments about that, I'm happy to take information. Victor's here. He can probably provide more information if you have questions.
At your discretion, Chair Wolf, I can go through it quickly.
Go for it. Yeah, go ahead.
Yes. I'm just going to go ahead and take the full task force meeting as an example, as the committee meetings are only 1 day off. So approximately 4 to 5 days before the meeting is going to occur, we post the agendas online, and that's usually on a Thursday or a Friday. That is listed on day 4 or 5 on my chart. And I believe in order for us to receive all documents 5 days prior to the board meeting, we need to get documents by about the 8th day prior to the meeting. And I have that listed as the 8th day. That would be a Tuesday, which would be 5 working days before the meeting. And in order for us to make the request to the parties in time, we do need the chair of the committees to let us know at least 14 days prior to the meeting. That way we can send off the request to the respondent and complainants, and we would send that off on approximately a Wednesday or Thursday, and they would need to respond to us by the following week on a Tuesday for us to have it 5 working days before the meeting. In going along with that, the one thing that we don't address in any of our procedures is if we do need to mail a notice of hearing to somebody, we probably would need to provide an advance notice of a meeting about 21 days prior to the meeting, just to give them a little additional time for mail to go back and forth. I have that listed as day 20 and 21, advance notice of possible scheduling to people who need to be, who we can only contact via U.S. mail. And that's just a quick summary. If we get the chairs to finalize 14 days in advance of the meetings, we will notify the parties of the meetings, and they can respond by 8 days before the meeting. And we will be able to forward anything we receive to all the parties even via U.S. mail if needed, and be able to get our agendas up by that Thursday or Friday on the 5 days before the meeting. If there's any questions, I know this might be a little confusing by stating days before meetings, but if there's any questions, the chart is there. It is highlighted to try to give a range of dates of when we need to get things done. If there's any questions, I'm happy to respond.
Or if anybody has questions about the administrator's report, I'm happy to answer them.
Okay. I'll just say thank you for creating that chart, Victor. Yeah, I was getting a lot of comments and complaints from certain members of the public that only want snail mail, and they, you know, because of the way the mail operates, or they weren't able to possibly get their the agendas and their and prepare at the same time as everyone else who could download it off the internet. So this is to kind of create parity for everyone, and so it just means we have to, you know, work a little sooner in order to get these out so everybody can obtain them. I remember back in the early 2000s when that's all we did was send things out by snail mail. There's very, very, very few, you know, folks that there was a big digital divide at the time. So, especially with big documents over the internet, was with really slow speed. So, please help, and it should be much appreciated.
I just want to I just want to make a comment about large documents. You know, with respect to the Hooper case, he probably had 1,000 pages in each one of his files for both of them, 61 and 62. And the reason I divide it has to do with how much data there actually is on each page. I have a certain amount of information that I'm allowed to include in when I go to send the records to the computer, and the computer uploads all the material. Mm-hmm. So that's why things are divided the way they are.
Yeah, I will tell you, back in the, I would say in the mid-2000s, when Sunshine was really beginning to pick up, when I came on board about 2005, 2006, we used to get on a regular basis, you know, 500-600 page agendas. They just get sent to my house. Would not fit through the mail slot. So, thank goodness for the internet at this point, but yeah, it's just tough with all those records. Okay, hearing nothing else for the administrator's report, we'll assume that's accepted into the record here.
I also point out something, Bruce, that you and I had talked about, and that is many times I get attachments from people that are 85, 125 pages long, and so what I've done is I just take a sample of what that document is. It could be a contract, and I would include like the cover page and the table of contents. You know, I know that for Mr. Malloy's matter, I did include the entire contract, but his file is not that big. But for many of the documents that Mr. Hooper was provided, they were lengthy. And so I couldn't put everything in there, and still I had to divide it up extensively, and it takes time.
Okay, thank you. All right, public comment on the administrator's report.
Sure. Can you hear me?
Yeah, I can hear you. I'm just typing. There's nothing. Are you ready, Mr. Warfield?
Yes.
Go ahead, sir.
Thank you. Peter Warfield. Library Users Association, Library Users 2004 at yahoo.com, P.O. Box 170544, San Francisco, California 94117-0544. I very recently asked the administrator for what the procedures were for preparing agendas and minutes, and apparently there was very little documentation. She did send me something. I'm not sure if the answer is completed, but in any case, one of the things that I have found very problematic is waiting 9 months or 10 months or even a few months if it wasn't for COVID, and then suddenly getting basically a command to appear at a meeting. It always struck me as odd that there was never any question as to whether that would be possible or convenient or anything else for the complainant. Obviously, the respondent, they're full-time workers for the city. They have occasional appearances. Certainly for the complainant, it's a lot of work. And especially when a lot of time goes by, memory fades a bit. One has to consult notes perhaps to refresh. So preparing materials is quite a job, even if it's minimal in quantity. So the idea that one would get 3 days notice or 2 days notice, which we got 2 days notice in March for an April meeting, and we immediately, as quickly as we possibly could, let the administrator know that that just wasn't enough time. We needed more time than 2 days to meet the agenda packet requirement. And the idea that we would wait and wait and wait with no word and no concept of when anything might be happening, and then suddenly out of the blue have 2 days notice to put material in the agenda packet, that just seemed wrong. And it didn't seem to give much time for having a replacement being put in our slot. The reason we went quick to say that it wasn't possible was so that somebody else might have a chance. So I think it's good to discuss. I think it needs to discuss. The procedures need to be discussed, and certainly the timelines to give people more time, and for you to be able to substitute somebody else if a person can't make it on the commanded date. I think some of the other procedures might be reviewable too, but this timeline I think is particularly difficult. I hope this straightens it out, but I think it should be discussed as an agenda item. Thank you.
Any other public comment? Okay, hearing none, public comment is closed. Let's move to the next item.
Item number 12, announcements, comments, questions, and future agenda items by members of the Sunshine Ordinance Task Force.
Okay, members. Go ahead, Member Stein.
Yeah, so I want to again raise the issue of the state of our meeting packets. Today's meeting packet clocked in at 2,757 pages and was made available to members 5 days before the meeting. I went through every page of the packet, even though it took most of my time over the past week, and I kind of felt lucky that I had the time for that. And of this 2,757 pages, I would guess that at least 2,000 pages were probably either redundant or not particularly relevant. They were either unnecessary to consider the cases at hand, or they contained redundant items, some of which appeared numerous times throughout the records. And so I think oftentimes important information also was buried in the midst of a long PDF. And because no material was indexed, and some of these links were missing or not working as well, could be very difficult to kind of negotiate the packet if you wanted to go back and look for things. So because of how it was assembled, I think it was difficult to know, too, what documents mattered most, or to refer back to them once you understood their importance when they came in sometimes kind of random orders. And I really don't think we should accept this state of affairs. And I would like to propose as a future agenda item that we address how to organize the packets so that they don't waste human resources and so that they include only relevant material. We've already had the suggestion that all supporting documentation be labeled and indexed and appear only once in a packet. And this, I think, is an entirely reasonable requirement. There are also items in the packet that pertain to administration and scheduling that I don't think need to be put in front of the entire task force when we're trying to, look at what's relevant to a case. And finally, I think there are items that I would consider the heart of the cases that come before us, like the petitioners and the respondent statements, which should really appear towards the front of every packet. In addition to determining a reasonable and efficient way to organize the packet, I would propose that the deadline for materials being submitted to SOTF or to SOTF be moved up to whatever date is necessary for the administrator to compile and distribute them with maybe at least 10 days notice of an advance meeting. Very difficult to go through 3,000 pages of material in 5 days. And this timeline, if we had at least 10 days, or if we could, streamline these packets or index the content that appear in them, it would allow us to read them and ensure that they get to the petitioners and respondents in time for our meetings as well. So I think a more efficient packet, not only would it be, would less be more in this case in terms of us being able to really get to the heart of what these cases are about, but it might also free up some of our time so that we could address some of the bigger picture issues that are under our jurisdiction instead of just, being mired in trying to get through a lot of redundant and sometimes irrelevant material that appear pretty often in these packets. So I just wanted to say I'm going to continue to raise this issue until we can address this problem.
I'll be happy to put it on an agenda if you're requesting it.
I am.
Okay, and we'll do it for August. Okay, Member Wong, and then Member LaHood.
Yeah, I just had a quick thing. I think I brought this up in the compliance and amendments meeting as well, but there's a really great podcast that's in partnership with KQED and NPR called On Our Watch, which is basically investigating different cases that came out of the release of documents through SB 1421. So just wanted to recommend that folks give it a listen.
Member LaHood?
Yes, I want to just circle back with the thing we mentioned at the very beginning of the meeting with anonymous speakers. Could we discuss setting a new policy that as long as we're doing remote meetings, that the first time anyone speaks, they either need to give a name or tell us that they're going to be anonymous for the duration of the meeting, and then we give them each a number, and they have to identify themselves with that number every time they speak. I think it would help with keeping track of who's saying what and for the future minutes. And I don't know what it takes to set a policy like that, but I'd like to propose that.
I agree with that. I had tried that at some of our earlier meetings last year, and it did not go well because it was hard to keep people remembering who to identify themselves as. I've had a little bit of a back and forth with one of the anonymouses. He now, well, I shouldn't say he, I don't know what his gender is, but they now sign their name as any moose, anonymous, instead of anonymous. And so that's how I know that it's that particular person or entity. But yeah, it's not easy, and I had some back and forth with them about that, and I mentioned that at the beginning of the meeting, and I just think that we do take as much care as possible, but we're in a public setting here. If you're walking outside, anybody can take a picture of you. There's no law that says you can't. So anonymity is based upon in a public space is based upon your own ability to protect your identity. In your private home, it's a different story. So I agree with you on that one. I'm thinking also based on Member Stein's assertion that maybe we should have some take 2 meetings per year and turn them into at least half the meeting be a retreat, a little retreat to go over some of these items so we have some time to do it instead of just a mere mention of them. And then, because I do a lot of this, I take your concerns very seriously. And believe me, Vice Chair Yankee gets an earful, from me and also now Member Wong, who is shadowing us, to try to figure out how best we can optimize and streamline our process. But it takes time. We're all got full-time jobs. It takes time to think about it. Sometimes I get a brainstorm in the middle of the day because I'm working on something else. It just kind of works that way. And without enough staff, with somebody who's like constantly focusing on it, in various ways. I know Cheryl has a ton of stuff on her plate, so sometimes it's just not enough. And Victor splits his time between probably 3 or 4 other commissions and and other work that he does. So I appreciate everybody's input, but I think we'd do better if we had some concerted time where we can spend an hour discussing like the particular item that you brought up, Member Stein. We just give ourselves enough time to be able to have a full conversation about it. I like to have that done usually in committees. In the past, it's been more fruitful because there's more flexibility in a committee. There's more time, but it makes it hard to do it with the full task force and trying to get everybody's schedules to kind of coincide for everybody to meet. I can be guaranteed almost everybody coming on a meeting of our full task force, but not in between, unless it's months in advance. So unless we do it that way, if you want it to be more expedited, go ahead and bring it up on any of your committees to take up any one of these subjects. You can try to hash out as much as you can there and then bring forward a proposal, and then we can have a little bit of a shorter discussion here at the task force and try to get things narrowed down. So it's another way to do it too. So, all right. Anything else? Okay. Public comment.
Yes, please.
You ready, sir?
Yes, I am.
Go ahead.
Peter Warfield, Executive Director, Library Users Association, Library Users 2004 at yahoo.com, P.O. Box 170544, San Francisco, California, 94117-0544. First of all, I'd like to appreciate all of the comments that folks are making, which have to do with presumably making the task force more effective, more efficient. Particularly want to agree with Member Stein. I remember when 650 pages seemed like a huge thing to try and digest basically over a weekend. I think it's crucial for the effective functioning, both for the members and for the public, to give a lot more time to review materials, including agendas, and to organize the material in a way that makes not only indexed, but makes it meaningful. I've always thought that the absolute minimum requirement and the basic requirement would be the very first thing in the packet would be the complaint. This is the opportunity and the kickoff for any hearing, and that's a complaint. Then there's the respondent's response. And then there may be additional materials presented by the respondent and the complainant. Those, to me, are the core. And very often these materials are buried, not in the front, but all scattered around amongst, as Member Stein said, tremendous numbers of stuff that you might want to include in the packet, but maybe could be pushed to the back. Administrative notices sent back and forth. the complaint cover memo sent to the respondent. There's a whole range of stuff that's very, very irrelevant to the core and of what's going on. And I think that that needs to be really thought out and discussed and made part of your whatever bylaws or complaint procedure. And there are a number of other things that I think, comments, I didn't hear anybody say what a lot of work you put in today, and to appreciate that. And as I've said before, I think next request is a disaster for the public and should be on an agenda. You apparently have had some contact with DTIS about it, and so that would be helpful. Thank you.
Any other public comment? Okay, hearing none, public comment is closed. Final item.
Item number 13, adjournment.
Is there a motion to adjourn?
Motion to adjourn. This is Member Wong.
Is there a second?
Member Stein, I second it.
Okay, moved by Member Wong, second by Member Stein. Can we take it by acclamation without objection? I think we can do it. We can do that without a roll call vote. Okay, thank you, everybody. And sorry for, again, another very, very late meeting. But thank you for hanging in there and maintaining quorum. Appreciate it. Good night.
Thanks, everybody.
Victor, you want to hang out for a bit?
Thank y'all.
I want to stop the recording.